All right, there are. Why did the man fall down the well? Because he didn't see that well. Yeah.
All right.
What branch of the military accepts newcomers?
I don't know.
The infantry.
Oh. What do you call a knight that's afraid to fight? Surrender. All right, these are bad. All right, then we're good to go. Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Thursday, February 6, 2025. We have 13 bills on the docket. We're going to start off with Senator Henson with Senate Bill 513. Yes, please.
Thank you.
Madam Mayor, welcome.
So this is a big deal, big day. Thank you. Thank you. For the record, Shanika Henson, Senator for Maryland's 30th Legislative District. I am here today on behalf of Senate Bill 513, Real Property, Unlawfully Restrictive Covenants, Modifications, County or Municipality Requirements. You'll remember that we did a lot of work in this committee and other committees to make sure that unlawful restrictive covenants were reformed out of deeds. An unlawful restrictive covenant includes those covenants that have provisions in them that are racially biased and biased against other groups. Those have been outlawed by this committee, so you can no longer have those provisions, but the process of reforming those deeds to make sure that they're not reflective of those provisions is still ongoing work. I have with us here the mayor of Tacoma Park. The mayor of Tacoma Park brought to our attention that the process by which we offer notice needed to be updated and modernized. So that's what this bill does. It just reforms the process for offering notice when we are reforming these deeds so that they no longer have that illegal language in them. And with that, I'll turn it over to the mayor of Tacoma Park to offer her testimony and personal experience with this.
Wonderful. Thank you so much for the opportunity to speak to you today. As we all know, it's unlawful to refuse to sell or lease real property to a person because of race, color, religion, gender, national origin, age, familial status, or disability, or to include any instrument, a restrictive covenant based on such characteristics. Many deeds continue to contain unlawful restrictive language despite it being unenforceable. Over 1,200 properties within the city of Tacoma Park have unlawful restrictive language in their deeds. The city supported changes in 2023 to Section 3-112 of the Real Property Article, which provided local governments with the ability to review deeds on file and, with required notice, modify deeds to remove restricted covenants. However, the city has found practical challenges in meeting the state's notification requirements to effectively remove these covenants. The city appreciates the sponsors of this bill as it includes additional notification methods like newspaper and website postings, which will make implementation easier. The city of Tacoma Park wishes to expedite the removal of covenants from all deeds within its city. We aim to correct historical injustices and affirm our stance against racism. But we need SB 513 to make this effort easier for our community and so that other municipalities wishing to follow our example will be able to do so. So we urge favorable support on Senate Bill 513 and look forward to working with this committee to make sure that it passes. Sincerely. Thank you.
Excellent. Thank you very much, Madam Mayor. Questions from the committee? right, I know we have one more witness signed up favorable with amendments, and that's Rebecca Snyder. If there are no further questions for the sponsor or the mayor, thank you both very much. Is Ms. Snyder, Rebecca Snyder here? All right, and then I want to also, I know that in your bill file, and is that, Ms. Bailey, are you back there? Just want to make sure.
Yes, Mr. Chairman.
So I know in the bill file there is unfavorable testimony, but I think that's withdrawn.
Withdrawn, yes, thank you.
Okay, excellent, just for the record. So there is no unfavorable testimony in the bill file, and MML is no longer in opposition, or was never in opposition. Okay, further questions? Excellent, with that, that'll conclude the hearing for Senate Bill 513. Thank you both very much. I forgot to light up everyone's questions for the maiden voyage. You got to light them all up. Yeah, everyone's being too kind today. All right. Well, now let's slip back over to the top. Do you want to, Senator Henson, you want to just continue going?
I would appreciate it.
Excellent. Let's get Senator Henson out. Is Senate Bill 514?
Thank you. May I bring up my panel, Mr. Chairman? I have Zafar Shah from Maryland Legal Aid, John Bay from the Vera Institute, Minister Thomas Anderson from BUILD, and David Wheaton from the NAACP LDF. And then I think we also will have some virtual witnesses to come as well. I think they were prepared to wait, so they're being wrestled from the hall. So I'll get started. Again, for the record, Shanika Henson on behalf of Senate Bill 514, Landlord and Tenant Residential Leases, Prospective Tenant Criminal History Checked, known as the Maryland Fair Chance Housing Act. Thank you for the opportunity to introduce this bill and provide key details on Senate Bill 514. This bill is also cross-filed in the House as well, and it is a priority of the Legislative Black Caucus of Maryland as a continuation of the work that's being done to support our returning citizens. What this bill would do is give people the opportunity for a fair chance at housing before certain criminal records are identified and used in the valuation process to determine an offer for tenancy. We know from the organizations' work that are here today that providing returning citizens with a second chance to turn their lives around, obtaining housing is one of the largest obstacles that those communities face. In general, this bill addresses the use of criminal history records checks being applied in the application process for the residential leasing of apartments, housing, and boarding facilities. I have with me a panel of folks who do this work every day, representing people who find themselves in these situations, and a person who can also testify and share with the committee what it was like to face this obstacle for themselves. Please understand that this legislation is not intended to mask or ignore the person's prior history, but at the same time, there are certain circumstances relating to incarceration that need to be considered based on the individual's performance in their acts to change their life. Because of their commitment to change their lives, this bill recognizes and gives value to the fact that if they verify the stability of their employment and they are transparent about their prior issues, that they should have the opportunity for housing. Again, I thank this committee for their consideration, and I will ask for a favorable report on Senate Bill 514. Thank you.
All right, thank you, Chair Smith, members of the committee, and thank you to Senator Henson for sponsoring this important bill. I'm Zafar Shah from Maryland Legal Aid. I just want to walk through for the committee step by step the process of lease applications under the Fair Chance and Housing Act. So from the outset, a landlord would be able to assess an applicant in the ordinary course using non-criminal factors. And after that, would be able to reject that applicant based on things like eviction history or credit score, et cetera. They can consider criminal history only after extending a conditional offer. So after the conditional offer is made, the landlord is able to inquire into conviction histories for first-degree murder, human trafficking, crimes subject to a lifetime sex registration, and then convictions over the past 2 years related to sex crimes like rape, kidnapping, child pornography, and arson. And based on that conviction history, the landlord can opt to withdraw the conditional offer, but before doing so must consider any mitigating factors, evidence of mitigating factors offered by the applicant, And also that withdrawal of the conditional offer must meet necessity of a substantial, legitimate, non-discriminatory interest. The applicant must receive notice of the decision to withdraw the conditional offer. And after that, that applicant has the option to seek a reassessment based again on mitigating factors. And that reassessment by the landlord must meet a 7-factor standard set forth in the bill. Factors such as how much time has elapsed since conviction, evidence of rehabilitation, et cetera. On further denial, the tenant has the ability under this bill to seek additional review by the Office of the Attorney General. And so that's the process. I'll leave it there. Maryland Legal Aid urges a favorable report.
Good afternoon, Chair. Happy birthday. Vice Chair, members of the committee. My name is David Wheaton. I'm an attorney with the Legal Defense Fund, founded by Maryland's own Thurgood Marshall. LDF is the nation's premier racial justice civil rights legal organization. Maryland Senate Bill 514 will ensure that thousands of Marylanders with a history of involvement with the criminal legal system have fair access to housing. LDF asked this committee to give SB 514 a favorable report out of committee. Due to discriminatory policies and practices at every stage of the criminal legal system, Black people are disproportionately subject to arrests, prosecution, and incarceration. Black people in Maryland make up 31% of the state's residents, but 52% of the people in jail and 69% of the people in prison. Currently, there are extreme barriers to access safe and quality housing for Marylanders with a history of contact with the criminal legal system. A survey found that nearly 8 out of 10 incarcerated individuals reported ineligible or denial of housing because of their loved ones or their conviction history. This legislation has the ability to help thousands of Marylanders with a history of involvement with the criminal legal system to find safe and affordable housing, thousands of whom are Black Marylanders. Furthermore, landlords frequently rely on inaccurate, incomplete, and outdated court records to deny people housing who have previous criminal records. Inaccuracies in criminal records also disproportionately hurt Black people. A Department of Labor study found that 33% of Black participants had at least one inaccuracy in their criminal record compared to just 18% of white participants, meaning Black participants were almost twice as likely to have an inaccurate record. This proposed legislation allows tenants to be able to provide evidence of inaccurate information found on their criminal history screening report. Finally, as a country that believes in second chances, every person in Maryland should have access to safe and affordable housing. This includes people with prior involvement in the criminal justice system. Currently, landlords are permitted to discriminate against thousands of individuals in Maryland. This discrimination disproportionately hurts Black Marylanders. Thank you. We ask a favorable report out of committee.
Good afternoon, Chair Smith, Vice Chair, members of the committee. Thank you for allowing me to testify in support of SB 514. My name is John Bay. I'm the director of the Opening Doors to Housing Initiative at the Vera Institute of Justice. We are a national nonprofit working to end mass incarceration and protect immigrants' rights. Opening Doors seeks to increase housing access for people with conviction histories. So this bill really disrupts this cycle of recidivism and homelessness. Housing stability and public safety are often linked. So people who are formerly incarcerated are 10 times more likely to be unhoused than the general public. And in turn, people experiencing homelessness are more likely to be arrested, convicted, and incarcerated than the general public. This bill will make all of Maryland's communities safer by allowing people with conviction histories to have the stability that comes with housing. There is no evidence that excluding people with conviction histories makes communities safer. In fact, most people with a conviction history in their past never have another one. What a criminal background check does, it provides information about a person at a time of their last conviction, but says nothing that has happened since then. The U.S. Department of Housing and Urban Development stated that a conviction history is not a good predictor of housing success. Considerations like a person's ability to pay rent, ties to the community, employment, and personal references are more useful in determining tenancy. Opening Doors at Vera recently conducted a study on how policies like SB 514 have impacted communities in Cook County, Illinois, Washington, D.C., and New Jersey. What we found after interviewing residents, policymakers, and other stakeholders was that the impact on housing providers' operations was minimal. Importantly, tenant safety and property safety did not change. Also, stakeholders agreed that having a non-discriminatory housing policy in place is positive for society and improves public safety. Thank you for taking this, for making the time to hear my testimony. Thank you.
Good afternoon. Thank you for allowing me to stand before you today. My name is Thomas Anderson, and I'm representing Build and Turnaround Tuesday. Build, Baltimoreans United in Leadership Development, is a coalition of almost 50 religious and nonprofit organizations in Baltimore City and County. Turnaround Tuesday is a job movement that has placed over 2,000 people in living wage and sustainable employment. Over the past 2 years, we've listened to about 700 justice-impacted people, with that being a fraction of the hundreds, even thousands of people in Maryland that has criminal record. We asked them all one question: what has been the greatest roadblock after returning from incarceration? The overwhelming answer was housing. We've heard stories of landlords refusing to allow housing because of criminal records, people wasting money on 6 and 7 application fees only to be denied or even ignored. There were some who were forced to even get people to apply for housing on their behalf. Many people have found themselves in shelters and unsafe living conditions as a result, and many have experienced bouts of depression because of their inability to find safe housing. I too have faced housing discrimination. Despite having a good job that paid a good wage, despite having a 750 credit rating, I was denied housing simply because of my criminal record. This housing discrimination has, in fact, become redlining 2.0. That is, it's the landlord's edition. Now, we have a call to action because in New Jersey, Build's sister organization has helped to pass the nation's first fair chance housing law, which is illegal in the state, which makes it illegal in New Jersey. And we're asking that you do the same here. Thank you very much.
Excellent. Questions from the committee? Senator West. Before we get into the questions, I just want to say, look, Build and Second Chance, you all do just awesome work. So thank you for your work and for being here today, because I've always been really impressed with this stuff, and hope the members of the committee get a chance to get more exposure into some of the stuff, the amazing work that you all are doing. So thank you for being here. Senator West, and then we'll go to Senator McKay.
Thank you, Mr. Chair. Senator Henson, let me start by asking you about the part of the bill that's on pages 8 and 9. It says, a landlord's decision to lease a residential dwelling unit to an individual with a criminal history, where the landlord's decision not to obtain a criminal history records check may not be the basis for a claim against the landlord. Now, over the course of my lifetime, dating all the way back to 1973, when the Sutton Place apartments in Bolton Hill were sued because there was a murder that occurred in the garage of the building, and the allegations were that the apartments had not sufficiently protected the tenants of the building. There had been case after case after case in which people living in an apartment facility have sued the owners of the department for failure to properly screen tenants or people coming into the apartment house, and thereby leaving tenants open to being attacked by other tenants or by undesirables. So as I read the language on pages 8 and 9, this bill, if enacted, would make sure that in the future no such claims could be brought against the landlords because they failed to check the criminal records of prospective tenants or decided to lease to a tenant with a criminal history. Is that correct?
That's correct, Senator. Thank you for the question.
Okay, so those cases will be at an end. And if
As it relates to this, criminal records checks, that
Right.
those cases would be at an
So
end.
if a person is a tenant in a building and the landlord leases to a serial rapist who lives next door to me and manages to break into my apartment and rape me, the person who is raped would not have a cause of action against the landlord for having leased the next door apartment to someone whom the landlord knew was a serial rapist, correct?
Well, the landlord could only be shielded from liability as it relates to the tenants of the bill, and the bill does provide for that initial screening out of persons who are on the sex offender registry. So if a person was a serial rapist in your fact pattern, I'm presuming they would have been apprehended and they would be on the sex offender registry. So under your fact pattern, no, they would not then be shielded.
I'm reading the exact language of your bill. It doesn't refer to sex offender registry. Here's what it says. A landlord's decision to lease a residential dwelling unit to an individual with a criminal history, that would include serial rape, or the landlord's decision not to obtain a criminal history records check may not be the basis for a claim against the apartment and rapes the woman in the next door apartment. That woman would have no cause of action against the landlord for having leased the apartment to a person whom the landlord knew was a serial rapist.
I disagree. If you look at page 6, lines 10 through 29, the duration of the page, it does have the carve out for those offenses that still could be considered by the landlord. So
But there's no reference back to page 6
Sure, but
in the
if I could
language that
just-
I read to you.
if I could finish this
Sure.
that brief
Yeah.
thought. The landlords still have the ability to screen someone out because they are a sex offender. So if the landlord is doing their due diligence, then they would in fact screen that person out based on what's still permissible under the bill. So we would hope that our landlords would be fully prepared to continue to do due diligence and to make full use of the exceptions that are provided in the bill.
But if the landlord did not screen the person out, yes, the landlord in my hypothetical would have had the right to screen the serial rapist out and not lease to him. But if the landlord didn't do that and leased to that serial rapist anyway, it appears to me that the language is on page 8 and 9 would prevent the woman next door who was raped by the serial rapist from filing a lawsuit against the landlord for failing to have screened the person out and declined to lease to him.
Well, that's certainly not the intent of the bill. The effort was made to define those different categories that exist on page 6 and to meticulously go through the criminal code to determine what sort of risky, behaviors or crimes would still be included and prime for screening. So the intent of the bill is that we've enumerated these things because we do realize that they are special exceptions. So I appreciate you highlighting that on page 8 and 9, and I'd certainly consider that a friendly amendment if that's the purpose of your question.
Thank you. Let's go to my second question, which is Mr. Zephyr Shaw, sorry.
Pardon me, Senator, if I may, and I was supposed to do this in my initial opening, and forgive me for being very new, but if I may have the folks who are here in support of the bill to please stand. There are people who did come from many different places who wanted to show their support. We certainly didn't want to overwhelm the committee with witnesses, but I did want them to be acknowledged by standing so that the committee could see the vast amount of support that exists for the bill. Pardon the interruption. Thank you. I'll yield to Mr. Shaw.
That's great. It's an impressive number of people.
Thank you.
So, Mr. Shaw, in your testimony, you said that the landlord could take a look at convictions that occurred within the past 2 years. As I read the bill, it says within the past 3 years. Is there a proposed amendment to reduce that 3 years to 2 years?
Thank you, Senator. That's actually, I neglected to mention that my testimony was based on sponsor amendments that would conform SB 514 to the House cross-file version. So the House cross-file version uses 2 years rather than 3 years.
Okay, so I haven't seen the sponsor amendments, but thank you for pointing that out. That's helpful. What's that? I'm about to ask why 3 years. So now that we've established that the intent of the bill is to say you can only look for the past 2 years, let's get, I guess, the sponsor back again if I could, and ask why the decision has been made that if someone has engaged in arson 2 years and 1 month ago, a landlord should not be able to use that fact as a grounds for not leasing an apartment to an arsonist?
So the sponsor amendments that happened in the House are not amendments that I've introduced to the committee. So if I could respond to your question based on the text that's presented to this committee, I would stick with the 3 years. 3 years is not an uncommon look-back period in the law. 3 years is the statute of limitation for many crimes, many of the ones that are not enumerated here and are those sorts of things we're looking to get people an opportunity to get beyond. So we used the 3 years that exist in law and said that 3-year look-back period would be something that would be sufficient for this purpose as well.
Thanks, that's helpful. But let me ask the question again then. If the landlord takes a look at the criminal record and sees that 3 years and 1 month ago, the person who's applying to rent an apartment was convicted of arson in an apartment house where that person was living, why do you believe that the landlord should not be able to decline to rent that apartment to the arsonist?
We fix time frame windows on everything. If a person committed arson and you didn't find out until 3 years and 1 day, then why can't you pursue them for criminal charges? I think that in the law, we have to make decisions, and we're called on to decide what's an appropriate look-back window, and we do that many times in our code. This is no different than that.
Okay, let me go on. I note that there are only 4 elements of crime that are specified that the landlord is now, if the bill passes, is now going to be permitted to look at. One is a sexual offense. Secondly, that occurred less than 3 years ago. If it occurred more than 3 years ago, the landlord can't pay attention to that. Child pornography that occurred less than 3 years ago. Once again, if it occurred 3 years and a month ago, that's not permitted for the landlord to take a look at. Kidnapping is the third, and arson is the fourth, and that's the extent of the list. So, if the landlord looks into the criminal record and finds out that 6 months ago, the person who wants to rent the apartment was convicted of gang-related crimes where the person was living, it appears to me that this bill would require the landlord to lease the apartment to that person, irrespective of the fact the person was convicted just 6 months ago of gang-related crimes. Is that right?
I want to add a layer onto your fact pattern. So it's not just irrespective of the crime, but this is a person who presents creditworthy, a person who has their first month's rent security deposit, a person who has stable employment where their monthly salary is 3 times the rent. All the other screeners that our landlords use to make determinations, they would still have to meet all that criteria. So in your fact pattern, this person who's committing crime has an incredible credit score. They have a stable employment, they have their first month's rent and security deposit, but they also had a lingering criminal conviction that was eligible for them not being passed over in this bill. Under that scenario, with that particular person, yes, we would ask our landlords to make a conditional offer.
Okay, so gang-related crimes should be ignored. What about drug crimes? Should they also be ignored?
We could do this all day, and I would be happy to, with every crime that's not listed in the bill, but the premise of your question is correct. We have the ones that are enumerated there, as you read for the record, and everything that's not there would be considered, except for the ones that are listed above, which are automatic disqualifiers. But to answer your question, other than the disqualifiers, the 3-year look back for the ones that you named, everything else, our landlords would have to make a conditional offer if they otherwise qualify.
Okay, well, I don't want to keep us all afternoon, but let me just give you one final hypothetical.
Okay.
So a person comes and applies to rent an apartment, and the landlord concludes, based on the criminal record, that this person has been convicted over the past 12 years of child abuse, assault, armed robbery, gun offenses, second-degree murder, gang-related crimes, drug crimes, burglary, and robbery with an intent with a dangerous weapon. All those things, and then as I read your bill, the landlord is not to use any of those facts in a decision not to rent to the landlord, because that should be those crimes should be illegally irrelevant as far as the landlord is concerned, correct?
So I, again, want to enrich and layer onto your fact pattern. A person who's had the time and intention to commit all of those crimes, you're saying that there's a great likelihood where they had the ability to have at least 3 times the income required so that they could meet the requirements for rent. I think under the fact pattern you present, just by the volume of crimes, if this person committed all those crimes and was arrested for those crimes, I think it's very unlikely they meet the threshold. So I don't even think we get to a consideration where the criminal record is a factor. Under this bill, a person still has to meet those threshold requirements.
Understand your response. I just note that some of those crimes could have been very remunerative as far as the criminal is concerned, armed robbery, burglary, and things like that, correct?
I don't know that it's the type of full-time job where you can show stability. I know we have landlords in the room, and as they've explained it to me, they like to see that a person's been on their job for a certain amount of time and see that stability in their work history. Now, you could be a career criminal, but I don't know that that comes with references.
Okay, I will stop there. Thank you.
Thank you.
Thank you. Thank you, Mr. Chair. Thank you for bringing this bill, Senator. As I read it, we have 3 pillars to this bill: reduction of 7 to 3 years, data collection, and then adding the maximum 1,000 civil penalty. And I have a couple questions with that. Number one, while the supporting testimony for this bill, while I may have missed it, seems to have everything to do with we shouldn't be at all checking these criminal look-backs. And I didn't hear really any of the testimony address why reducing from 7 to 3 years is better. I just heard everyone said that we shouldn't be doing the process. And I don't understand the 7 to 3. I was wondering if you could help me with that.
I appreciate your question. I think the 7 years that you're referencing, that was in some of the written testimony. There's a federal statute when it comes to qualifying for federally assisted housing, where the look-back period that's permissible there is 7 years. That's a decision that our federal partners have made, but this bill is much broader. It wouldn't just be for federally assisted housing, it would be for housing in general. So when we're talking about the broader landscape of housing, the proponents of the bill believe that 3 years is the more appropriate look-back.
Okay. But that's what it talks about, page 3, line 15, previously at 7 going to 3. And I understand, because my next question has to do with HUD's tenant protections. I just haven't heard why 7 is too much and 3 is where it should be. And we can follow up and offline for that.
If I may, I believe that we tried to strike that balance with Senator West's question as well. 3 years is a common look-back period in our law. 3 years is the most common statute of limitation for crimes that you would be able to get a second look at under this bill. So we're mirroring that statute of limitation language. If you could no longer be charged and convicted of the crime, then you shouldn't still be held responsible for it when it's time to screen for tenant rating purposes.
And I understand that and appreciate that, but the premise of my question was the testimony here today is supporting that we should be against the current policy, not the 7 to 3. But the second question that I have has to do with the next, I'm calling it pillar, the data collection complaint. I think that's a good part of it. We really need to see what data was the genesis for this. And so my question, do we have any other data from the federal that says that this is a practice that we should go from 7 to 3 for Senate Bill 514?
May I defer to my panel and just check in to see if anyone has that?
Thank you.
Somebody has that? Thank you.
Thank you for the question, Senator. So if I could repeat back the question, it's what is the rationale from reducing the look-back period from 7 to 3?
Right. Is there any data out there that says that?
Yes. So across the country, these fair chance housing laws, they have been passed in state and local jurisdictions pretty recently. So New Jersey passed the most robust law, I believe, in 2021, New York City in 2025, Cook County, Illinois, and a few other local jurisdictions. Data collection is happening right now, but from what we have discovered from our qualitative report, and we produced a research brief last month, we've interviewed housing providers, policymakers, people with lived experience, other tenants. And they have said that after the implementation of the bills in their respective jurisdictions, nothing has changed. And, crime hasn't gone up. People's, right to their peaceful enjoyment of their property hasn't changed. And, some of those jurisdictions have look-back periods that go, 3 years across the board, regardless of the type of conviction. And some just offer an individualized assessment without a look-back period.
Well, the follow-up question, if I may, Mr. Chair, is then, I'll just go into, why is then HUD's tenant look-back protections not sufficient?
So HUD's protections around their housing for federally subsidized housing, there are only two statutorily required prohibitions based on convictions, and those are people who are on the lifetime sex offender registry and people who are convicted, and this is very specific, people who are convicted of producing methamphetamines in federally subsidized housing. For all other convictions, they leave it up to the Public Housing Authority's discretion. But in last year's proposed rule that HUD came out with to reduce barriers to federally subsidized housing for people with conviction histories, they had suggested that a 3-year look-back period is appropriate.
Okay, and you may be able to answer this question, if sir. With a maximum $1,000 civil penalty, what's the genesis of that? Why did we pick 1,000? Is there something else in code that would align with, or should the maximum be up to 5,000? I mean, you look into? Okay.
Yeah, we'll definitely have to look into that and come back to you.
The last one, you know, a lot of people on this committee know I am not an attorney. I know I sound like one, but that in my questioning, just kidding.
I'm not an attorney either, so I
Oh, yeah, hey, then we can, so this will be perfect for you. Can you walk through me the process of conditional offer in like a layman's language? I mean, a lot of this tenant landlord laws that we pass here are for the big conglomerate, those who have management companies and all that kind of stuff. I have more favor for those who are the small landlords. And so could you walk through from a layman's standpoint, what exactly the conditional offer and how that would happen?
Of course. And actually, I could speak from my personal experience because I myself am formerly incarcerated. I was released from incarceration in 2010. And fortunately, I live in a jurisdiction that actually has these protections in DC. So I was actually able to walk through or live through the conditional offer process.
Please.
So when I rented my current apartment, I saw the apartment. Leasing agent showed me the place. I liked it. My wife liked it. And then we took it off the market by putting a security deposit. They ran a credit report and verified that we both made 40 times the income on an annual basis. And after we were given a conditional offer based on that credit report, then the landlord provided a notice for me that both of our criminal background checks will be run. And DC, because they have those protections, because they have a look-back period, I fell outside of the look-back period. And then after that, I was approved. So it's taking the house off the market with a security deposit, credit check is run, conditional offer is made, and then a criminal background check is run.
Okay, thank you. Thank you. Appreciate that. Thank you, Mr. Chair.
All right, further questions from the committee? All right, seeing none, thank you all very much. Thank you. I will now move on to the next panel of proponents. It's Martin Mitchell, Shyam Washington, Darrell Davis, and Ms. Hilliard, Elizabeth Hilliard.
Chairman, I'm actually not going to testify because our other OP person was able to.
Oh, great. Okay. Excellent. All right. Whoever would like to go?
Good afternoon, Senator Smith, Chairman. Good afternoon, and thank you for this opportunity to give me a chance to speak. Good afternoon, Senator Henson. Thank you all for being a part of my journey and allowing me to be a part of your journey. My name is Darrell Davis. I am a real estate investor. I am a business owner in Fort Washington, Maryland. I am a proud graduate of Bowie State University, and I also am a former incarcerated citizen from the Department of Corrections in Maryland. Upon being released in 2012, I began the road to redemption. On the road to redemption, I was blessed with an opportunity to receive my bachelor's degree in 2017. Also, while working to improve my life, I was able to acquire a brick-and-mortar location for my business and obtain a commercial lease. However, due to discriminatory housing practices in Maryland, I found myself homeless and living in my gym until 2022. Voting yes for SB 514 not only helps individuals such as myself, but it helps to strengthen our economy because 22% of working adults in Maryland find themselves with some kind of former incarceration record. Voting yes for SB 514 not only strengthens our economy, but it also helps to brighten the future for the students and the youth of tomorrow because 67,000 students have a parent who has some kind of previous incarceration record. Voting yes for SB 514 not only brightens the future for our students tomorrow and strengthens our economy, but it also strikes a blow against homelessness because an individual who has been previously incarcerated runs the chance of being without housing 10% more than our general population. So I'm here to stand in favor for SB 514. Thank you guys for giving me an opportunity to share my experience.
Greetings, Chair and distinguished members of the committee. I appreciate you guys for taking up this issue. It's a very important issue. My name is Martin Mitchell. I'm a former councilman from the city of Laurel and an active NAACP member, but today I'm here as a community organizer for Life After Release. Life After Release is a Prince George's-based reentry organization that helps our brothers and sisters returning home and some while still in a carceral state. I have been in our community for years, and fair housing has continued to be a top priority, especially for the returning citizen community. Housing is a basic necessity and should be granted to everyone. Many times we don't truly understand an issue or empathize with an issue until it hits home or affects us personally. This bill is personal to me because one of my younger cousins has been incarcerated for several years, but fortunately he will be released this June. I had the pleasure of talking to him yesterday and, mentioned this bill to him. And he said, well, that's fortunate. Hopefully I won't have to live with the family for too long. And, that is the goal that, after someone is released, after they complete their time, they should have, the basic necessities afforded to them. The integral question we must ask ourselves is, does everyone deserve fair housing? And I believe everyone will answer to that affirmatively, yes. I stand here today and I implore this deliberative body to vote affirmatively for the Maryland Fair Chance in Housing Act, SB 514, and I want to echo and say that I'm sharing the story of many of our members of Life After Release who are doing the work, thereafter, and they just want a fair chance. Thank you.
Good afternoon. My name is Shaheen Washington, and I'm a leader with Turnaround Tuesday. Turnaround Tuesday strongly supports the passage of SB 514. Turnaround Tuesday is a workforce development movement which supports returning citizens in Baltimore City by providing job placement, social skills training, wellness resources, and housing assistance. Many of our participants arrive seeking employment but express deep frustration over housing denials despite securing jobs and meeting all other reintegration requirements. This challenge reflects the broader struggles faced by returning citizens across Maryland, yet it remains a persistent reality for those Turnaround Tuesday serves weekly. While Turnaround Tuesday successfully connects returning citizens to career opportunities, housing remains the primary barrier beyond employment. Many share feelings of defeat, questioning the value of working hard, only to be denied stable housing. Some, despite securing jobs, are forced into having to accept some of the worst housing due to these barriers, leaving them to wonder, am I not worthy of a second chance when I'm doing everything right? But let me quickly tell you my story. So growing up on Baltimore's west side, I lacked access to resources which pushed me to the streets to support my 6 younger brothers. At 18 years old, I was convicted and sentenced to 10 years serving 8 in prison. After my release, I committed to turning my life around, but the stigma of my criminal record made finding stable work difficult. In 2023, I landed my first job since release through Turnaround Tuesday and started rebuilding my life. Despite improving my credit, my finances, I faced repeated apartment denials. Discouraged, me and my girlfriend, Y and I searched the Baltimore County, and we were approved for an overpriced apartment that we couldn't afford. Almost 2 years later, I'm employed as a community engagement specialist for Turnaround Tuesday, and I work with Bill to advocate for the reforms in the criminal justice system. I'm expecting a new child in June, and I'm preparing to move again. But despite my process, since my incarceration, I still harbor feelings of being denied housing. By acting this year, Maryland has the opportunity to ensure justice-impacted people have real second chances to rebuild their lives. Thank you.
Excellent. Thank you very much for your testimony. Questions from the committee? All right. Senator Muse.
Thank you very much, Mr. Chairman. And to anybody who can answer this, and thank you for coming down from the 26th Legislative District. Hey, you tell them I was behaving myself and working, okay? This is a question for any of you. I've often struggled with this. On the one hand, we say we can deny you housing, and yet on the other hand, there are laws that say if you're sleeping in a park, you can be arrested. Where in your mind, I mean, I don't know what you've done, but I just struggle with what do we do? You can't go to the bathroom in the street, you can't live in the street, you can't live in the park, you can't live, and at the same time, you can't get housing. I'm just trying to struggle with what else the answer would be, and how did you live when you couldn't find apartments? Anybody can. How did you live when you couldn't find where? How?
Thank you for the question. Thank you for the opportunity to answer it. There's an old saying that I was brought up with in the church, that it takes a village. And I truly believe that for a returning citizen to establish a life that allows them to be a productive member in this community, not only does it take the village of his family, but it takes the village of his community. And being able to provide a substantial place for someone to not only require shelter, which provides them an opportunity to substantiate their needs, I believe the first thing that we can do is create some type of educational program. Because of the way that the law is worded, our opportunities to obtain residential leases are much different than our opportunities to obtain commercial leases. However, if one does not understand the wording of the law and how to navigate these financial spaces, you find yourself faced with certain obstacles that make it hard for you to take care of yourself. So the first thing that I would say is creating a safe place between organizations that allow for a smooth reentry educational process on what to expect upon release.
Thank you, and thank you, Mr. Chairman.
Excellent. Further questions from the committee? Well, all right. At the risk of sounding corny, I'll say this, and I'm sure that the senator from the 26th district will affirm this, but Mr. Davis, you started your testimony saying, thank you for allowing me to be here. I just want to say that this is your committee, this is your government, so thank you for taking the time to participate in the process. But you'll never have to ask permission to be here. This is yours, so this is your government at work. All right, further questions from the committee? All right, thank you all very much. All right, we'll hear from Shanice Anderson, and then we've got some people joining us virtually. Is that Ms. Anderson coming up? Okay, I guess we can let some folks in the. After Ms. Anderson finishes her testimony, we're going to move on to E.V. Yost. You'll be next, okay?
Good afternoon. Esteemed members of the General Assembly, thank you for affording me the time to vocalize support for Senate Bill 514, addressing the issue of fair and accessible and equitable housing for justice-impacted persons. I serve currently in the position of Community Engagement Coordinator for the Maryland Office of Public Defender. I created and oversee the Reentry Project for OPD. The project supports our clients by connecting them to social support services, resources, and providers to assist with daily living. One of the most, if not the most vital of social supports is housing. Housing requests account for over 1/3 of the referrals made to the Reentry Project. Housing requests account for over 1/3 of the requests made for the Reentry Project and remains the most persistent barrier to reentry. As indicated in an article published by the Center for American Progress entitled Strengthening Access to Housing for People with Criminal Records is Key to Successful Reentry, and I quote, long-term housing options require broader scale and capacity, as well as integration into the existing private housing market. The vast majority of rental units in the United States are privately owned and run, with 38% owned by individual landlords and 40% owned by partnerships or corporations, indicating that successful reentry policies need to focus on the private rental market. Since background checks disproportionately affect Black and Latino communities who are overrepresented in the criminal legal system, strengthening renter protections would also provide more equitable access to safe housing and help reduce racial disparities in homelessness, employment, and health. Our clients have been given move-in dates, paid application fees, only to be denied once the lack of credit and background check reports came back. This practice is disqualifying, unfair, defers hope, and denies access for those that are marginalized and face increasing disparities. Redemption isn't just a passive state, but an active pursuit that requires concrete steps towards improvement. It is for those reasons that I asked this esteemed body to support Senator Henson's Senate Bill 514.
Excellent.
Thank you.
Thank you very much. Questions from the committee? All right, seeing none, thank you very much.
Thank you.
Thank you. All right, we'll now move on to Evie Yost. You're up. Welcome.
Thank you. Good afternoon. My name is Evie Yost. I'm a housing attorney in Disability Rights Maryland, the state's federally designated protection and advocacy organization mandated to advance the civil rights of people with disabilities. DRM strongly supports SB 514 because it aligns with our goal to end the unnecessary segregation and institutionalization of Marylanders with disabilities. This bill would increase housing opportunities and decrease the potential for discrimination for renters with disabilities who are more likely to have criminal histories and already face numerous barriers to accessing safe, affordable, and accessible housing. While only 15% of the general population is estimated to be disabled, at least 40% of all people currently experiencing incarceration in the U.S. and 23% of those on probation or parole are disabled. Criminal record discrimination disparately impacts Black disabled households. It's estimated that more than half of all Black people with disabilities in the U.S. will be arrested before they reach age 28. By limiting a landlord's ability to require disclosure of prior convictions before making a conditional offer and providing for recognition of consideration and of evidence of rehabilitation and mitigating factors surrounding an individual's conviction, SB 514 would promote housing security for people with disabilities who previously interacted with law enforcement due to conduct resulting from their disability. I work with countless adults whose mental or behavioral health disabilities like autism, PTSD, or schizophrenia sometimes cause them to behave erratically or have difficulty controlling their body's responses during interactions with law enforcement, which results in criminal records which, without context, might lead a landlord to draw inaccurate conclusions about them as prospective tenants. Without protections like SB 514, people with disabilities are at risk of long-term homelessness or institutionalization due to their inability to access housing and the stigma associated with criminal records that are often the result of benign behaviors associated with manageable medical conditions. Increasing access to decent, safe, and affordable housing for people with conviction histories is a long way to ensuring that those with behavioral health disabilities have the opportunity to be fully integrated into all aspects of the community and to enjoy a healthier and better quality of life. For these reasons, we strongly urge a favorable report. Thank you.
Excellent. Thank you very much. All right, we're going to continue on with the panel, then we'll open up for questions. Jamar Russell, you're up next.
Yes. Thank you all for this opportunity. I'm in favor of Bill 514. My name is Jamar Russell. I'm a returning citizen and a successful graduate of the reentry program in PG County. Currently, I am employed by the Behavioral Health Division of the Health Department mentoring the youth. Now, one of the things that I would like to point out to you is while I was incarcerated, I was able to manage a $3.2 million contract for the Maryland Vehicle Administrator. Now, though I've done my time, I've also proved that I can be successful in various areas. And I don't think that anybody that's gone through a situation like mine that have served their time or being able to be impressive in other ways to re-enter society should be further penalized. So we have to think about the things that can actually aid the returning citizens to become successful. This includes housing, where a person can actually have more peace. Coming from where we come from, there's a lot of noise, a lot of different things in which people have to engage in. So being able to transition where people aren't used to things going into society would be necessary for the housing. Then there's further things, excuse me. Oh yeah, the things to be able to be encouraged to be more successful. So while in my reading and during my time, there were things like the New Jim Crow and the Meaning of Life that was done by the Sentencing Project that shows that there's a lower recidivism by people that have done certain time, had an education, and done numerous programs. So what we need now is to make sure that we also have the housing to prove that these people can be further successful, me being one of them. So I've been out here for 15 months, have self-published 7 books, and working with various programs to facilitate the help the at-risk youth and the juveniles. So there are more men that's like me, and some of them is serving time and can't get housing because of this.
Excellent. Thank you very much. All right, now we'll turn on to Altariq Witcher. You're up. Welcome.
Thank you so much, and thank you for having me. And my name is Altariq Witcher. I am from New Jersey. I am currently the Managing Director of External Affairs for Fair Share Housing Center based out of Cherry Hill, New Jersey. We were one of the organizations that helped spearhead New Jersey's Fair Chance in Housing Act that mirrors SB 514. I am also director and co-founder of the Returning Citizen Support Group, which is also based in New Jersey, a group of formerly incarcerated individuals working to provide wraparound services for those returning from the carceral space. I am also a property owner. I own 2 multifamilies, and I manage properties for several other real estate investors. And I actually rent almost exclusively to returning citizens. Having been a returning citizen myself, or being a returning citizen myself, and knowing the challenges of finding affordable, safe, affordable housing. I was given an opportunity in 2011 to rent my first apartment when I first came home. And thereafter, I purchased a multifamily from my landlord 4 years later and started my property management business. And I've been pretty successful and mostly dealing with the renting to returning citizens. I know there's been a lot of testimony, so I don't want to rehash many of the other things that have been said, but people returning from the carceral space are entitled to adequate housing. I've had super success renting to returning citizens. When COVID hit, many residents who were, or tenants who were gainfully employed, had no prior criminal history, great jobs, great references, everything else, they fell on hard times, while at the same time, my returning citizens were the ones working Amazon, ShopRite, different jobs, and they were the ones that maintained good tenant status throughout. For those landlords that don't realize how vital it is to rent to returning citizens, I'm here to state that it's a great untapped market that they really need to look into. I thank you so much for this opportunity to speak.
Thank you very much, Mr. Witcher. Questions from the committee for our panelists joining us virtually? All right, seeing none, thank you all very much. All right, we'll now switch over to the favorable with amendments, and I see Mr. Anlu and is Ms. Clark here, Ashley Clark.
Good afternoon, Chair Smith. Happy birthday. Vice Chair Wallstreicher, members of the committee. For the record, my name is Ashley Clark. I'm here on behalf of the Maryland Multi-Housing Association. We do want to acknowledge and thank Senator Hinson for working with us on this important legislation. The first thing I'll start by saying is that landlords are in the business of leasing apartment homes. Our goal is to have 100% occupancy and not to deter applicants from that housing. And so we do want to acknowledge acknowledge Senator Henson's concerns regarding the barriers to housing, which is why our members try to do their best to not only work with, but also be sensitive to housing challenges faced by formerly incarcerated individuals. I did want to take a few minutes to highlight some of the amendments we discussed with and are continuing to work with Senator Henson on. The first being the removal of the conditional offer. We believe that's an unnecessary two-step process. And don't believe that rehabilitated individuals should have to go through multiple steps to gain access to housing. They've already gone through enough. And so if we are able to make it plain by what the offenses are at the outset, based on a 7-year look back, there aren't any surprises or letdowns when they are trying to get access to housing. The second thing, and I want to acknowledge Senator West and Senator McKay for bringing this forward. The listed offenses should have a 7-year look back and not a 3-year look back. These are offenses that landlords should be able to consider when providing housing. We can't guarantee someone's safety, but we do have a duty to mitigate risk, particularly if they are known. And so that's for the safety of all tenants. The third thing is related to the Attorney General's data collection and the published information that's provided. Our members are fine with the collection of the data, but we do have some concerns with the publishing of that information. Excuse me. Particularly, well, I will end and say that it's not a denial, it's a delay for what we think is a reasonable time frame. And so with that, we are asking for a favorable report with amendment. Thank you.
Good afternoon, Mr. Chair, and happy birthday, members of the committee. We want to, Brian Anlou with the Apartment and Office Building Association of Metropolitan Washington. We want to commend the sponsor for introducing this important piece of legislation. Many AOBA members are proud to provide second chance housing for tenants. To that end, they support the individualized assessment, notice provisions, and only not denying based on arrests only. However, housing providers need to be able to screen prospective tenants for violent crimes, including assault, burglary, and robbery. Need to be able to screen for fraud, including defrauding individuals, credit card and insurance fraud, and drug-related criminal activity, excluding marijuana. As you all know, Maryland is still facing an opioid crisis driven by heroin and fentanyl dealing, but the bill only allows housing providers to specifically screen for methamphetamines. Including these amendments would align Maryland's law with DC's criminal history law. Lastly, the 3-year look-back period is not sufficient. You all heard testimony earlier that HUD considered moving to a 3-year look-back period last year. The Biden administration actually rescinded that revision early last month. According to a 9-year Department of Justice study, almost half of returning citizens who did not have an arrest within 3 years of release were arrested in years 4 through 9. And so we think that the 3-year look-back period is insufficient. Lastly, AOBA is happy to work with the sponsor to find the right balance between protecting tenants and increasing housing options for returning citizens. And so with that, we respectfully urge a favorable report with amendments.
All right, questions from the committee. Ms. Clark, you were going to talk about the publication of the information. I just want to give you an opportunity to finish that thought.
Sure, thank you. Thank you, Chair. The only thing that there were a couple of data points in the bill. The first being the good faith compliance that's listed. It's not really defined what that would be. And then it also doesn't mention how long a landlord would be on the website, nor the process of the removal from having their names published for that information. And it's also not clear whether it would be per infraction or if it's based on a certain number of complaints for that particular landlord. So those are some of our concerns with the piece related to the Attorney General.
Excellent. All right. Further questions from the committee? All right. Thank you both very much. Thank you. All right. Is Mr. Castelli here? Signed up in opposition. All right. So that looks like that's it. With that, that'll conclude the hearing for Senate Bill 514. Thank you very much, Senator Henson. All right, we're now going to move up to the top. We're going to go with Senate Bill 446. We have Claire. Ms. Barrington coming up. Yep. Okay.
All right.
She can take pictures.
Good afternoon, Chair Smith, Vice Chair Waldstreicher, and members of the Judicial Proceedings Committee. Thank you for the opportunity to present Senate Bill 446, Condominiums, Property Insurance Deductibles, Unit Owner Responsibility. Senate Bill 446 raises the unit owner's property insurance deductible from up to $10,000 for damages originating from their unit to up to $25,000. This will save thousands of dollars in premium costs for both condominium building owners and unit owners. Increasing numbers of claims for damages to buildings are raising rates on master policies. This results in higher premiums for condominium building owners. By increasing the amount for which a unit owner may be responsible in case of building damage, overall master policy premiums can remain reasonable because the building's master policy will not be responsible for as much of the damage repair. With this simple change, premiums can be less affected by damage to the building originating from an individual unit, which means fewer costs will be passed along to condominium owners. This bill would not necessarily make unit owners personally responsible for paying up to $25,000 out of pocket, as the incidences in which this deductible would be paid can be entirely covered by their own unit owner's policy. Therefore, Senate Bill 446 is only increasing unit owners' deductible in case of damage to the building originating from their units, insured under unit owners' policies, so that overall master policy premiums do not continue to rise. Condominium and unit owners will both save money, and unit owners can choose insurance that includes this deductible for damages originating in their units in their individual unit owner policies. Senate Bill 446 will positively impact condominium communities and protect against rising costs. For these reasons, I respectfully request a favorable report on Senate Bill 446. Thank you.
Thank you very much. Questions from the committee? Senator Muse, you had a question?
Thank you. I'm saying, hi, how are you?
Hi, I'm great. How are you?
Tell Senator Bio that her friend asked about her. Let me ask you something. I'm kind of confused. This means that individual owners of a condominium who are now paying $5,000 deductible.
Up to $10,000.
We are going to make a decision by law that they have to pay $25,000. Is that correct?
Yes and no. The current ceiling on deductibles that a unit owner may be responsible for is $10,000 currently. And with this bill,
and they want to raise it to $25,000.
Yes, and this is in an attempt to minimize the amount for which a master policy may be liable so that those premiums don't continue to rise. Condominium building owners are seeing their master premium continue to rise as claims are made against the policy.
Okay.
And so by increasing the amount for which a condominium unit owner may be responsible for, the master policy will be claimed upon or claimed against less, which will keep premiums lower for
At the same time, you have people with limited incomes, you have seniors, and some of the calls I'm getting, it's scaring them to death. How would they even do that? Some of them are asking. The last question is, if I may, why is it that the condominium association cannot get together and figure this out and vote? Why are we making a law raising somebody's, insurance? When it comes to liabilities, why would we do that? Because I don't see any other place that's done that before.
Thank you for your question. If I can respond to the first part. Fortunately, many insurance policies insure this deductible so that should something happen and a unit owner is liable for $25,000 under this law, the insurance company will actually pay that claim. It doesn't necessarily mean that the individual unit owner will be personally held liable for that cost. Their insurance policy for their unit within the apartment can cover that.
For me, anytime my deductible is going to be A, B, C, and D, nobody's going to pay that but me. I wish I had an insurance company that would say we're going to pay this for you. I'd stay there for the rest of my life. So I'm not sure. And I guess my only question now, and I'll get with the Senator, but you're doing an excellent job. My only question is, why would we as a legislature, be involved in saying, for this particular, this condominium, we are going to raise the deductible and put it in law? That's my basic question, but thank you.
To clarify earlier, the deductible, as I was informed, the term is used in the legislative process, but not necessarily in the same way that an insurance company would administer that. So it is part of a policy rather than a deductible in terms of what you may be familiar with. And as to why the necessity of this bill, I can definitely get back to you with answers from Senator Bidle on that.
A+. I'm going to tell her when I see her. Thank you very much, and thank you.
Ms. Garrettson, what is your affiliation with the chair's office?
I currently intern for the senator.
Yeah. I'm gonna go ahead and say that you should be, there's got to be a promotion on the way there, because this is a stellar job.
Thank you so much.
She may have some competition for that next round of the Senate seat, but no, I'm kidding. But seriously, excellent job. That was amazing.
Thank you for having me, and happy birthday.
Hey, thanks. Oh, thanks. Triple bonus points. There you go. All right. Let's see. Is Scott Silverman? And then we'll switch to the opposition panel.
Chairman Smith, Vice Chair Waldstreicher, and members of the committee, thank you for having me. My name is Scott Silverman. I am a community association attorney. I've been representing condos, co-ops, and HOAs in the state of Maryland for about 30 years. I want to devote my time to responding in part to Senator Muse's questions further to clarify. The underpinning of Section 11114 of the Condo Act, which this bill would modify, is the thought that the common risk in the association is better borne by the collective of unit owners, the association, rather than the individual. Before, and that is through the protection of the policy, the master policy. Before 2009, we spent a great deal of time and often a lot of litigation arguing about who is responsible for the deductible, the master policy deductible. Then the legislature came along and you changed 11114 to create what is essentially no-fault insurance. So under the master policy, under 11114, if the cause of the loss arises in the unit owner pays. If it arises outside of the unit, it's a common expense. It doesn't matter who was negligent. And the thought at the time that was preferable to protracted litigation with unit owners and condominiums battling each other over who was responsible for who left the bathtub running. So what happened was the legislature, in making the change, had to establish a limit for which the owner is responsible. And initially the limit was set at $5,000. Then, I'm sorry? Who established that? You did. The legislature did. Several years later, you raised it to $10,000 in recognition of rising premiums and rising deductibles that are being forced upon the master policy holders as a result of losses throughout the industry, which we've all seen in the news, both natural disasters and a proliferation of occurrences such as occurred in Surfside. There's also been proactive measures taken by the associations to raise their own deductibles in order to keep their premiums under control and to resist the need to raise assessments to meet premium costs. Okay, that's a very important motivator as well. Now,
let me just ask you this so that you can.
Sure, go ahead.
So that you can continue.
Absolutely.
There's nobody I know who understands condominium law except Delegate Holmes.
Yes, I understand. He's been an important ally.
And you came up with 20. It's a big jump from 10 to 25. What's the justification for that jump?
I'll tell you exactly. Right now, if you may or may not be aware, the condominium insurance market is crazy. Our clients are seeing premium costs that are increasing year over year by as much as 150 to 200%. This is resulting in incredible assessment increases. The only way to balance the scales under the way the current law is constructed is to make the unit owners responsible for the deductible when the loss originates in their unit. And I agree with you. That does increase individual unit owner responsibility. However, we are not doing this without consulting with the what we call the HO6 carriers, which are the insurance carriers that are writing policies for the individual owners that cover their improvements and betterments, their personal property, and when they are held responsible for the master policy deductible. And there's, in fact, a bill that is supposed to be dropping this session, I'm not sure if it's in the hopper yet, which will mandate HO6 coverage throughout the state of Maryland for condominium owners. Right now, it's dependent upon the governing documents. They have to amend to make that requirement. This bill, when it drops, will require that coverage, and the HO6 carriers are going along with the jump from 10 to 25 and have indicated to us that the premium increases for those HO6 policies will be modest. Right now, it costs dollars a month for an individual unit owner to insure themselves against what is now a $10,000 chargeback. It will only be several more dollars a month for them to insure themselves against a $25,000 chargeback.
And I'm sure this is not your motivation, but the reason I ask that is because I've been involved with condominium associations for a long time. The only time in my district I've seen this done, something like this done, is when they wanted a certain group of people to move out so that they could up the rent and bring another group of people in. That's the only time I've seen something like this again.
That is not what's happening here. In fact, Senator, I would give you the analogy that condominium unit owners are like people put in partnership with one another in a business where they couldn't choose their partners.
Okay.
So imagine if you were in a business where you were in charge of a multi-million-dollar budget in some cases, and you couldn't pick the people that you were in there with. And that's where these people are. And unfortunately, condominiums are becoming increasingly unaffordable nationwide and in Maryland because of these escalating costs, not just insurance, which is a major driver, but also the aging of the infrastructure, which many condominiums are now facing, having to reserve for, and that's pushing up their assessment costs as well. So we're trying to do this, trying to keep condominiums affordable for the citizens of Maryland. And under the current law, this is the only way we know how to do it.
I appreciate you taking the time to do that, and thank you, Mr. Chairman, for letting him, because this is not my area, but thank you for letting me.
No, it's good.
So I can understand.
No, 100%. I learned a lot. All right, further questions from the committee? All right, thank you very much. Thank you, Mr. Silverman.
Thank you, Senator, and happy birthday as well.
Thank you very much. Thanks. All right, now, so that'll conclude the testimony for the proponents of the bill. We'll now switch to the opposition panel, and we'll start off with Jenny Polhouse and Jean Hyatt.
Happy birthday. I didn't know it was your birthday. Birthdays are very precious. My name is Jeannie Polhouse, and I am a condo owner. Thank you for allowing me to give my opinion of this bill. Ever since the condo building in Florida collapsed, condo owners in the state of Maryland have been lambasted with one piece of legislation after another. The first one was written in such a vague manner, House Bill 107, the Reverse Reserve Study Bill, that it has caused condo associations to raise their condo dues dramatically, in addition to annual assessments that are bankrupting many condo owners. Now, this bill wants to increase our insurance deductible for damage to common areas, which rarely happens, to $25,000. That will add another cost to our ownership fees. This is in addition to our incredible increase in water bills and our gas and electric bills, particularly in Baltimore City. In Baltimore City, many condo owners are elderly, such as myself. I am 82 years old. I am too old to move somewhere else. And we bought a condo because it was a more economical way of home ownership without all of the maintenance. Now it is becoming unaffordable. This must stop. I am not in favor of this bill. Thank you.
Hello, my name is Jean Hyatt. I've lived in, thank you for the opportunity. I've lived in my condo for 30 years, pretty peacefully, raising modest rates each year. No one assessment in 30 years. The building falls in Florida. We're bombarded with laws, as Jeannie said. I'm passionately opposed to this bill, and I am not a political person. I'm trying very hard not to be emotional. I've heard Scott Silverman talk about these things. Everybody's talking about it except the people who are living the law. And let me tell you, it has been awful. I would like to focus on one main reason. I think the deductible, which is the amount of financial risk you can take, should be between the person and the insurance company. It's always been that way. It's the way with auto and health and long-term care. And insurance companies put on their websites, choose the deductible that's the most you can afford, but no more. Suddenly, people are saying, you know, the law is considered that we should have to pay such and such a deductible. And I heard, in respect to Mr. Silverman, talk about all kinds of things and then say, but with a $25,000 deductible, you will save a little bit on your premium. I want to tell you, I'd rather have a few dollars on my premium than be exposed for $25,000. I'm a retired school teacher, and I just feel like, no offense, I don't feel that any state legislature should have the role or the right to determine what the deductible is, which is the financial exposure you can afford to take. That's not the same as coverage. So, you know, I guess if they said you've got to have X amount of coverage on your condo like they do for rentals, okay, but I really do hope you will not vote for this bill, which will put a terrible burden on us. And I think really, I don't know any other state that is forcing people to take deductibles that they may or may not be able to afford.
Senator
Thank
Hughes
you
has a
for
question.
your time.
Thank you very much. Thank you.
And these issues are important to me without boring you about anything else, because housing is important.
I'm sorry.
These issues are important to me because people having housing is important to me without having to go into a bunch of things that you won't know. You said something. You said you can make your own, you could get your own insurance company. Is that what you said? You could get your own insurance company and you can kind of figure out the deductible outside of what this bill does.
Well, what I'm saying is in all phases of our life, auto, health, long-term care, everybody talks to an insurance company, you figure out what should the highest deductible I can take that I would feel comfortable if I had to come up with this money. And then they base the premium on that. And I just feel like for the state to say you've got to have this deductible when I just feel like I don't think anybody would like someone else to say to them, I don't know your financial situation, but you've got to expose yourself to this financial risk. And even though you are quite willing to pay the insurance, we're not going to give you that choice. We're going to say you must have this deductible. And I can tell you, things do happen. My neighbor's refrigerator, she didn't know it. She's in a wheelchair. It dripped onto my ceiling. She didn't know it. If this law were in place, she would have had to come up with $10,000, $15,000. I used to work for many years for insurance defense attorneys, and they're very good at their job, and their job is to make sure the insurance company doesn't have to spend money, so they'll find ways. But the main thing is, I have asked everybody, including sponsors of the bill, why did you do this bill? And I haven't gotten any answers, because if it is to help condo owners, it certainly doesn't help us. It hurts us. The only one in my opinion, that this helps is insurance companies, because now with
That's
$25,000,
my point.
they're off the hook. They don't have to pay. They don't have to pay it. If you didn't have this, then I would pay my deductible and they would have to pay.
Right.
But $25,000 is a big hike.
And if I may,
Yeah, of course.
one
Yeah,
more.
to make sure.
Somebody said you're 82 years old, and I suspect that you're retired and you're on a fixed income.
Yup.
For me to vote on something like this, to give you something that is $25,000,
I would
then
have
you'd have to move, and then somebody else comes in, and it just goes on over and over again. Is that correct? Okay, that's okay. I got what you're saying.
And if I just might very quickly say, Senator, I mean, I really have a problem with any state entity saying to anybody, we're insisting you take this financial risk. So basically you're saying to me, I want you to take a risk that will bankrupt you, and you won't have any choice in the matter, whereas I would like to work with my insurance company and take a risk that's suitable for me. And if I have to pay a slightly higher premium, I would rather pay that premium.
Excellent. Senator West. Thank you very much. Thank you.
Thank you, Mr. Chair. I missed most of the hearing, and I'm sorry. I was back working on another bill. But I just want to thank you ladies. This is the second time you've been down here during this session, and both because there are a lot of bills this year that involve common ownership communities. My guess is you may be back again. And
on Tuesday.
I want to say it's a pleasure hearing from you and hearing common sense. Just one question. I'm assuming that in your common ownership community, an awful lot of the people are senior citizens?
Most of them, yes.
And you're operating on fixed incomes?
Yes.
And I think we should keep that in mind when we review bills that place requirements on people who live in common ownership communities.
I think that's why we came to condominiums, because we thought this way people pool their money and all these things can be done through the association. That's one reason we moved to condominiums.
Great.
Thank you so much.
We'll look forward to seeing you again. Thank you.
Thank you both.
See you next Tuesday. Thank you all for being here. Senator West, you make a good point. You make a very good point. All right. I think that's it. And that'll conclude the hearing for Senate Bill 446. Well, now I know we're joined by Senator Jennings, Senate Bill 489. Welcome.
Thank you, Mr. Chairman, distinguished members of the committee. For the record, Senator J.B. Jennings, District 7, here on Senate Bill 489. This session, you've had many bills dealing with this issue. I think it shows that it has become a major issue in our districts, and many of the legislators have tried to address it, and this bill is no different. This amended version actually is trying to specifically address a primary concern of the property owners, which is expediting the eviction proceedings through the court system with this when they find that they've had these false leases issued. I worked with the court, spoke with them. I'm not speaking on their behalf, but they did make recommendations and gave their opinions. And one of those is a significant amendment that a hearing must be scheduled no sooner than 4 calendar days and no later than 7 calendar days after a complaint is filed. And that is designated to protect the homeowners and the legitimate tenants from individuals who illegally take possession of a property. Some of those most common schemes out there that we're finding are scammers are posting as landlords, collecting deposits and issuing fake leases, and creating these leases with fraudulent signatures. Unfortunately, we do have our constituents that are signing these and taking possession of a home and living there, but they're not living there, unfortunately, legally. And you do have the homeowners that are having to figure out how to get these people out of there. It's unfair situation for both sides, both the homeowner as well as these poor individuals who've taken the possession of the home. But it's a situation that needs to be resolved, and I'm working with the homeowners on this side. This bill streamlines the eviction process, ensuring eviction hearing occurs within 7 days of case posting, allowing eviction determination to be made within the same day as the hearing, and authorizing immediate enforcement of the eviction by the sheriff's office. Again, Mr. Chairman, you've had several bills on this introduced. I know this committee works very hard. You guys spent a lot of time deliberating and going through these bills. I'm just offering another piece of legislation here with some ideas, with some amendments to hopefully put into the debate in the equation as you try to come up with a resolution to this issue that we're trying to address. So with that, I ask that you please look at this legislation and try to come up with some type of compromise to fix this situation.
Thank you, Senator. We've had people from Baltimore City, Prince George's County, Montgomery County, Baltimore County, and now you're just all talk about this issue. So we've got a couple of vehicles. We're definitely going to work on this. So thank you for this, another avenue to consider. We'll go to Senator Sidnor, then Senator West.
Thank you. From the defrauded side, I know this bill is about the other side, but I'm curious, do you have any ideas on how you help the other side that's been defrauded? They come into a place, maybe I'm claiming that I own the home and now I'm collecting rent and I really don't own the home. So this gets me, but do you have any ideas on how you deal with that person who
So you're saying, I'm sorry, I just need you to speak up a little louder. I sit next to a senator upstairs that, ironically, she's always making me speak louder.
So you want a place to live. I act as if I'm the owner.
I sign a lease. You come to me. I'm looking for, let's say I go on Craigslist to find out an apartment.
Correct.
You list it. I come, I sign the lease.
Correct.
I move in. Come to find out that,
yes,
over here he's saying, hey, this is my property.
Right.
He didn't own it.
Right. Any idea on what we should do for you?
That's what I said. It's a tough situation because now I'm stuck saying, hey, I signed a lease.
Right.
But I'm living illegally in a piece of property that, unfortunately, that I don't have the right to be there.
Right. Do you have any idea on what would be fair to you?
I'm going to have to move out. I mean, I'm not legally there. Let's be honest. I'm not legally there.
Okay. Thank you.
I'm going to have to move out.
Thank you, Mr. Chair, and thank you very much for this bill. When I first read the bill, I thought, oh dear, it's another squatter bill. And the squatter bills all seem to have the same problem, which is that it takes forever to get these issues resolved. And if you try to do it really quickly, you're risking abusing the constitutional rights of the person who's being thrown out. But I love your amendment. I think your amendment is a really venturesome and creative way of trying to have a quick hearing in which everyone has a chance to be represented and get a quick decision so that the person who really owns the property and has the right to be in the property will get back into the property within a short period of time. So thank you for bringing the bill. And I think that we will probably be working on a number of these bills, and I think your language will be very helpful to us.
Thank you. And again, I commend my staff. They work very hard on this. They're the ones that have handled, the constituent cases calling in throughout the year where we've had these happen. And, Senator Sidnor, you're right. It's tough I truly feel for the person who signed that lease. They've moved in. Where are they going to go? But unfortunately, it's not theirs. And, it's the world yeah. They are. Yep. But you know what? Maybe we strengthen the penalty against that person who falsified that document and go after them and take the penalty and make the punitive damages go back to that person, the victim, and give them the money. Shouldn't go back to the state. Maybe give the victim though.
Which is the only reason which is why I asked you the question. I'm curious
again,
of other people.
We're not being adversarial. As Senator West said, it's a problem. We're trying to fix it.
Right.
We are working here as a team. I'm just bringing another idea to the table to say, hey.
No, thank you.
Senator, thank you very much. This is great.
Thank you, Mr. Chair.
We'll keep you apprised of our progress.
Yes, sir. Thank you.
All right. So that will end the hearing for Senate Bill 489. Is Senator King, I saw Senator King around here she was in the antechamber. Is she still out there? If you can hear me. If not, we're going to move to. Okay. If she's not out there, then we're going to move on to Senator. Oh, is she coming? Hey, there she is. All right. Feeling the love in JPR today. So now we have Senator King with Senate Bill 464.
Thank
Senator,
you,
welcome.
Mr. Chairman. Mr. Chairman and members of the committee, as a resident of Montgomery Village and a former member of the Montgomery Village Foundation Board of Directors, I have seen firsthand the difficulties that condominium boards face in running and maintaining condominiums. Many condominiums have provisions requiring a vote of all the residents in order to increase an annual assessment. Unfortunately, many condominium boards have found themselves in situations where even though repairs or maintenance are desperately needed, years can go by without an approved increase by the residents. This puts the entire condominium complex in jeopardy. Senate Bill 464 would allow condominium boards to enact no more than a 5% increase for common expenses, excluding reserves, even if the residents do not vote to approve, in order to fulfill the board's fiduciary duty to maintain the community. What we have found in Montgomery Village, no matter when we have an election, people just don't vote. They don't participate in the HOA voting at all. No one wants wants increases, but no one wants to live in unsafe conditions that arise when regular maintenance and repairs can't be performed. Mr. Chair and members, you should have an amendment that I have introduced that tightens up language to ensure that it is clear this is a maximum 5% increase. This legislation will help the boards in their endeavor to keep their communities safe, and I ask for a favorable report on Senate Bill 464. I have with me this afternoon Mr. Michael Conroy, who is the Executive Vice President of the Montgomery Village Foundation. He'd like to say a few words and also will answer any questions you might have.
Thank you.
Good afternoon, Chairman, members of the committee. My name is Mike Conroy. I'm the Executive Vice President of Montgomery Village Foundation, the large-scale homeowners association responsible for the planned community of Montgomery Village, as Senator King mentioned. Thank you for this opportunity to lend our support for Senate Bill 464, which will allow a board of directors of a Maryland condominium to make a 5% increase in the annual assessment in the event that unit owners do not vote to adopt the budget proposed by the board. It's often assumed that HOAs and condo associations make arbitrary rules and raise fees that produce no tangible results. But the reality is that regular maintenance, upkeep of a community, and service contracts are often the bulk of an association's expenses. And frankly, none of those things are glamorous, but they're necessary and need to be funded. These basic services, along with the funding mechanism, are part of the primary fiduciary duties of an association's volunteer board of directors. And when a board is not able to perform these duties, they're held accountable by the community. In many older condominiums in the state, master deeds, bylaws, or other governing documents contain a provision that requires a council of co-owners, or all the unit owners, to approve the annual assessment for the condominium. If the unit owners do not approve the proposed assessment, the previous year's assessment stands, and when approval is denied year after year, a board is unable to address the rising costs of material, labor, and service contracts. As a management agent for several condominiums within our planned community, MVF has experienced the deterioration of property that is caused by the failure of owners to face the reality of these rising costs firsthand. Volunteer condominium boards are elected by their owners, and they act in good faith on behalf of the owners to meet the safety and maintenance standards for their properties. SB 464 would increase the condominium board's ability to properly set annual assessments and accomplish these goals and fulfill their fiduciary duties. Therefore, MVS respectfully asks for a favorable report on SB 464. Thank you.
Questions from the committee? All right, seeing none, thank you both very much. Thank you.
Thank you, and happy birthday.
Oh, thank you. No other place I'd rather be right now. Yeah. All right. All right. We have Ms. Hyatt. You're up for favorable with amendments.
Okay. Well, thank you again. I'm a little confused about this bill, and I guess that's why I'm testifying. Right now, because of the House Bill 107, the Reserve Study Bill, gives the board unlimited power, overrides bylaws to raise fees as much as they want, which has resulted in our community 30% rise in monthly fees and assessments of $4,000 to $14,000, but in others more. So there's all that money going there. Pardon me. The result has been, there's only one pot of money, and that's the owners. So all this money has to go to the reserve study for things that may or may not go wrong 20, 30, 40 years. What has had to suffer was the operating expenses, which are every day, and they're very lean because there's only so much money. So we haven't had the experience where somebody has voted down something. I guess if a board needs it, I would be for letting them put in 5%, but I do want you to know that if the operating expense is more than the 5%, that would mean there would be a special assessment. So in the end, it kind of works out the same. I guess what I'm saying is I could be for the bill unless you can figure out another way. What really needs to happen is changes in House Bill 292 amendments so that all this money doesn't have to go there, so that operating budgets are not so lean and people can do the preventive maintenance and other things that would make it so you didn't need all these big repairs later. So I would be for this unless you can think of some sort of amendment where it can coordinate with the reserve study in some way. But I know that's a little confused, but we'll call for a special assessment if it's over 5%. Thank you.
Thank you very much. Seeing no questions from the committee, that'll conclude the hearing for Senate Bill 464. And I see Senator McCray is here, so we'll go with Senate Bill 573. Senator McCray, welcome.
Thank you, Mr. Chair. Mr. Chair, for the record, Corey McCray, represent the 45th Legislative District. I come to you in reference to Senate Bill 573. I was just skimming through the testimony for Senate Bill 573, but this bill is a very simple bill. It gives the ability for the local jurisdiction, when they're doing some level of a civil fine, to raise from $1,000 to $10,000. When I looked at the testimony, I'm not sure if they have a level of understanding. When folks illegally dump in our respective neighborhoods, there's a significant amount of work that goes into catching these respective actors, and for them to only get a $1,000 fine because the jurisdiction can only give out a $1,000 fine is pretty challenging. And that's not just from an illegal dumping from a trash standpoint. Let's say tires or different things of that nature. When we're thinking about like what is the penalty that someone could do, there's no incentive, and they'll be able to pay something like that from that local jurisdiction standpoint, and that's why we're coming to kind of lift that up. But more importantly, you have folks from the jurisdiction that will be able to explain and articulate why something like this is necessary. So I just say, please vote favorable. It looked like it was heard last year. Like I said, this is my first time putting it on before the administration. Whatever you all do come up with, I do think that we all, I hope, would agree that $1,000 for the local jurisdiction from a civil fine isn't enough to get rid of bad actors. Thank you. Please.
Yeah. Good afternoon, Mr. Chair, Mr. Vice Chair, Justin Williams, Deputy Mayor for Community and Economic Development for Baltimore City. To build on what the Senator said, you heard last term a bill for the charter counties that raised the civil cap. The city has its own special provision in our city charter, which is set by state law. So this would propose to change our city charter provision from $1,000 to $10,000. What has driven this specifically for me, because I was passionate about this, was illegal dumping in the community, Poppleton. Typically, what happened in this specific case that really pissed me off was there was 3.6 tons of tires dumped in the community. We sought criminal penalties into the criminal court process. Unfortunately, the judge imposed a fine of just $500 and community service. understandably for the judges in the criminal system, that they see bigger cases, they see drug and violent crime, and so they don't give as enough attention to the legal dumping. But as I'm sure you know, dumping, especially in communities like Baltimore, it has this crazy deleterious impact. And so the Mayor Scott noted that this slap on the wrist is a slap in the face of the community. So having the ability to do a civil citation up to $10,000 for egregious instances like illegal dumping is something we're seeking through this legislation. But noted in some of the written testimony too, there's some other kind of unique instances where we want to go higher than normal. Some of the legal banded signs like the "we buy houses" or "we buy your insulin strips" or things that are nuisances and are seen as a cost of doing business when we do catch someone getting fined. So we want the authority to go up. And of course, we need to do local legislation and the city council to change things as well. If there's any other questions, I'm happy to answer them. Otherwise, we ask for your favorable support. Thank you.
Good afternoon, Chair Smith, members of the committee. My name is Nina Themelis. I serve as Director of Government Relations for Mayor Scott in Baltimore City. As you've heard from the Deputy Mayor, right now the maximum criminal and civil penalty we can impose for any violation that happens in the city is set at $1,000, and that's in Article 2 of our city charter. That level was set back in 1982, and as mentioned, there was legislation passed last year that allowed for other counties, the charter counties to increase their maximum penalty. So all we're looking to do is to be able to address an issue that is very significant in the city of Baltimore. We have thousands upon thousands of service request responses for illegal dumping. We see a lot of concentrations of illegal dumping as well, where there are hot spots that have potentially the same actors illegally dumping in the same space over and over again. And so while they may get hit with a $1,000 penalty every once in a while, they know it's not going to be every time, and the costs associated with doing things the right way are likely going to be more than that one-time $1,000 fine whenever they are caught. So we think this is a pretty simple bill, and we hope for your support, and we would like for you to vote favorably for Senate Bill 573. And again, we're here for any questions you might have. Thank you.
All right. Thank you, Mr. Chair. Senator McCray, I actually had a bill in yesterday that, not similar, but it's centered around the same issue with a lot of this dumping and litter. And so I just want to know, from your vantage point, if you'll be supportive of my bill, which, one, allows for residents to capture this on camera, and they'll be able to split the fine. So if the fine goes up to $10,000 for illegal dumping, and somebody submits this, the video footage of the person that's dumping the tires or littering, you guys with the city would share half of the proceeds with the person who actually submitted the information. So we can start having a lot more people that's more vigilant across the state of Maryland to keep folks from dumping and littering in our communities.
Yep. I just like to say it's very prevalent. I think that it's prevalent in neighborhoods like ours, to be honest with you. And what we'll find is most of the people that's doing it don't even live in the city.
Exactly.
They're contracted. They're doing work from that standpoint. They may get and receive some level of benefit to take it to the dump, and it doesn't make it to the dump, is what you'll find a lot of times when folks are catching, neighbors are catching. I found there was a video of one of our councilmen ran down on somebody that was illegal dumping, saying, no, we're not allowing this in our respective neighborhoods. But what happens is the resources that we're putting out is way more than $1,000 when you're setting up the camera on the pole, when you're deploying the resources from the Department of Housing to be able to track the people or look through the trash to figure out like how did these type of things. There's no incentive from that piece of it. But I'd love to take a look at your legislation, which is the question. I do think that any type of incentive to where we share them with respective neighborhoods from that standpoint is always beneficial because it pours more money into the respective neighborhoods where the action is taking place. So I'm open to looking at it.
Thank you, sir.
Yes, sir.
Thank you, Mr. Chair. Senator McCray, I'm totally with you on the issue of dumping.
Yep.
But the problem with the bill is the bill amends the charter of Baltimore City, and its section of the charter is just a general provision saying the city can provide civil, criminal fines and penalties for the violation of any ordinance, rule, or regulations.
Yep.
So what the bill says is that you can increase the fines for any violation of any ordinance from $1,000 to $10,000. I'm looking at a letter from the Maryland Retailers Alliance which I find persuasive, and I wanted to read you a section and ask you to respond to it. They say, the city of Baltimore is already an expensive jurisdiction to both live and conduct business in. Between high utility costs, taxes, insurance, and security rates, many business owners must carefully weigh the desire to operate within the city against the cost of locating there. Additionally, the average business does not operate with the intent of breaking the law. Incurring a $1,000 fine for an accidental code violation without an opportunity for corrective action is already costly for small businesses that are struggling to break even. Increasing that potential fine by 900% to $10,000 would have a major impact on entities that find themselves in violation of an ordinance due to ignorance, accident, or honest mistake.
Yep.
So on the one hand, you've got what I totally support, which is the dumping. On the other hand, you got the possibility that changing the charter in this way could allow the city to really hurt small businesses in the city with fines for unintended errors of up to $10,000. So how do you respond to that?
Yep. First, I just want to thank you for lifting it up. As stated, when I gave my opening remarks, I was looking at some of the testimony that was there. I'll make sure that I have a strong conversation with those folks because that was my first time seeing that respective testimony that they gave, and I think they should have gave me the due diligence to share it with me versus just submitting it via the website.
Agree with you. We've had that problem before in this committee.
Yep. The second part that I would say is that while we isolated illegal dumping, I think that the deputy commissioner talked about the signs that's in folks' neighborhoods. When I go to neighborhoods in Baltimore County, this isn't something that's prevalent, but if you walk through a number of my neighborhoods, all of a sudden you see somebody jumping out of a car that's tackling signs up to these things, and what you see is the neighbors are the ones that's removing these. It's usually not the city, but it's the neighbors that's frustrated that it keeps happening in their neighborhood. She talked about 1982 since the last time that we looked at this, where it was $1,000, and we're in 2025 at this moment. So $1,000 over a 40-year period isn't the most incentive for them to act in the right way. I think that they're also asking for up to $10,000, so every isolated situation isn't going to be a $10,000 fine. I would say to myself, just like in Baltimore County, you're very respectful of small businesses. I want businesses to be in my jurisdiction. I want my jurisdiction to grow, so I'm not going to do things that's going to hamper that level of growth within there. But I also want businesses and I want people to be respectful of the neighborhoods that I also represent. And the fine that we have at this moment isn't suitable or incentive to do it because the incident that the issue that we bring up of illegal dumping is very prevalent. You can go on Rose Street and you'll see that between Rose and Bel Air Road and Milton Avenue, we'll come and clean it up and it'll be right back there 2-3 days from now. And sometimes we do catch the actors because we'll have 3 cameras on there, but it's still happening. We'll find them and it's not that incentive for them to change that level of behavior.
Great. Thank you for your answer.
Yep.
I was just going to ask you a similar question because the premise of the bill is to address dumping, and I assume that you all. I don't know if I'm not a.
It's a multitude. We just selected that as one of the issues.
Got it. Gotcha. That was my question. Were you trying to address dumping? Because if not, like, I assume you made that blanket decision to cover all ordinance violations.
I would say all ordinance violations, but like I'm. No one in here would characterize me as a person that think of penalty, penalty, penalty. The thing that I think about is the folks that are coming, and when a councilman runs down on somebody that's illegal dumping, we do not know if they have a gun, we do not know what they're walking into, but you can see the level of frustration that's taking place with leaders in that respective neighborhood and folks that's coming in and don't have that. So I'm not a person that's been over penalized from that standpoint. I just say that it's very out of control with a number of the different subjects that the jurisdiction do have power for. He keep jumping up the.
If I may also, Mr. Chair.
Please come.
You can come on up to the podium.
May also, just to build on what the senator was saying, the impetus from my perspective, working with the mayor preparing for this term to raise the cap, dumping was the motivation, but then in thinking about other things, just came to mind the signage issue. The abandoned signs are a big problem from Baltimore, where the fine does not serve as a deterrent to people who just do the work. It's kind of the cost of doing business when we catch some of these people. There's also the issue like unlicensed vending, which is a repeat thing where we only charge $1,000, but a food truck who doesn't do the right thing only can get slapped with a $500 fine. So the thinking was allowing the charter to have up to $10,000 to allow some flexibility. Ultimately, on every single fine we want to impose, the city council will have to pass separate ordinance to decide which, I guess, violation would require or would impose that fine. So I don't foresee a situation where a fine for a business that doing business activities that are kind of customary, that a broken window or graffiti would be anywhere close to $10,000.
It's enabling legislation for the city of Baltimore. So if you'll have get a delegation letter, we'll go to work on it.
Yes, sir.
All right, appreciate it.
Thank you
All
all.
right, thanks. Thank you. All right, with that, that'll end the hearing for Senate Bill 573. We'll now move on to Senator Reedy with Senate Bill 556.
Thank you, Mr. Chairman, and members of the Judicial Proceedings Committee. It's good to be before you again, Senator Justin Reedy, here to present an issue that I think you've heard something about and have real concerns about. A number of our constituents I know have reached out to us in the past. Last session, we were discussing the governor's housing bill, and around that time, a lot of news had been breaking nationally about issues with squatters in taking over people's homes and either overstaying a lease or in some cases, preying on someone's charity and then not leaving. Other situations, including ones in Maryland where someone perhaps lives in Florida part of the year and then comes back and discovers someone's in their home. And in some of the other places in our country, there were some states and cities that really made it to where after 30 days or 60 days, someone could claim that they owned your home, and it was actually really hard to prove that they didn't. Maryland's law in respect to a property actually changing hands is pretty strong. You'd have to have basically abandoned your home for 7 years for someone to, and somebody would have had to have been living there for 7 years for someone to really claim ownership. However, and the problem I pointed out on the floor of the Senate with an amendment that I really brought up for discussion purposes was the challenge is you could have someone who has a squatter in their home, and they go through the process of trying to get them out. But even if they're completely in the right, and it's clear that there's no question about somebody, maybe a lease dispute or anything, could still take a couple months to get them, in the best of scenarios, to get them into court and out of your home. And a lot of the way the law works, it protects the squatter because we do want to protect tenants that are legal tenants from being from trouble, but the laws can be used against rightful homeowners and on behalf of folks who are breaking the law and occupying property. So, as amended, Senate Bill 556 would prohibit the knowing and willful presentation of false documents in order to possess real property. It would prohibit a person from leasing a real property that person does not own or is not authorized, obviously, to lease. It would prohibit someone from listing or advertising for sale real property if the person knows that the purported seller is not the owner of the property. And importantly, this bill would authorize the owner of residential property or the owner's agent to request that a sheriff return possession of residential property to the owner under some spelled out certain circumstances. The sheriff would be required to serve notice immediately to vacate the property to an unlawful occupant and return possession of the property to the owner. The sheriff would have the authority to arrest individuals while allowing an individual who is perhaps, if it's done in error and harmed by that wrongful removal, they would be able to recover treble damages. So there's a protection if in the case of someone being removed inaccurately or wrongly to receive compensation. So we do still have a protection there. The legislation would also establish that an owner is not liable to an unlawful occupant of residential property for damage or destruction or loss of certain personal property when they're being removed. And the sheriff is not liable to any party for damages to property resulting from the removal of an unlawful occupant from a residential property. Now, there are amendments we've submitted to the committee from the Maryland Multi-Housing Association, which the original draft of the bill, and another state has done this, and the criminal penalties were pretty high, so we actually took some of the criminal penalties down a little bit and made a couple of other tweaks. We also want to be sure in whatever we do this session, I know, Mr. Chairman, that if someone rents a property not knowing that they've rented with a false lease, we don't want them to be penalized if when they can show that they rented in good faith, they still will need to leave the property. But we also we're not going after those people. We're going after the people who intentionally would deceive someone into renting a property under false pretenses. So, Mr. Chairman, what I would say is, and I would call your attention, there was a witness that we had from Anne Arundel County who could not be here today because of a surgery. Her name's Rebecca Boykin, but she has a very harrowing and really awful story about what happened to her and her family in their family home. And it's a lengthy testimony. I'm certainly not going to read the whole testimony. But essentially, she was preyed upon by someone who, a couple that was using other people in this regard. And even she got wise to what was going on, letting people stay in her home. They didn't want to leave. She became wise to what was going on. She got legal help. She didn't have a lease, so there was never a lease, but she got legal help. But even once she was clear to everybody involved that these people were defrauding her and staying at her property illegally, it still took, it took 3 months to get a court date to be in court. And then they were told that even if the court found in their favor, it was during the holidays. And oftentimes it's difficult. Law enforcement doesn't always want to remove during the holidays. That's what she was told. Now, I'm not speaking for law enforcement on that. My point is she suffered tremendous physical and emotional damage. And so I just encourage you, if you have a moment, to read that testimony as you look at the bill file. I think it really underscores why we want to take action this session. I also know there are other folks who've brought legislation forward. I believe this is a very strong way to go about it, to say we're not going to have any tolerance for this kind of illegal activity with some appropriate safeguards if someone becomes overzealous. But I also willing to work with the committee, of course, on whatever we want to do. But I think we'd like to kind of close what I would look at as a bit of a loophole in our law. Again, for the public that might be listening or anybody that covers this, the good news is we don't have the situation where people could actually lose their title or deed to their property quickly. But this kind of stuff is it's not right. And so hopefully we can work together and try to bring an end to this kind of activity as much as possible. Mr. Chairman, I believe we have witnesses. Oh, please, yes, come on up.
Good afternoon, Mr. Chair, good afternoon, Chair, and members of the committee. Here, Ashley, here again on behalf of the Maryland Multi-Housing Association, along with my colleague, Matt Pipkin. And we just really want to thank Senator Reedy for meeting with us, and he discussed the amendments, and we're really just echoing his testimony in support with those amendments he did discuss with you. We also did have conversations with Senator Jennings and Senator Watson, who are also on board in trying to get this legislation passed, because we know this is something that's very important. There's a lot of legislation regarding squatters, and so we think that this bill is the most comprehensive of the ones that have been presented so far. And Senator Sidnor, to kind of speak to your concern with there being 2 victims, Senator Reedy's bill does address, at least in this bill, unlike the others, that you do have the conversation with that person and saying, we're asking for you to vacate our property. And so there is some form of notice that we kind of haven't seen in some of the other legislation. So we are asking for a favorable report with amendment. Thank you.
Good afternoon, Mr. Chair. I apologize. I left my birthday cake for you at home. Happy birthday to you. I'm Matt Pipkin. I'm here on behalf of the Maryland Multi-Housing Association. I'll simply just say me too. I'm very happy to take any questions and work with the committee on getting something through.
Excellent. All right. Do we have virtual guests? Susan Malone? Okay. And then Matthew Pipkin, which you just said, and Robert Slade. Mr. Slade, welcome.
Hello. My name is Robert Slade. First, I'd like to thank the chairman and the committee members for allowing me a few minutes to address the committee about my thoughts and concerns about Senate Bill 556, addressing fraudulent possession and unauthorized lease, or listing of real property. I reside in District 42, Senator West District. I described in my written testimony the incident that opened my eyes about how limited a property owner's recourse is regarding fraudulent listing and ultimately fraudulent sale of real property. All the information needed to conduct this fraudulent activity is available online, from deed information to information on tax information on SDAT. I think this may be a situation where regulation may not have kept up with the technology. Sadly, there's some people will figure out how to enrich themselves. People will figure out how to enrich themselves through fraud at the expense of hardworking Marylanders. My wife and I found out this ordeal. There's little to protect property owners from fraudulent possession of real estate. Though our ordeal did not involve the leasing, I know sadly that's becoming more of a problem too, and I'm supportive of the component of the legislation that involves leases too. I learned a lot about the fraudulent listing and potential sale of real estate from someone other than the actual owner during my ordeal. Though my crisis occurred in Carroll County, I learned this occurs more frequently in urban counties. The only change I would kindly request is that you remove the word residential, so it'll be clear that this bill would include all kinds of fraudulent activity of real property, including building lots, farms, especially with multi-parcel deeds, which may be easier for a fraudster to latch onto. Again, I would like to thank you for taking time to address this very important issue, and thank you for reading my written testimony that goes into detail. And please, you feel free to contact me if you have any questions. Thank you.
Excellent. Thank you very much, Mr. Slade. Questions from the committee? Senator West.
Thank you, Mr. Chair. It really isn't a question. It struck me how prevalent this practice must be. My father's best friend was a fellow named Bill Boykin, and Bill Boykin was the father of Rebecca Boykin. So I've known Rebecca Boykin since I was a child. And the fact that an old childhood friend would have suffered this kind of disastrous situation just shows that this is not an isolated situation. It strikes into a lot of our houses. So thank you for bringing the bill.
And I would definitely encourage folks to realize that it involves building lots and farmers with like multi-parcel deeds. It's pretty scary.
Excellent. Thank you for that.
Thank you.
Further questions? All right. Thank you all very much. Thank you, Senator. Thanks, sir. Thanks. So now I'll switch to the opposition panel, and we'll start off with Anthony Rodriguez. John Kern, Elizabeth Hilliard. Are you coming up for this one? And is Unika Namdi? She's still, there you are. Whoever would like to start. Yes.
Good afternoon, Chairman and Vice Chairman and committee members. My name is Anthony Rodriguez. I'm a volunteer attorney with Shore Legal Access on the Eastern Shore. Shore Legal Access provides free legal services to individuals who cannot afford an attorney. And I'm here to testify on behalf of Shore Legal Access and the clients we represent in rent court in the 8 counties on the Eastern Shore. We oppose this legislation because we don't think it's necessary, and it undercuts existing protections for tenants under Maryland's wrongful detainer law. This legislation also has the potential to burden local sheriff's offices with administrative and adjudicative responsibilities by injecting their offices into the process of deciding legal rights of citizens, including tenants, regarding possession of property. This role is currently carried out by local district court judges, and we see no reason or data that would support changing the existing process and moving those responsibilities to local sheriff's offices versus judges. We have represented several clients under Maryland's wrongful detainer statute, and the process works when judges decide whether occupants of real property have legal rights to remain on the property. In one example, we had a case where a client, similar to the descriptions earlier, who was scammed but when she rented a house for 11 months from someone who purported to be an agent for the property owner, and actually had our client sign a lease that was fraudulent. Eventually, the actual owner filed a wrongful detainer action. Our client, who was the tenant at that time, brought the matter to our attention, and we were able to help her through the wrongful detainer action and assist her in resolving the matter and moving out from the premises. The process worked with her in terms of protecting her rights to due process and the ability to defend the action that was taken against her. And we think it's important that those due process rights continue to be afforded to tenants like our clients. We therefore oppose this legislation and urge the committee to vote unfavorably on it. Thank you.
Sure. Thank you, Mr. Chair. Happy birthday. Greetings, committee members. My name is John Kern. I work for a housing equity nonprofit in Baltimore City. And we help homeowners that are facing myriad issues with their properties, one of which is foreclosure because of failure to pay ground rent. And I know ground rent has come before the committee over the years, and I won't bore you with all the details about what ground rent is and what it's all about. But as you can imagine, despite our best efforts, folks are still getting caught up in ground rent foreclosure to failure to pay. It's not a lot of money. Oftentimes they're not able to pay because the management companies that actually accept the payments can change. They don't know where to send their payments. So long story short is they get caught up in this, and they get sent to us. We actually receive some money to help homeowners through the foreclosure process, and sometimes we were able to pay to stop the foreclosures. But if not, our concern, of course, and I appreciate Senator Reedy's concern about homeowners being treated in negative ways. It's funny, we're on the inverse of that, where effectively homeowners are then turned into squatters. So now here they are getting essentially evicted from their homes because of failure to pay ground rent. And I would agree with my colleague on the left from Shore Legal Access, which is that we appreciate all of the protections that are in place for them and would hate to see that those homeowners, because of failure to pay ground rent, would then be treated as squatters and be referred directly to the sheriff's office. So we would actually encourage an unfavorable on this bill. Thanks so much.
Good afternoon. My name is Nika Namdi. I'm the Executive Director of the SOS Fund, and I'm also the Founder and Chief Operating Officer of Fight Like Be More. And we're here we are here asking for an unfavorable report on Senate Bill 556 for a similar reason that Mr. Kern just spoke to. We also do work surrounding tax sale foreclosure. And in a case where someone has experienced a tax sale foreclosure, we could see how lien purchasers or their attorneys would use this law to avoid having to go through the due process of housing court and then just summarily call the sheriff to have people evicted as a result of tax sale foreclosure. The other piece is the bill does speak to protections in terms of folks being able to, if it is found that they were evicted improperly, that they could receive funds back. Just noting that access to legal counsel for many of these families is prohibitive in terms of the cost. Most attorneys don't take these kind of cases because of the small awards, and the pro bono legal services in much of Maryland aren't able to take cases with affirmative claims. So therefore, that if someone is evicted wrongfully in a case like this, whether it is a ground rent case, whether it is a tax sale case, or whether it is a case where someone has signed a fraudulent lease without their knowledge, it is not as easy as one would think to just go and get an attorney and bring this kind of case in front of the judiciary in order to get your funds back. And so we encourage you all to not issue a favorable report on Senate Bill 556, and I'm happy to take any questions. Thank you.
All right,
Thank you. Good afternoon, Chairman. Happy birthday. Vice Chair, members of the committee. I'm Elizabeth Hilliard with the Office of the Public Defender, and we are also urging an unfavorable report on Senate Bill 556. I don't often get the privilege of sharing the stories of victims, but in this case I do, because we work with individuals before they are system involved to try to prevent their system involvement. And although their stories are not unique, I have the privilege of sharing the stories of two individuals who were the victims of a scheme that they thought they were paying rent to the actual owner of the property, but they in fact were not. And under the way that the bill is currently written, they would be subjected to immediately being removed from their house, no resources, no judicial process, and no due process in place. The first was a family that was evicted after having been paying rent for months. The actual owners had not been receiving their rent and did not know that the space was being occupied. The family was comprised of a young mother with two very young children, and they were living with their live-in boyfriend. The boyfriend was working, but the mom was not. She was staying home to care for the children. And them being evicted actually resulted in him losing his job, and the mom and the two children had to leave the state to relocate with her family. The second story we have was actually a disabled mother who had two disabled children that she was trying to secure housing for. When she finally did secure housing, she had a first name and a phone number for the landlord, but that was it. She started paying rent on a property she thought she had ownership of or the right to occupy, and only found out after the process of a wrongful detainer was brought that she actually did not have right to the property. Thanks.
Excellent. Thank you very much. Questions from the committee. Senator Muse.
For whoever. And I agree with Senator West. This is a really tough one, because you got maybe a family in the house, and they excited about their new house, and they went about it in their mind the right way. There is a concern for them, but there's also a concern for the person who says, that's my house. And right now in the court system, it could take months before this is adjudicated and comes before court, right? Would you, and yet this bill says immediately. I don't know the answer to that, but if your reason for opposing it is because of the word immediately, what would be a timetable for you other than 7, 8, 9 months in court? And in Prince George's County, it'd be forever. Because that family's sitting out there saying, oh my God, this is my house and there's nothing that my county can do to remove someone. This is just a real tough thing to deal with.
Thank you for that question.
I don't know the answer, so I'm looking for answers.
And this is just speaking from the Office of the Public Defender. I'm happy to let the other panelists also respond. But we do not think that there can be a fair process of removal without due process. And a sheriff providing notice is not sufficient due process.
Okay.
And so if there needs to be an expedited court process, that is something that could be considered. But right now, what this is going to do is problem shift as opposed to problem solve. We are going to increase the number of families and individuals who are houseless, and then perpetuate this problem of people falling prey to schemes and fraud because they're desperate to find housing. So without a judicial oversight piece, we would oppose the bill.
Okay, and yet again, is there something in the bill that we can say, and I hate putting, the people who own the house and say, okay, we'll expedite it, and that goes from 7 months to 2 months. I mean, what would they do? But what would do any of you have any kind of compromise or anything that would be fair to both?
I think that one thing that we've heard over and over again is that the housing or rent court doesn't have the resources necessary to address these concerns in a more speedy manner. So I think one thing is to boost up the judiciary's ability to handle the amount of these types of cases that are coming through. But barring that, if we all, I think, would feel like it is unfair to people who are facing these issues to be summarily evicted and also exposed, I want to be very clear, exposed to interaction with the sheriff in a way that could result in some other criminal charges. Because to be honest, if you show up at my door and ask me and tell me I have to leave, there could be some issue, right? And I'm what people would consider to be a reasonable person. So I think the state, if this is the direction that the state wants to go, then the state should bear the responsibility for housing people that are victim both to fraud, but also those that have been victim to a tax sale foreclosure or to a ground rent foreclosure. Thank you.
Thank you all very much.
Ms. Elizabeth. Thank you, Mr. Chair. In that story, which is very unfortunate, it still wasn't their house, correct?
Well, they were paying rent on it. They thought they were lawful tenants.
But it wasn't their house. And so I understand the story, and I do feel bad for them. But shouldn't we be then addressing that somewhere else? The other young lady had said something about the state's responsibility to pick that up. It's almost like that the testimony is kind of conflating the two issues. And I'm just having a hard time seeing the difference. If I own the house, then I should be able to take possession of it regardless of somebody else committing fraud and then putting a victim. And look, I understand the victim is that's why they're a victim. I just don't understand why the first infraction is that they don't own the house. So I don't understand why we can't have a process where somebody can get their property back. And to me, saying that they thought that was there, they were in fraud, should not have to do it. They seem to be two different issues.
If I may ask a clarifying question, I apologize. Is the fact that someone is a renter as opposed to a homeowner an evictable offense? Like, are you suggesting that that should be the basis for the
No, I'm saying
removal?
that the victim is the person who was perpetrated by somebody who said, I own this house, I'm going to give you a contract, you're going to pay for that rent, but doesn't have anything to do with the ownership of the house. Why does the person who actually owns the house have to bear multiple days, whatever this other process, when this bill addresses that issue? And I think there's some other stuff that takes into consideration to discourage somebody from trying to take advantage of these tenants. So the victim part is the tenant, not the landlord, not the owner of the house.
Okay.
Okay? But I just don't understand why the tenant who believes they're the tenant should have protections that the owner of the property, they just want their property back. They didn't have anything to do with the scheme. They didn't have anything to do with it.
Neither did the tenant in the cases where they're being.
Actually, the tenant did, because regardless of somebody committing fraud, they're the ones that went into that agreement. Now, it was fraudulent, but to say that they are at the same level of responsibility that, say, the person who actually owns the house, I don't believe that's on the same level playing field.
Real property article 14101 does have the wrongful detainer process already in place, and that does protect the property owner. To me, the issue that is arising in these cases, as Senator Muse pointed out, is the delay. And I think that trying to expedite the eviction of individuals without judicial process is the crux of our issue with this particular solution. If there was a solution proposed that would address the delay but would not result in people being houseless without any due process, then I think we would be happy to come to the table and have a conversation about this. There are already many, many criminal laws that exist for, the individuals who are fraudulently putting out the property as their own. And deterrence works best with swiftness and certainty of conviction. So pursuing the individuals under the existing counterfeit statutes, fraud statutes. Actually, I think Chairman Klippinger pointed out there is already an existing piece of the burglary statute that may even apply. Pursuing those remedies for the people who are wrongfully holding out the property is something that should be considered. It shouldn't be further legislated to approve an expedited eviction process for people who are often victims themselves.
I think now I'm completely confused, and now I think that
Perfect, then I did my job.
The person who actually owns the house is the victim, not necessarily somebody who has gone in unwillingly. And so I just don't understand where one victim's right trumps another. And we could discuss this later. It's not worth the time. So thank you.
Further questions from the committee? All right, seeing none, thank you all very much. We'll move on to the next tranche of opposition panelists with Catherine Davis and Matt Hill and Joseph Lovelace. And then we have Emily Towie joining us virtually.
Good afternoon, Mr. Chair, members of the committee. My name is Matt Hill. I'm an attorney at the Public Justice Center, which is a part of Renters United Maryland, which strongly opposes SB 556 because it violates constitutional due process, will increase homelessness, and increase the potential for violent confrontations with law enforcement. I want to skip straight to what Senator McKay was asking about. Last time we talked a lot about fraudulent rentals and fraudulent schemes, and I know there's a lot of testimony about that today, but these actions are oftentimes deliberate. We have property owners who are preying on tenants, and after that hearing that we had a couple weeks ago, my office got exactly that kind of case. It was a Thursday afternoon. 7 elderly and or disabled residents contacted our office because they had an eviction scheduled for Tuesday in a wrongful detainer case. The owner, the landlord, had recently purchased the property. He knew that there were renters living in the property, but thought that because they weren't his renters, because he just bought it, that he could file a wrongful detainer. Again, all these clients were elderly disabled. The case was addressed to all occupants, but for whatever reason, it didn't get to my clients until they got that notice of eviction that they were going to be put out in less than a week. So we got involved. We got the court to stay the eviction through an emergency motion. The problem with SB 556 is it takes the court out of that process. It makes the sheriff totally responsible. Who are we going to file an emergency motion with? The sheriff? We're going to make the sheriff the arbiter of whether or not somebody is going to be evicted or not? They are not equipped, or nor is that their role in our process. For these reasons, the Attorney General's office in their written testimony says that this bill is unconstitutional. It's a violation of due process. So it's not just fraudulent schemes that are at issue here. I think, too, your one more point, Senator McKay, is that we don't have any data that addresses this issue. How could wrongful detainer work better? I suggest a work group in which the committee addresses questions like, how long does it take to get from complaint to trial, from trial to eviction? What are some of the best practices? How can we fix wrongful detainer rather than just scrapping the court? Thank you.
Data. And so I'd like to see what the data is that we actually have these issues. And then in your case, how many clients are you having to defend for this compared to how many actual situations are being reported in the state of Maryland. So
I agree, Senator. And I think the best practices could also include, to Senator Muse's point, how do we then assist people who have been victims of fraudulent schemes in this way? Is there some relocation fund that can be used? Could the court be empowered to stay an eviction in order to allow for that relocation to take place? All these are really important questions, and this committee is operating in a total vacuum of information. Thank you.
Good afternoon, Chairman and members of the committee. Thank you for letting me be here. I'm Katie Davis. I direct the Courtroom Advocacy Project with PBRC. We provide free representation to low-income tenants facing eviction. We sympathize with the situations that have been talked about here today, but are opposing this bill. And I'm going to jump right to, we have many reasons in our written testimony, but I'm going to jump right to unintended consequences, much like what my colleagues have said already. We frequently accept cases that are filed as wrongful detainers despite the existence of a landlord-tenant relationship. Most are either dismissed or settled. Under this bill, all of them would result in eviction. I'm going to highlight just a few of these that we've had just in the last 3 months. I can tell you our numbers that we have of these. They're more than you would think. Typically, our clients have a lease but need help proving it. Often the relationship with the landlord is rough already, and they're already trying to leave when they come to us. In one case, our client had been paying rent to her aunt for 4 years while caring for her elderly father, who was the owner's brother. 3 weeks after her father died, the aunt filed a wrongful detainer against her. We took the case to trial and won, giving our client time to continue her search for better housing. Under this bill, she would have been evicted within days, way before she could have contacted us. Similarly, we represented a tenant who worked as the maintenance man for his rental property. He was terminated from his job and immediately received a wrongful detainer action. We resolved the case through a stipulated dismissal that required him to move out within 3 weeks. Still, lots more time than he would have had under this bill. Yet another case involved a refugee family with 7 children. They also had a lease, but would have had a hard time finding it within the few days allotted under Senate Bill 556 and would have been rendered homeless. We negotiated a stipulated dismissal in that case that gave them 2 months to find alternate housing. So eviction is a legitimate means for allowing owners to regain their property, but families have a right to due process, and we can't circumvent that way. So we need to enact legislative schemes that promote those. We urge an unfavorable report on this bill. Thank you. Yeah.
Any knowledge as to maybe through National Conference of State Legislators, which we'll look into, but any knowledge of what other states have done that may come close to where we are, because every state has this problem?
I don't have that data. I think it would be great to find because, as you say, every state, I'm sure, does have that problem. And it would be interesting to see what they've done. I don't know. Maybe some of my colleagues know what they've done.
That's fair. Thank you. Thank you.
Thanks.
May I address that question, Mr. Chair?
Please. Oh, I'm sorry.
Senator Muse, just briefly, so some states are taking action on this. I think that they're reforming the wrongful detainer process. Other states are taking a bill similar to what's been provided in SB 556, and this bill mirrors almost exactly a bill put forward by the American Legislative Exchange Council, or ALEC, which is a very conservative right-wing think tank that has been successful in passing this legislation in Alabama, Tennessee, Florida, Georgia, and West Virginia. And we urge Maryland not to follow suit in what those states are doing.
Okay. Thank you. Wow.
Good afternoon, members of the committee. My name is Joseph Lovelace. I'm a staff attorney with Maryland Legal Aid, and we urge an unfavorable report on this bill. And the sort of easiest way to explain why is while this bill is intended to tackle a very specific problem, it only tackles the scammer and the victim. It doesn't actually tackle the scam. The reality is, for most renters, it's an opaque minefield trying to find, if you wanted to know who actually owns the property that I'm trying to rent, is the property management company that holds itself out as authorized to rent, are they? There's no way to know. There is no clearinghouse to get that information. What we have proposed in our written testimony is what we described as a holistic solution, that we would create a centralized database where all properties set for rent would be publicly available so that you would be able to see where these properties are located, who is owned it, and who does the owner designate as their respective agent. Because right now, there's no way to find that information. It doesn't exist. It's not publicly available in the record. We would require that all rental property operators and managers be licensed so that we can monitor their performance, and we would ask that all tenancies have a written lease. And what's important here too is we should add in our lease requirements that the owners sign off, because what we've seen is that property owners change. It's a commodity for certain investors. They change all the time. Under Maryland law, if a property that you are renting is purchased by someone else, you're still a tenant. The new owner steps in the place of the previous owner. It's just like a new foot in a new shoe. There is no way to trace your lease between owners. If your owner changes several times, you might have the original owner on your lease. I've seen leases with no reference to the owner at all. So we'd urge an unfavorable for this bill for all of the reasons that have been stated thus far. Thank you.
Excellent. Thank you very much. Questions from the committee? All right, we're going to go switch to our virtual panelist. Emily, Ms. Towie, welcome.
Thank you. Good afternoon, Chairman Smith and committee members, and happy birthday, Mr. Chair. Thank you for giving me the opportunity to speak today. My name is Emily Towie, and I'm speaking on behalf of the Montgomery County Renters Alliance as one of our outreach coordinators. The Renters Alliance is Maryland's first and only regional nonprofit dedicated exclusively to renter outreach, education, organizing, and advocacy. Since our founding in 2010, the Renters Alliance has been an unwavering advocate for expanding and strengthening renter protections. Our mission to help renters directly contradicts Senate Bill 556 and its intention to deny tenants their constitutional right to defend themselves before a court when they are in danger of losing their property. The Renters Alliance strongly opposes Senate Bill 556 because it enables property owners to circumvent due process eviction procedures, leaving tenants vulnerable to unjust removals from their homes. Senate Bill 556 further perpetuates uneven power dynamics between landlords and tenants by allowing property owners to simply submit a written request to the sheriff for an immediate eviction of someone they claim is not the lawful tenant, without ever having to step foot in court to prove their accusation to be true. We are unfortunately very familiar with bad actors' efforts to diminish renters' rights and disrupt stable housing. Residents of rental housing already face a lack of due process without good cause eviction protections. Landlords are currently allowed to non-renew any tenant, which is 60 days notice, and they do not have to provide a reason for the request to vacate. If Senate Bill 556 were to pass, landlords' unchecked power would only grow, as then they could legally skip the process of filing and appearing in court to present the facts to a judge and can instead escalate to having the sheriff forcibly remove the tenant. We too often see predatory landlords abuse the lack of good cause protections to constructively evict tenants who complain about unsafe conditions and not receiving the services that they pay for and entitled to. We caution that Senate Bill 556 will be another protected avenue for predatory landlords to evict tenants who they do not like. And for those reasons, we urge an unfavorable report. Thank you so much for your time.
Excellent. Thank you very much, Ms. Towie. Questions from the committee? All right, seeing none. Thank you very much. Good to see you. Have a good one.
Thank you. You too.
All right, with that, that'll end the hearing for 556. Thanks, Senator Reedy. All right, we're now going to move on to Senator Muse, Senate Bill 484.
Thank you. This should be a quick bill, if there's such a thing. Thank you, Mr. Chairman. I said happy birthday, and I missed the party, but I did get my cupcakes. Members of the Senate Judicial Proceedings Committee. For the record, I'm Senator C. Anthony Muse, representing the 26th Legislative District of Prince George's County. I have a sponsor panel with me, which includes Matt Hill, Public Justice Center, Mark Council, Healthcare for the Homeless, Jesse Rabinowitz, Rabinowitz, okay, National Homelessness Law Center, and Dave Prater, Office of the AG. Senate Bill 484 will protect unhoused individuals from crimination for basic survival activities such as sitting, sleeping, eating, protecting themselves in public spaces. As you know, to criminalize homelessness does not address the root cause and only perpetuates further hardships. In fact, it adds to the burden on the state and communities. It's both, in my opinion, it's immoral, counterproductive to punish people and even send them to jail for simply existing in public while they are denied access to adequate housing. I think I said to you all early, we have bills that say you can't get an apartment or a rental, and you can't have a place to live because of, for example, your record. And on the other hand, if you're homeless, you can't sleep in a park, and that's what this bill deals with, areas like that. We have a current housing crisis in Maryland anyway. Maryland faces a severe shortage of affordable housing. The lack of shelter space forces individuals, especially vulnerable groups, to make unsafe choices, escalating risks to their physical safety and well-being. I'm going to let my panel address the statistical specifics of this bill, but if you criminalize being homeless, it's just like, you know, on one day we try to say we need less, you know, we need to do something to deal with the overcrowding jail population, so we'll do something there. Then on the other hand, we'll make a, you know, I know what the Supreme Court did, we make another law that says, but now we have a new group of people, and this can never, ever handle the problem that we deal with in Maryland. In my opinion, and I don't need to repeat it because you all know my story, in my opinion, it is just cruel to say when I slept in the park, when I had nowhere to sleep, it was just cruel for somebody to come along and just arrest me. When I was homeless, I had a friend who looked out for me. He was a lawyer. He was homeless. He was a lawyer who had a nervous breakdown because of his family situation. He lost his job, drank a lot, ended up homeless. All of these people are not folks that we sometimes think about when we think about homeless. They're people with stories, they're people with lives, they're people who had unfortunate things happen, and I just don't think criminalizing that is the way to go. Now, we do have some amendments that, you know, that have come in. I think the Attorney General has some amendments. We'll talk about that. I'm willing to amend the bill as we can, but the basic point of this is that we cannot be a state that will begin to round up homeless people and take them to jail. That just can't happen. So I urge a favorable report on this, and I'm willing to work with the committee and anyone else to make sure that we can somehow find common ground, but do not let this be the case in Maryland. Thank you very much for. Okay. So, man, you want to go on? Whatever he says. How you want us? Okay.
Okay. Thank you. Thank you for your time. Allow me to be here. My name is Mark Council. I'm sorry, I'm on the board of directors and Consumer Relations Committee of Healthcare for the Homeless. I want to thank you for strongly supporting this bill. Let you know that housing saves lives. I have seen what happened to people who have lived in the streets and either be forced on to live on have been threatened to be charged with criminal crime. For instance, that we had Park Dell in Wyman Park, Baltimore, Maryland, where people was not communicating well with the city. Some of them had said that the city was not communicating at all with them, where there's some of the valuable things have been thrown away due to the lack of communication with the city. The encampment was supposed to be cleared out March 6, 2024 of last year. The city came 2 days early, March 4th, 2024, with their properties and possessions been thrown away at that time, and they didn't have no means of how to get those things back. We can't keep going criminalizing people. Criminalizing people is never the answer to homelessness. Housing, health care, and dignity and justice is what we need for homeless. People often sometimes live outside because they have no other options, The shelter is unsafe. There are things, there are abuse, conditions, and the landlords take advantage of people living on the streets, living in the housing and every place else. We ask you to please pass this bill. Housing is not the answer. Homeless is not the answer. I'm sorry, housing solve homelessness. Housing solve homelessness. Thank you.
Senator Smith and members of the committee, thank you for the opportunity to testify before you today. My name is Jesse Rabinowitz, and I am here on behalf of the National Homelessness Law Center. We proudly support Senate Bill 484, the Unhoused Individuals' Rights, Civil Actions, and Affirmative Defense Act. My testimony focuses on the national context behind this bill and the important role that Maryland can play in protecting the rights of our unhoused neighbors. Everybody needs a safe place to live. Unfortunately, instead of focusing on real solutions like housing and services, over 150 cities have passed harmful, expensive, and counterproductive anti-homeless laws over the past 7 months. The swath of anti-homeless laws began in June when the Supreme Court ruled in the historic Johnson versus Grants Pass case that cities can arrest, jail, ticket, and fine people for sleeping outside, even if they have nowhere else to go. I saw firsthand as a social worker doing homeless street outreach just how expensive and harmful taking a punitive approach to homelessness is. Clients had their documents and life-saving medication thrown away. People were uprooted from their communities and cycled through jails and prisons. Tax dollars were wasted on policing that should have been used for housing. Using jails and fines is the most expensive and least effective approach to homelessness. It just does not work. But Maryland can show there is another way. Amidst the harmful creep of anti-homeless laws, states across the country are introducing legislation that will restore the basic rights gutted by the Supreme Court. These laws have been introduced in Virginia, Illinois, Connecticut, and Massachusetts, with more introductions expected any day. Maryland can join in this growing chorus by passing Senate Bill 484 and ensuring that Marylanders who cannot afford housing are not ticketed or arrested for simply trying to survive outside when they have nowhere else to go. Maryland can show that housing is the solution to homelessness, not handcuffs. And according to our research, there is broad bipartisan support for this and similar bills. 72% of adults reject the use of fines, jails, and tickets for people sleeping outside. Not arresting or ticketing people for sleeping outside when they have nowhere else to go is a vital first step, but more must be done. The leading cause of homelessness is a growing lack of housing that people can afford. In Maryland, a worker earning minimum wage needs to work 82 hours a week to afford a modest one-bedroom apartment. This will not be solved by putting people in jail or giving them fines. The only solution to homelessness is ensuring that everybody, regardless of race, class, or income, has a safe place to live. By passing Senate Bill 484, Maryland can take an important first step towards solving homelessness.
Excellent. Thank you very much.
Thank you again, Mr. Chair, Mr. Vice Chair, members of the committee, Matt Hill at Public Justice Center. And we, as a nation state, know how to solve the crisis of homelessness. It's with affordable housing. We've seen this with the 55% decline in veteran homelessness since 2010. The federal government made a significant investment in helping folks who are veterans to not be homeless, providing housing first and wraparound services, and that's the kind of decline that we've seen, and so we know it's possible, but the answer again is housing, and as my colleague said, not handcuffs. I lost an eviction case a few months ago, and my client ended up becoming homeless. She was sleeping in her car. She didn't need to be arrested or hustled off to another parking lot because she wasn't allowed to sleep in her car in the parking lot she was in. What she needed was affordable housing. And that's all this bill asks, is that before any law enforcement action takes place, there's an individualized assessment regarding whether that person has been offered adequate indoor shelter. Is this not the least that we can do for our brothers and sisters who have been dispossessed of even the smallest piece of earth? If we say that housing is a human right, this bill is foundational to making sure that's not just a slogan. On the cost piece, I know there's a fiscal note. I think, again, to my colleague's point, putting people in jail, arresting them, much more expensive than making sure someone has housing. When someone is homeless, the emergency room becomes their primary care doctor. That's paid for usually by Medicaid, which is then paid for by all of us. Much more expensive than making someone in jail. Kids, when they are homeless, they have to be bused, if they want to be, to their old school. Extremely expensive for local jurisdictions. Those kids then don't get the quality education they deserve, they don't get the jobs they deserve, and then they're not paying the taxes that then fund all the services we rely on. Again, long-term, extremely expensive. Thank you.
Good afternoon, Mr. Chairman, members of the committee. My name is David Prater. I'm an Assistant Attorney General in the Civil Rights Division. The Attorney General supports SB 484 with amendments. Just briefly, that amendment would remove the Attorney General's authority to enforce the provisions of this bill. We believe jurisdictions and municipalities will comply with in good faith with the will of the General Assembly. I want to address 3 points. First, what this bill does. This bill restores a very common sense rule that it is cruel and ineffective to criminalize offenses for people who are experiencing homelessness for merely existing in public spaces. Second, this bill does not create a license for people to engage in conduct that is otherwise criminal, such as harassment, such as public urination, such as aggressive solicitation. Those remain criminal. Third, this is an issue of state concern because when these ordinances are passed, one of 2 things happen. One, someone is arrested and they go into jail, and that costs about $5,000 a month to the state. Or 2, the person moves to another jurisdiction, which it then becomes that jurisdiction's responsibility to solve. So the state wants to take a proactive approach and stop a death spiral where each jurisdiction is pushing out people who are experiencing homelessness, it becoming another problem for another jurisdiction to solve. Instead, we are encouraging jurisdictions to adopt policies that work, such as housing first and supportive models of housing. And so for that reasons, we urge a favorable report with amendments.
Excellent. Thank you very much. Questions from the committee? Seeing none, thank you all very much. Thank you. All right, we'll now hear from Elizabeth Hilliard, Jamie Delaney Baggett, Mr. Shaw, Zephyr Shaw.
Hey, good afternoon again. Chair Smith, members of the committee, for the record, Zephyr Shaw, Advocacy Director for the Human Right to Housing at Maryland Legal Aid. And I just want to start by just stating what might not be obvious, but I hope it is, which is that this bill is not about the rights of some immutable class of people. Unhoused people can be all of us. So this bill is about the rights of all of us. I know that you know from the beginning of session when Secretary Day came to talk about housing, that you know that over 50% of all Maryland renters are cost burdened, housing cost burdened. When you look at renters who are earning 30% of area median income, 3 in 4 of those households are severely housing cost burdened. So they have an estimated $319 to pay towards costs other than housing. So they're on the brink. There's a lot of people who could become homeless at any time. Maryland Legal Aid sees up close that our clients and our community partners are experiencing the threat of homelessness every day. We are part of the Access to Counsel and Evictions program. We implement that law, and that program represented over 9,000 households in 2024. And those households reported in feedback surveys that if they were evicted in that case, their only alternative shelter would have been a transitional shelter or the streets. So that's why this bill is so important. We know that our clients face that razor's edge where they could be out on the street, not deserving to be criminalized for simply trying to mete out their existence in public when there is no other alternative indoor space. So we urge a favorable report on Senate Bill 484. Thank you.
Good afternoon, and thank you for the opportunity to speak today. My name is Jamie Delaney Baggett. I'm an MSW student at the UMB School of Social Work, and I'm here as a member of Social Work Advocates for Social Change to express our support for SB 484. This legislation will address the overcriminalization of the unhoused and provide critical protections for this vulnerable population. Members of our coalition, including myself, work with people who are unhoused every day. We know both from our work experience and our academic studies that criminalizing people experiencing homelessness does not solve the problem of homelessness, and it is expensive for the state. Protections for people who are unhoused are a topic of national conversation. Last year, the Supreme Court held that the 8th Amendment protections against cruel and unusual punishment do not prevent cities from criminalizing outdoor sleeping, regardless of lack of housing and shelter options. Filling this void in protections falls on the state. Some of Maryland's peer states, like Rhode Island and Connecticut, have established bills of rights for people who are experiencing homelessness. Maryland stands to benefit greatly from adopting a similar strategy, not only reducing strain on the criminal justice system, but also improving outcomes for unhoused Marylanders. Furthermore, embracing a progressive approach that is in this bill would reinforce Maryland's commitment to social equity by addressing homelessness in a way that is compassionate and sustainable. Social Work Advocates for Social Change urges a favorable report on SB 484. Thank you.
Good afternoon, Vice Chair, remaining members of the committee. Elizabeth Hilliard with the Office of the Public Defender, here to urge a favorable report on Senate Bill 484. The majority of our points have already been made, thanks to the predecessors at this dais. I just want to highlight that now more than ever, Maryland has both the duty and the responsibility to protect the individuals who are living here, and especially the vulnerable individuals who are living here. We can't jail our way out of the houselessness crisis. People do not choose to be houseless, but we can choose to protect those houseless people. I'm happy to answer any questions, but we urge a favorable report on this bill. Thanks.
Thank you. Any questions for this panel? Senator Sidnor.
Thank you, and I apologize that I was out, but do we have any data here in Maryland as to how many individuals have been caught up and prosecuted and imprisoned because of simply the acts that they were engaged in because of their homelessness?
Well, Senator, I can't speak specifically to due to houselessness, but what I can tell you is that in the 2024 fiscal year, there were 5,000 charges. There were 5,000 individuals charged under 10201, which is one of the two provisions covered in this bill. Unfortunately, I did not have time before this to pull the trespass, which is the second part of it. But I think also of note is that also in the fiscal year 2024, only 400 cases reached a disposition, which is quite a staggering juxtaposition. Well, I'm tired and can't say that word right now. Thank you, juxtaposition, thank you. To the 5,000 who were charged. And out of those 409 dispositions, 258 were null prost, 44 were steaded, 14 were dismissed, 7 were not guilty after a jury trial, 2 were not guilty after a bench trial, 1 was abated due to death, and 1, the person was found not criminally responsible. So a significant portion of the cases that actually reached disposition didn't even reach a guilty finding, despite the individual having to go through the harrowing process of being charged and going through the criminal process.
Have local jurisdictions modified how they deal with those types of things since, because I'm assuming this is grants passed, this is a response to grants passed. Have they changed how they've been responded to homelessness here in the state of Maryland?
I can't speak to that one. I don't know.
Would you happen to know?
We did provide citations and legal aid's written testimony to at least 3 ordinances, which are county ordinances, is Frederick's, as well as Ocean City's. And there's another one in there. I'm blanking on, Senator.
No, but have they?
But they're not new. They're not new reactions.
Exactly.
They were existing, and what they do is they do allow for arrests based on these life-sustaining activities that under this bill would be protected.
But has a new life been breathed into these statutes since grants passed?
I'm not familiar with whether there are new ones that have been passed, but it's an area that we can look into and get back to you on.
No, in other words, is law enforcement, because many times law
breathing the
enforcement weren't
enforcement
using
life?
them, so are they now enforcing them now? That the court, our U.S. Supreme Court has said, yeah, go ahead?
I'm not sure, Senator. It's something we can look into.
Okay, thank you.
Thank you. Juxtaposition, houselessness. We got it. Any other questions for this panel? Seeing none, we will take the next panel. Favorable with amendment is Mr. Pipkin. Mr. Prater already testified. I think that's it, Mr. Pipkin.
Good afternoon again, Mr. Vice Chair, members of the committee. For the record, my name is Matt Pipkin. I'm here on behalf of the Maryland Multi-Housing Association, requesting a favorable with amendments to Senate Bill 484. I've spoken very briefly with the senator. Our concern really is for the property owner who has a building, let's say, in Baltimore City. And as this bill states, in the public places, the sidewalks are essentially given sanctuary, and as long as the individual is conducting life-sustaining activities, they are okay to stay there. Our issue is if the individual had possibly harassed staff or residents before, do they now have to wait and, wait for a reoffending? I mean, it's just, we don't want to put our housing providers in difficult situations, and we, certainly want to protect public safety. But we certainly do commend the sponsors, and we absolutely understand the intent of the legislation. Willing to work with the sponsor on amendments, and however we can be of service. So specifically, we're requesting that to the bill that a public place, as specified from lines 20 on page 3 to line 4 on page 4, may not include locations adjacent to residential and commercial property. Again, very amenable how you want to word that. Additionally, MMHA would request an amendment to specify intently that private property is excluded. As you know, there are private parking lots, we certainly, again, don't want to just get caught up in that. Again, MMHA is ready to, work with the sponsor. Thank you.
Thank you. Questions for the Maryland Multi-Housing Association or Mr. Pipkin? Seeing no questions, we'll now move to the opponents of the bill, Angelica Bailey-Lupari, Sarah Sample, Chris Burchino.
Thank you to the chair and members of the committee for having me today. My name is Sarah Sample. I'm here on behalf of the Maryland Association of Counties, and we are in opposition to Senate Bill 484. I would like to start off by saying that all of our jurisdictions treat unhoused individuals with dignity, care, and consideration. There's no question about that. The climate right now is that we have a housing crisis, an opioid crisis, and we have a severe increase in mental and behavioral health challenges that a lot of people are experiencing, and that's contributing to an increased number of unhoused individuals. So in response to that, locally, we've tried to build out more resources when it comes to social services, when it comes to human services, mobile crisis units, public safety units, and also public health units. So we are trying to address this problem and trying to do it in a meaningful and thoughtful way. Our concerns with the bill are threefold. There is preemption in here, but I'm going to spend my time talking about two other elements. One is that the housing standard will have a chilling effect on the types of interventions that these teams that we're building up are able to have with these communities because of the increased exposure to liability, and that's a major concern of ours. It will decrease the amount of times that we have like a life-saving touch point with some of these communities, and as an example, it's because there are instances where we'll have accessible and safe housing, but it doesn't meet the standard in the bill. So it will limit our ability to have those life-saving interactions. So that's a concern of ours. We think it could potentially increase the number of individuals who are unhoused for longer periods of time, and we're concerned that when you have larger groups getting together, taking life-sustaining activities, that there are other things that are not addressed in life-sustaining actions in the bill, like expelling human waste, that are a major public health concern, and that's just a reality of some of these circumstances. So I want to point that out. And then the last thing I want to point out is that when it comes to having a civil fine to do with homelessness, that is very sparingly used. It is very rare, but I want to also offer that it is something that the potential to use it is something that can get an individual who is unhoused, but also potentially dealing with addiction, substance use disorder. It's a way to encourage them into services that they are having a hard time accessing on their own that they probably really do need. So those are our concerns. I'll wrap up. I would welcome anyone to visit a jurisdiction and see some of the work that we're doing.
Thank you, Ms. Sample.
And we appreciate this bill, but we would unfortunately have to oppose it. Thank you.
Thank you so much.
Good afternoon, Angelica Bailey-Thupari on behalf of the Maryland Municipal League, in very respectful opposition to this bill as well. I would echo everything that my colleague from MACO said and just want to highlight a couple more points. Our members found the logistics of this bill confusing and difficult to implement. And they are, of course, wary of any potential costs from increased liability and litigation. This bill includes the right to storing personal property, for example, but we're unclear on how that works. What would be sufficient? How is stored defined? Do towns need to provide storage lockers to qualify, or is the overhang of a public building sufficient? What about small towns without public shelters, without bus stops, things like that? How can this be safely and accurately implemented? And life-sustaining activities includes things like eating and drinking, as my colleague referred. But does eating include cooking? At what point does food preparation become cooking, which could be much more intrusive or unsafe than simply unwrapping a sandwich? The bill also says that local governments can't threaten, fine, or charge with a misdemeanor unless the activity is obtrusive, which is a reasonable concept, but without guidelines or factors, obtrusive is very subjective, and getting this wrong could result in expensive constitutional challenges. So as my colleague said, this could have a chilling effect and could be potentially very expensive for local governments. So we obviously agree with the concept that all persons should have dignity and safety, but we do respectfully request an unfavorable report. Thank you.
Good afternoon, Vice Chair and members of the committee. I am Worcester County Commissioner Chip Bertino, and I'm here to express opposition to Senate Bill 484. Though authored with noble and sympathetic intentions to provide additional rights to unhoused individuals, the bill's consequences heighten the public safety concerns of counties across the state and diminish the rights of all citizens. National considerations aside, the consequences of this bill play out in real terms in local jurisdictions. The bill preempts local policies while exposing counties to new liabilities, public health issues, and litigation. It mandates that county taxpayers provide free housing for individuals and families indefinitely. It is a backdoor unfunded mandate imposed on local jurisdictions. Local government should be empowered to handle this issue. In Worcester County, for instance, the Homeless Outreach Team, a multi-agency effort, has worked since 2018 to support the indigent. The team helps get vital records needed for employment, provides mental health services, and puts people in touch with shelters. The team ensures individuals are connected with appropriate resources and services. A county, a community, and the people should do no less. SB 484 prevents local action as well as criminal and civil citations, thus removing the county's ability to act when public safety, public health are threatened, and law enforcement services are necessitated. I urge you to provide this bill with an unfavorable report. If the legislature is convinced this bill should move forward, please consider tightening up the definitions, providing the necessary funding to local jurisdictions, and incorporating amendments that protect the county's ability to maintain safe public spaces for all citizens. The labor of legislators are not for the faint of heart, nor are they always appreciated. But I thank you for your service, your time, and your consideration.
Thank you so much. I didn't see who put their light on first, if you happen to. Senator Sidnor, go ahead.
And good afternoon. I'd like to ask you all the same question I'd asked the other panel. Actually, maybe to Ms. Sample, since you represent our local governments, many of which likely already have statutes on the books that their law enforcement may be using. Since the Grants Pass was held by our U.S. Supreme Court, have your members been using those laws to come after the homeless with any increased rate of use or whatever?
So anytime that there is a Supreme Court case, it does have a local effect. It's something that we want to make sure we bring back to our jurisdictions and especially our county attorneys. So when Grants Pass decision was made, we put together a group of our county attorneys and started talking about just what the ruling meant. And we stayed in touch with them, and what we have found is that nobody has increased their policing of anything. I know that there are some local jurisdictions that do have certain ordinances, but as far as changing behavior to be more aggressive in terms of moving populations, that is not something that we have seen, but it was certainly something that we wanted to make sure we stayed in touch with local jurisdictions on.
Now, something that I think maybe some of the proponents had said, and I agree with, when you are attempting to deal with homelessness, you deal with it by providing additional housing, additional affordable housing. I know this General Assembly passed legislation last year to kind of begin trying to address some of the underlying issues with the building of affordable housing in the state. I know some of our local governments have acted in some ways that I think makes things a little bit more difficult to bring affordable housing, whether it's through their zoning or whatever. If homelessness is an issue, I think all of you testified to that you all are attempting to deal with homelessness by having homeless shelters and providing services and the like. But if the answer is more housing, are your member organizations trying to look at what they're doing with their zoning codes?
Yeah.
Senator, thank you for the question. I can speak to what we're doing in Worcester County, and I suspect that many counties that are rural like ours. Affordable housing is an issue across the state. But it's also very clear that the state legislature over the years has forced upon localities rules, regulations, and laws that make it difficult to create affordable housing. The mandating sprinklers in new housing in Worcester County has increased the price of new housing by $30,000. New septic regulations that have been in place and are being considered by this particular legislature during this session will increase the cost of affordable housing. We want affordable housing in Worcester County. I don't think that I'm alone as a commissioner in Worcester County. It's across the state. But it's a partnership that we require the help and assistance of the state legislature to ensure that we can provide that without undue, unnecessary, and very expensive costs associated with bills or laws that come down from the state. So we need your help. And that's the only way it's going to work, I think, in Worcester County, is if we have a partnership with this legislature, with this government, to ensure that we can create housing that is affordable.
And that sounded as if you deflected and placed the blame squarely on this General Assembly.
No, sir. But it is a partnership. I did say it was a partnership, and that's what it is. We can only do so much, and our citizens in our county can do only so much. But when we are hamstrung by legislation that comes down that requires more expensive septic systems in a rural area like ours, that's a huge deal.
But you all control your zoning pretty much completely.
Well,
right?
that's fine, but we have to do it in the through the guidelines of what the state requires, and it makes it challenging, especially for a rural county. I can't speak to an urban county, but it does make it challenging for a rural county such as ours. But we would love to partner with the legislature and with the state government to ensure that we can provide affordable housing in our county and throughout the state. So I don't know if I've answered your question, but that's the answer that I think is most appropriate for affordable housing in Worcester County.
No, that is fine. Thank you very much.
Thank you.
Thank you, Senator Sidnor. Senator West.
Thank you, Mr. Chair. Ms. Semple, maybe I could talk to you. I will admit that I have only received during the course of my political career glimpses of the homeless issue, mostly in Baltimore County. So maybe you can answer this. Does the state have any kind of a holistic approach to handling homelessness, or is it a catch-as-catch-can, county by county, municipality by municipality problem?
So I would say that there has been some ebbing and flowing, and I would say some inconsistencies in terms of how the state does take certain actions when it comes to collaborating locally, and it's going to be different based on jurisdictions. But I can say that it is absolutely something that we would be open to and we would welcome in terms of being able to collaborate to deal with some of these things. But I think over the last decade or two, there's been a lot of inconsistencies in terms of what kind of help they're able to provide.
So it's always frequently a cop-out to say what we need is a task force. But it seems to me that rather than a bill which hones in on elements of a problem, we really need to address the whole problem on a statewide basis and try to come up with a program, a plan that everybody can buy into and then sign on to, which will deal with the problem in a comprehensive way rather than a patchwork way. Would you agree with that?
Absolutely, yeah. That's something we would welcome.
Thank you.
Thank you.
Thank you. Any further questions for this panel? Seeing none, thank you so much. That concludes the hearing for Senate Bill 484. Senator Muse, thank you for bringing that bill. We'll now move to Senator Love with Senate Bill 549 and whomever you would like to bring up.
Can I bring up my panel?
Of course.
Thank you. Okay. Good afternoon, Mr. Chair, members of JPR. Sarah Love here to present SB 549, the Stop Silencing Survivors Act. I want to ground us in some statistics. In Maryland, more than 1/4 of all adult women have been the victim of rape sometime in their lifetime. Nearly half of all adult women in Maryland have experienced other forms of sexual violence, and about 1/3 of Maryland's adult men have experienced other forms of sexual violence. Nationwide, 1 in 5 women and 1 in 16 men are sexually assaulted while in college. Sexual assault is the most underreported crime, with only about 1/3 of these assaults being reported. Let's contrast that to robbery, where the majority of them, about 60%, are reported. So the statistics tell us that sexual assault happens far too often and is far too underreported. And if that weren't bad enough, many abusers sue their victim to stop them from disclosing the assault. And that is where SB 549 comes in. The bill seeks to address an abusive litigation practice that targets survivors of sexual assault. These survivors are being sued for any number of torts, including defamation or intentional infliction of emotional distress, juxtaposition, if we're going to get all caught up in our words, by those who assault them. This tactic has the intended effect of not only further victimizing the survivors, but also dissuading other survivors from reporting the crime they suffered. SB 549 is modeled after our current law protecting employers who provide references for former employees and balances access to the courts with preventing abusive lawsuits. Under SB 549, a person acting in good faith may not be held liable for disclosing any information about allegations of sexually assaulted behavior to another person. The bill further allows that the good faith presumption may be overcome by clear and convincing evidence that the person acted with actual malice or reckless disregard in disclosing false information. As I said, it preserves access to the courts and sets a standard that will ensure that those who bring these suits have been harmed and are not using them to further harm their victim. And I just want to close by saying this bill has been endorsed by the Women's Caucus and the Maryland Legislative Agenda for Women. So for these reasons, I respectfully request your support, your favorable report on SB 549. Thank you.
Thank you, Senator Love. Mr. Chair, remaining members of the Judicial Proceedings Committee, I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're here in strong support of Senate Bill 549. Senator Love, thank you for your support for this, your leadership for sexual assault survivors, and your very comprehensive description of the bill. As Senator Love said, this really balances two competing interests. And Senator Love has already talked about how much sexual assault is underreported, but I also want to bring the committee's attention to the fact that we encourage survivors to come forward all of the time. There are people who, they put up billboards, they do trainings from the YWCA, they go to their colleges and they say it's important to come forward, it's important to speak up, to speak out, because we say if you don't come forward, sex offenders are going to go free. Our communities are going to be endangered. You're not going to have the help and support that you need. Civil lawsuits, they're contradicting all of that information, all of those pleas that we provide for survivors. And, you know, I work at the Maryland Coalition Against Sexual Assault, but part of our work is the Sexual Assault Legal Institute. So we have lawyers all over the state who provide direct legal services for survivors. And we see these retaliatory civil lawsuits designed to silence survivors. There's a cottage industry of law firms that are seeking people who have been accused and saying, hey, let's sue the survivor. Survivors who are sued, they have to provide a defense. So they are the ones having to prove, I was sexually assaulted. Senate Bill 549 artfully balances the competing interests and say, we don't want to shut down access to the courts. We're just going to say, we'll give you a chance for remedy as long as this is really intentionally false, recklessly false, or done with actual malice. For these reasons, we urge your strong support and a favorable report for Senate Bill 549. And Mr. Chair, I see you've returned, and so I have to wish you happy birthday.
Thank you very much.
Good afternoon, Mr. Chair, Mr. Vice Chair, and members of the committee. My name is Melissa Spurn, and I am a law student and an extern at the Erin Levitas Initiative for Sexual Violence Prevention, operating out of the University of Maryland School of Law. I am here to testify in support of Senate Bill 549. First, Senate Bill 549 will help make college campuses where sexual assault is at its peak safer by encouraging victims to come forward without fear of further repercussions. In college, I served as a resident and community assistant and had a student disclose to me that she had been sexually assaulted. She begged me not to report it, pleading, "Please, I don't want to go through this again. I haven't seen him in years, and I'm in a really good place now." She then asked me, "Would the cops find out? Would my parents?" My residents' fear, while disheartening, is not unique. In Maryland alone, over 21.3% of women have been raped, and 44% have faced other forms of sexual violence. However, less than 1/3 of rape and sexual assault is reported to law enforcement. Second, Senate Bill 549 will help reduce the chilling effect of potential civil liability for reporting sexual assault to campus officials or police officers. This chilling effect means survivors refrain from reporting incidents to law enforcement or Title IX officials out of fear of enduring further trauma, potential civil legal consequences, and damaging their social relationships. As a society, we want to encourage the reporting of sexual assault because we can support the survivor to reduce their trauma, prevent harm to others, and work on solutions. Third, Senate Bill 549 protects those who file charges against their assaulters from being sued in civil court, as long as they're made in good faith. Without Senate Bill 549, survivors may face additional court costs as well as the psychological trauma of another trial. In conclusion, Senate Bill 549 fosters a safer environment for reporting sexual assault by alleviating one of the many fears survivors already face, being sued for reporting. I therefore urge a favorable report on Senate Bill 549. Thank you.
Good afternoon, Mr. Chair and members of the committee. I'm Elizabeth Tang from the National Women's Law Center. I'm an attorney, but I'm also a survivor, and I'm here in strong support of the Stop Silencing Survivors Act. Here in Maryland, nearly 2 million residents of all genders will become victims of sexual violence in their lifetime, but most of them will never, ever come forward. And one of the biggest reasons why survivors stay silent is the very, very real fear of retaliation. You heard my colleague Lisa just say, there is a cottage industry of defamation lawsuits. 1 in 5 student survivors of sexual assault are targeted or threatened with a defamation lawsuit. Defamation lawsuits are the 3rd most common type of retaliation for survivors in the workplace. And abusers don't necessarily expect to win these cases, but they know that their victim must still incur immense financial costs. We're talking 5, 6, 7 figures, and psychological costs in order to defend the lawsuit from their abuser or assailant to the very end. This is why many victims are coerced into silence or into withdrawing their claims. I have seen many of these terrible cases at the National Women's Law Center. In 2023, I actually co-authored a toolkit with survivors who have been sued for defamation to teach other survivors who get sued for defamation how to fight back. I have also submitted numerous amicus briefs to state courts in Connecticut, the District of Columbia, Illinois, Massachusetts, and New York in support of survivors who were sued for defamation after reporting sexual assault. SB 549 is critical because it would ensure that abusers can no longer weaponize Maryland courts against their victims and would protect survivors' rights to speak out at all in the first place. And SB 549 is also nothing new. In the past few years, states like California, New York, Rhode Island, Tennessee, Vermont, and Washington State all have passed laws to explicitly protect survivors from being targeted by defamation lawsuits. I hope Maryland will join them, and I urge you to issue a favorable report out of this committee. Thank you.
Oh, my apologies. Is Debbie joining us? Is it Debbie?
No, she had to leave, but we have Professor Burke, I believe.
Okay. Is she in the waiting room? Okay. Thank you for that. Professor, welcome. Is Debbie joining us? Is it Debbie?
Yeah.
All right. If you could turn your browser off, if you're streaming it, if you just click out of that tab or close the browser, then we won't get the feedback. Professor, welcome. Is Debbie joining us? Is it Debbie? Yeah. All right. If you could turn your browser off, if you're streaming it, if you just click out.
Is that better?
There you go, perfect.
Okay, good afternoon. My name is Victoria Burke, and I'm an attorney and adjunct law professor. In December 2019, I went out with a male friend, and we went for drinks, and the next thing I remember is wake up with very bright lights all around me. I somehow was in the emergency room coming out of a severe coma, and I believe that the person I was with had drugged my drink. I had no clue how I arrived at the hospital, but I was later informed that paramedics had found me unresponsive in a parking lot, face down in my own vomit, having been, having not known how I got there. I was like very startled, and I started doing my own investigation. I went to the police and had them like look into what happened to me. Unfortunately, the police lost my blood evidence, and they also lost my video evidence as well, making it very hard for me to proceed through legal channels to get justice in that way. I was telling a friend of mine who is a defamation attorney about what happened to me, and she cautioned me, be careful not to use your abuser's name, don't use anything that may identify him, or you could be sued for defamation. And I was very stunned, but she said, in the wake of Me Too, many litigations have gone forward for defamation for those simply speaking out about what has happened to them. And so bills like Senate Bill 549 would protect the ability to come forward and tell people exactly what has happened to you and feel safe that you would not be sued. And if you are sued, that you would be able to get your attorney fees and incentivize attorneys to take on these cases. Thank you.
All right, thank you very much. All right, Senator Sidnor.
Thank you. So are there causes of action other than defamation that this bill is attempting to reach, or is it just about defamation?
Thank you, Senator Sidner. This covers any cause of action, and that was explicitly because of a case in Prince George's County we had. It's written in my written testimony, but we had a woman. She went to the doctor. She was going to a clinic for people with limited means. Her doctor molested her. She decided not to report. She woke up in the middle of the night. Her TV was on, and the prosecutor was there saying, hey, if you have been molested by this man, picture of the doctor on the screen, please come forward. And so really the prosecutor encouraging her to come forward. She did that. There wasn't a conviction, but he ended up giving up his medical license permanently. And then he sued her for defamation, intentional infliction of emotional distress, interference with contract, malicious prosecution. There were, I believe, 9 different causes of action. At the end of the day, we were able to get the lawsuit dismissed primarily because the attorney filing the case had failed to comply with some of the technical requirements for IAED and some of the statute of limitations for filing these causes of action. But it's not just defamation. It's this broad range of causes of action. So if you limited it to defamation, it would be very easy to just get around that. So that would not be an effective solution.
And you touched on it with your example, but I was curious what happens to most of these plaintiffs' cases. Are they generally dismissed, or?
They're not. They're often settled, and they're often settled for if you be quiet and take things back, kind of a non-disclosure agreement. Additionally, we had another case where it was a horrible case, and we ended up winning on the merits, but it was particularly horrible to me because it was a young woman in college. Her parents were a paralegal and a firefighter. And they had a little bit of money, so too much for legal services, but not enough to pay for a private attorney. And their umbrella policy had lapsed during one of the big hurricanes, Hurricane Isabel, I think. And so they had this enormous cost. I mean, they just were financially burdened for years. And we were able to find a private attorney who helped us represent her. But we also learned through the course of that many people who do have umbrella policies, then the insurance companies are just settling kind of, go away costs. So it's not like people are winning these lawsuits. They've got insurance companies pressuring them to settle and also to have a non-disclosure agreement and really silencing them.
So then my third question, and again, was what happens, and this is something that's been bothering me since January 6th, is seeing attorneys go into court with bogus cases and then them not being held to account and not losing bar licenses and things, but making just, arguments that didn't make sense. So in the case of a defamation case, truth is your shield. The women who are then accused of defaming the person, I'm assuming, did a criminal case go forward where they would have the evidence that they were not defaming but actually truth-telling, number one. And number two, what do you all know? Does anything happen to these attorneys that are bringing what you all are calling these weaponized cases? Is anybody filing things in the attorney grievance commission if this is a cottage industry?
Well, kind of breaking that into the separate questions, of course, there are different standards of proof in criminal and civil, and one of the benefits of a civil lawsuit, of course, is that that gives citizens the ability to go to court. What's happening here is we're abusing that. Many survivors don't want to press criminal charges, so these are people who have simply told their stories. Mm-hmm. And in the case that I was talking about with the doctor, she actually had pressed criminal charges, but there wasn't sufficient evidence, so they steadied that case in return for the medical license. So each of those decisions about are there criminal charges, is the survivor doing a civil lawsuit herself, all those are fairly individual.
So you don't have that ability to say, look, this court found that what I said was truth.
That's right.
You don't have that.
Right, but I don't think he would have given up his medical license permanently absent some degree of truth in that. Right. The problem with the truth defense is it is a defense, right? So then you're placing the burden on that survivor to prove something that's very difficult to prove. I will say we had that exact question that you had about the January 6th cases with the doctor's case, and went through the rules that apply to each of us as attorneys and did file an attorney grievance complaint, just advising the board.
Did it work?
I don't think that we ever learned a result. So I doubt it. But,
thank you.
But it's our obligation to file if we know of something that's violating the ethical rules.
Again, when it's called a cottage industry, there's attorneys behind all of this stuff that have certain duties. And okay, thank you.
Thank you, Mr. Chair. So as I read this bill, I sort of had a similar reaction to the SLAPP suit bill that Senator Hedelman brought several weeks ago. And this is my concern. I just wanted to share. I think I'm with you on this, but I want to share the concern. We, in our society, the courts are open to people who believe they have a case. And I wouldn't want for us to take legislative action which would prevent people from who believe they have legitimate cases from bringing legitimate cases. So in both the SLAPP suit situation and here, it seems to me that a special burden is being put on the plaintiff by a very difficult standard of proof in order to allow the plaintiff's case to go forward, to have to prove stuff at the outset which is very hard to prove, namely the state of mind of people on different sides of the case. And the intent being to prevent these cases being filed in the first place. And that's a matter of some concern because we simply can't get to a situation where, well, in any case, one side's going to win at the end of the day and the other's going to lose. We can't get to the situation where the losing party is is viewed as having done something wrong, as having when they brought the case to begin with. So what can you say to alleviate my anxiety that both in the SLAPP suit case and in this case, we're putting such burdens on the plaintiffs to go to jump over massive hurdles in order to proceed forward with the cases that they've brought?
So certainly, I'm more familiar with this bill than I am with the SLAPP bill, but my understanding of the SLAPP bill is that it's got a fairly detailed procedural
yeah, why don't we just talk about this bill? I don't want to put you on the spot about a bill you're not familiar with.
Thank you. I appreciate that. I mean, I want to say I agree with you. We should have access to the courts. And I really think that Senator Love has done an excellent job kind of artfully balancing the competing concerns that you have to weigh as a legislature. And my view of this is that it just clarifies the elements. I think that all of this is going to be part and parcel of the trial if it goes forward. Your element is going to include that the statement happened, and your elements are going to include that the statement was intentional or recklessly made, or that it was made with actual malice. This is not that different, honestly, than the defamation suits and your defense as a public official, right? We have a slightly higher standard, right, if you're going to be sued by a public official.
You would agree that requiring a plaintiff to prove actual malice at the very beginning of a lawsuit before any discovery has occurred puts them under a very significant obligation. And if they can't sustain that obligation, then the case just can't go forward.
Well, but it's actual malice or intentionally or recklessly disclosed. So it's not, it's one or the other. So I think that you could prove simply that this is a reckless falsehood or that this is an intentional falsehood.
And they'd have to prove it by clear and convincing evidence, which is a high evidentiary standard, not just by the preponderance of the evidence.
That's true. That is the language in this bill, and that was adopted directly from the statute that's currently in place for employers in the reference situation. So it tracks current law. And although it's a high standard, it's an intermediary standard, right? It's not preponderance, but it's not reasonable doubt.
It's not beyond a reasonable doubt, no. Yeah. That would be virtually impossible for anybody to establish, especially at the outset of the case before there's been any discovery.
But wouldn't this be part of discovery, Senator? I think that would be part of what your discovery process would be, is looking for intentional, looking for reckless. So this is again, in my mind, in my interpretation anyway, this is adding an element to the cause of action and saying that these causes of actions are not going to be able to proceed, unless you can prove that. So I think that's subject to discovery.
Okay. I appreciate your answers. Thank you.
All right, further questions from the committee? Seeing none, thank you very much. Thank you all. Thank you, Senator. Do we have any other? Senator Charles, you want to go? Sponsor one. All right, that'll conclude the hearing for Senate Bill 549. We'll now move on to Senator Charles with Senate Bill 540.
Good afternoon, Mr. Chair, Mr. Vice Chair, and honorable members of the Judicial Proceedings Committee. For the record, I am Senator Nick Charles, here on behalf of Senate Bill 520, Common Ownership Communities, Recreational Common Areas, Sensitive Information as Condition for Access. This bill is a crucial piece of legislation that upholds the privacy, dignity, and inclusivity of residents and common ownership communities across Maryland. The bill ensures that individuals and families are not forced to disclose sensitive personal information, such as Social Security numbers or birth certificates, as a condition for accessing recreational community spaces. Common ownership communities should foster welcome environments, not impose unnecessary barriers that discourage families from enjoying the amenities they help maintain. Unfortunately, in many communities across Maryland, residents are being subjected to intrusive documentation requirements that are both excessive and discriminatory. Senate Bill 540 provides a clear and necessary safeguard against these practices, preventing residents from being unfairly singled out while still allowing reasonable security measures such as requiring a government-issued photo ID. The need for all this bill became evident after multiple reports of homeowners associations imposing invasive documentation requirements on residents. For example, in one recent case in District 15, represented by my cross-file Delegate Foley, an HOA required a birth certificate for a child to access a community swimming pool. This is unacceptable, and it's not an isolated incident, as across the state, similar practices disproportionately impact many communities. Some may argue that community associations have the right to regulate access to amenities. Senate Bill 540 does not challenge their ability to enforce security measures. It simply ensures that personal and sensitive information is not misused as a gatekeeping tool. Privacy and equity should never be sacrificed under the guise of administrative oversight. By passing Senate Bill 540, we affirm Maryland's commitment to fairness, inclusivity, and the fundamental right to privacy. I urge the committee to provide a favorable report, and thank you for your dedication to protecting the rights of Maryland residents.
Excellent. Thank you very much, Senator. Senator Henson.
Chair, I'm curious, what was the rationale for requiring the birth certificate to access an amenity? Did they say why?
They didn't have a rationale. It's just there was no provision to stop them from asking for it.
Wow.
So they're asking for Social Security cards and birth certificates. You don't need that to get access to a pool where you pay your HOA fee. You know, typically when you go to a lot of these communities, they give you a wristband or something. If you want to bring guests, you have to be with your guests. But asking for folks to provide a Social Security card or asking for a birth certificate is outrageous.
Okay, thank you, Mr.
Yes.
Chair.
And I believe for 441, we should have someone online. She's still okay. Great. All right. Good evening, team. In accordance with Chapter 654 of the 2022 legislative session, the Maryland Department of Housing and Community Development staffed the Task Force on Property Appraisal and Valuation Equity. And they were charged with addressing the persistent misevaluation and undervaluation of property owned by minorities. The task force completed its work this fall and made 5 recommendations to address its charge. Senate Bill 441 focuses on one of those recommendations, which would require the timely reporting on sales of new construction through the multiple listing service or a comparable system. Senate Bill 441 does 2 things. It defines what a multiple listing service is, and it requires developers, builders, brokers, or real estate agents to enter the final sale price of new homes into a multiple listing service or similarly accessible database within 30 days of its sale. The task force noted a critical component to ensuring the reconsideration of value process is viable is a requirement that builders and developers of all newly constructed residential properties enter comparable sales into a publicly accessible system such as MLS within 30 days following the closing escrow, which would follow the MLS rules and regulations for reporting sales. The task force asserted that this was extremely important. So as Senate Bill 441 is one of a few recommendations noted to help address the persistent misevaluation and undervaluation, I request a favorable committee report.
Excellent, thank you. And then we have, Ms. Priestley, welcome. You can join, you can come off of mute. We're ready for you. Can we ask her? Let's see. Hold on. There you go.
Okay, thank you. Good evening, or good afternoon, Mr. Chairman and members of the committee. My name is Jacqueline Priestley. I'm a resident of Prince George's County and co-founder of the Fair and Unbiased Appraisal Advocates. I also recently chaired the state task force that was just mentioned on property appraisal and valuation equity. I'm here to express my support for SB 441. In 2021, as the construction of my family's home was nearly complete, my husband and I prepared to move from a construction loan to a 30-year term loan. During that process, we received appraisals that we felt did not accurately reflect the actual market value of our home. In fact, our appraisal came in significantly below our cost to build, while new homes in neighboring counties generally appraise over build cost. At the exact same time, several of our neighbors and other families in nearby communities faced similar challenges. Some were in the process of converting their construction loans to permanent loans. Others had their homes listed for sale for years. And while there were buyers ready and able to pay the asking price, appraisals would come in well below. Additionally, this reality negatively impacted homeowners who planned to use their homes for business collateral, as well as those who wanted to refinance their homes for better interest rates. To help rectify this issue, my husband and I decided to have our home listed on the multiple listing service after we closed on the purchase to reflect our actual build cost. In listing our build costs, the families I mentioned who were in disputes with lenders or struggling to get asking price for the sale of their homes could order new appraisals and use our transaction as a comp. As a result, these homeowners secured new appraisals that reported their homes at higher value. In short, this approach works. Additionally, as part of my work with the Task Force on Property Appraisal and Valuation Equity, we examined the approach and impact of adding the final sale price of a new home into an MLS or similarly accessible databases. As noted in our report, the task force believes that timely reporting of new construction sales will increase transparency in sale prices and help provide sufficient comps in neighborhoods that would otherwise have insufficient sales data to determine an appropriate opinion of value. For these reasons, I urge the committee to issue a favorable report on Senate Bill 441. Thank you.
All right, excellent. Thank you very much. All right, let's take questions from the committee. So Senator Muse and Senator West.
Thank you, and thank you for bringing us this bill. In Prince George's County, we have even had persons to same house, same value. One was black, one wasn't black. Two different, appraisal costs. And it made us begin to look into it in Prince George's County. When it comes down to appraisals and comps, we get absolutely much lower appraisals than right across the bridge in Virginia of the same home, et cetera, et cetera. So I'm hoping that this is something I want to work with you on and look at how we can implement something like this and figure out, because we know what's done in certain neighborhoods. But absolutely same square footage, same house, same blah, 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 and two different appraisals. Now, I'm not saying all of it is based on that, right, but we know that in Prince George's County, there is a racial problem when it comes down to it.
And I believe Delegate Kim Taylor has a few other bills that may be coming out of this task force. This is just one of them.
Great. I want to work with you all on this.
All right, thank you.
I guess a couple of questions. First of all, why does the bill only address new homes as opposed to the sales of existing homes?
Shall I let the task force chair respond to that? Oh, you're on mute.
You're on mute.
Hold on. We'll take you off. There you go.
Thank you, Senator West. The reason being because there's no publicly facing data required related to new home sales. And when you look at a county like Prince George's County, like many others, there's a lot of land where homes are still being built. So when you build a community of 600 or 1,000 brand new homes, none of those go into a public facing database where it's easy for consumers to say, I can see the comps. of homes similar to mine. So what ends up happening is oftentimes we can look at an MLS that only shows homes for resale for marketing purposes. So our ask is to ensure that all home sales, and specific to this bill, that new home sales be added to the MLS or a similar database system so that we have a more accurate representation of what's happening in the market. With the county or a geography where several new homes continue to be built, without knowing about those transactions and being able to use those new homes as comps, a sizable portion of the data is absent in current appraisals.
Okay, so the decision to use the adjective new wasn't accidental. It was intentional. You wanted to include new homes, but not existing homes.
Existing homes arguably are often already provided in the MLS by realtors looking to promote the property. What's not happening, though, are new builds.
All right. Secondly, I'm going back many, many decades now. My grandmother opened the first woman-owned real estate company in greater Baltimore area back in the 1940s. When her boss for the company she worked said that women are going to have to take a cut in pay because I don't want to make the men take a cut in pay. They're the family breadwinners, but I'm going to make the women take a cut in pay. And she said, my resignation will be in your desk the next morning. And it was. And she opened her own firm. She was a member of the multiple listing service. So my understanding is it's a membership organization for which you have to pay a membership fee to be a member. Isn't that correct?
Yes, Senator, that is correct, which is why in the language in the proposed bill, we say a system such as MLS or a similar database.
It says similarly accessible database, and my question is, what is a similarly accessible database, which would not require money to be paid to join it?
On part of the task force, our job was not to identify what that option could be, but rather uncover a mechanism that would provide greater transparency on actual
Okay, are you aware of whether there is such a similarly accessible database? Or if there is none, the effect of this bill is to require people to pay money to join the multiple listing service.
Many of whom already are members and have access to the MLS.
Okay, thank you.
Thank you.
All right, further questions from the committee? All right, thank you very much. We'll now switch over to the opposition panelist, Mr. Enton. Actually, is Ms. May here? Sorry, coming up, and then we'll switch to the opposition panel. You have favorable with amendments?
Yes, thank you, Mr. Chair. Lisa May with Maryland Realtors, and my testimony may be much shorter because of the question that Senator West just posed. Realtors supported this task force, supported efforts to make property valuations more fair, but we did want to come before you today to explain our conflict of interest that we think exists with this bill. Our multiple listing service, Bright, serves all of Maryland. And our local realtor boards and associations are shareholders of that organization. They receive dividends and other financial compensation based upon the number of subscribers that Bright has and the fees that they pay into that system. So to be very clear, under this bill, home builders would be required to pay for a service where realtor organizations profit. And that is something for you to decide and to wrestle with as you examine this bill. And if that's not the direction that this committee wants to go, we at Maryland Realtors stand ready to help you with that similarly accessible database option, which already exists in the bill. With that, I'll just wrap up, and I'm happy to take your questions.
One question. Thank you, Mr. Chair. Back when I occasionally transferred real property, when I was actively practicing law, we had to pay transfer taxes and recordation taxes. Back in those days, there were actual stamps that got affixed to the deeds. So it was possible for anybody to go into the land records office and determine exactly how much had been paid for a particular piece of property by looking at the stamps on the deed. Is that no longer possible?
No, that should be available probably through your local clerk of the court, but also we believe through SSTAT, is that because state level transfer taxes are also paid, that the final consideration is reported there as well.
So isn't it correct that an appraiser could simply access the SSTAT records and determine how much was paid for new houses in the Prince George's County area by checking the SSTAT records?
That's my understanding, Senator. I don't know exactly how quickly that information is reported because it does, it goes to settlement, it goes to the county, then it goes to the state. So the timing of that, there may be some lag in it, but it is there.
Apparently in some counties it's very prompt, in other counties they're a month or two or even 3 months behind.
Yeah.
I got it. Thank you.
All right, thank you very much. Thank you. What is Sarah, you may know this, what is the recordation tax in Montgomery County? It's like 16 grand or something. It's crazy. 16 grand, I think. All right, Mr. Enton and Lori Graff, come on up.
Good afternoon, Mr. Chair, and I would be remiss if I didn't say happy birthday. We've been hearing all day. I'm Lori Graff. I'm the CEO of the Maryland Building Industry Association. I will be brief. I think a lot of the points have already been mentioned. I did serve on the task force. We were supportive of 95% of what came out of the task force. I will say that I flagged this. I tried to talk to the task force about this issue very early on. If you look at the records of the task force, you will see I was adamantly opposed throughout the process. I did vote against the report for this one piece of it. However, we obviously do support the rest of the report. We do think we need to do something to fix this. However, having mandating a proprietary product that is for profit, that the realtors or anybody has to join and people are benefiting financially, I'm not sure is the best avenue that the legislature should go down. So that's our main concern. As Senator West mentioned, this is readily accessible in an SSTAT. I went and checked my property just to check it out. If you go to SSTAT's website, you put your address and your county in there, you can see how much I bought it for. I bought it from 2017. I can see how much the person prior to that bought it for. If we don't like that process, obviously we can work on that and work with SSTAT, and maybe it's not quick enough, that type of thing. I think there's some room for improvement on that, but we don't believe this bill is the correct avenue. We talked about the similar database. I'm not exactly sure what that means. Is that SSTAT? I don't really know. Happy to work on it, happy to figure out better solutions. We just have a lot of concerns with this one, considering we really don't even have access to MLS and we would have to join. So thank you.
Thank you, Mr. Chairman, members of the committee, Robert, and on behalf of the Maryland Building Industry Association. I know that I look all the time at Zillow, and I get emails from Zillow that tells me what's out there in the market. When you go to Zillow, you can look up just using Zillow and see what, geographically look on a map and see what the houses sold for around you. In addition, you can go, as Ms. Graff said, can go online. You can look and see, what deeds were recorded. Every deed states what the purchase price is. And you can go to the website, put in the county, put in the address, see all the deeds, and every deed that you click on in chronological order will tell you what the purchase price was. So it just seems to me to require for new homes that they pay I don't know what the fee is to get this information, but my guess is it's not inexpensive. And I think for citizens, you can find plenty of sources to check and see what your appraisal is. When I refinanced my mortgage, I wasn't happy with the appraisal. I went online and I could see exactly what the other houses around me had recently sold for. I went back to the appraisal company and complained about it, and they rewrote the appraisal. So I think there's information out there that's adequate to address my good friend, the sponsor's concerns. Thank you.
Thank you. And for the record, I want to say that Mr. Enton is old school, so he told me he was coming to oppose the bill. So I do have a question for Ms. Graff. And thank you for your testimony and your service on the task force. Would you say that most of the members of your organization, would they have access and already pay for MLS?
No, they don't.
Most of them don't?
Most of them don't. We have a few that, for smaller custom people that may be building on spec, but MLS, I mean, it's really for sales. It's a service for sales. So a lot of people aren't going to use it if they're using we're not using realtors really. We have our own in-house salespeople. So for most part, no. Obviously, there are people that use realtors and have access to it.
Thank you very much.
Further questions from the committee?
Thank you.
All right, seeing none, thank you all very much. With that, that'll end the hearing for Senate Bill 441 rather. We'll now go on to Senate Bill 442, Senator Sidnor.
All right. So Senator Sidnor testifying on behalf of Senate Bill 442. So last June, the United States Fourth Circuit Court of Appeals ruled in Todman versus Mayor and City Council of Baltimore that a couple's 14th Amendment due process rights were violated because Baltimore city law declares a tenant's belongings abandoned upon eviction without adequate notice and a reclamation period. Holding that the responsibility for ensuring constitutional requirements in the execution of evictions falls to the respective municipalities, the court affirmed the money judgment for the couple for over $180,000 and found Baltimore City's abandonment statute and eviction practices unconstitutional. While Todman only addresses the constitutionality of eviction practices in Baltimore City, the court's holding implicates every local jurisdiction in Maryland, particularly those like Baltimore County and Prince George's County that also declared tenants' possessions abandoned upon eviction without notice and a reclamation period. Thus, if the Fourth Circuit found that the city did not pass constitutional muster, other jurisdictions do not either. Ordinances, policies, and practices vary from locality to locality, but under Todman, the procedural due process rights of Maryland tenants are violated every time an eviction that results in the loss of a tenant's personal property takes place. Maryland should have a uniform process for eviction procedures as provided in this bill to avoid local liability and provides a baseline measure of dignity for renters. Todman aside, Senate Bill 442 is important on a very human level, which is that we want to ensure that people do not lose valuable personal possessions in evictions, including medicines, social security cards, birth certificates, pictures, and family mementos at one of the lowest points in their lives. So often, tenants believing that they can vacate or pay and stay before the eviction occurs are left flat-footed when the sheriff arrives to evict them. In those moments, the tenant, if they are even present, must vacate the premises immediately and forego all of their possessions still remaining on the property. In some jurisdictions, the possessions are placed on the street where they are often stolen or ruined. In other words, the possessions are locked inside the property, and tenants commit criminal trespass if they try to get them back. Last summer, my office received a call that a Western Baltimore County resident who was disabled and in a wheelchair had been evicted with all of her belongings being dumped on the curb. She had no ability to move her belongings and no place to go. Multiple people kept walking by, some explicitly asking whether the items were free. Some people even rummaged through her belongings. My legislative aide, along with many others, crowdsourced funds to put her up in a hotel and rented a storage space for her. For the next several hours, they raced against the fleeting daylight and triaged her belongings, asking her what was worth saving and what had inevitably had to be left behind. They loaded up her belongings, and an emotional toll was visible. Her friend stayed that night on the sidewalk to guard the remaining belongings from being stolen so more could be salvaged the next day. Relying on best practices from jurisdictions around the country, Senate Bill 442 resolves the aforementioned issues by requiring landlords to provide notice to tenants at least 14 days before the scheduled date of eviction. On the date of eviction, the sheriff escorts any occupant off the property and the landlord changes the locks. Upon changing of the locks, a 10-day reclamation period begins where the landlord must provide the tenant reasonable access to their belongings for 10 days, either on site or in another secure place like a storage locker, to allow the tenant to reclaim those possessions. Senate Bill 442 offers a win-win situation for the tenant, the landlord, as well as the community. We've been talking about litter and trash, and many communities where people deal with this situation all the time become trashed because of these types of practices. It makes the eviction process more predictable. The tenant knows at every step of the eviction process what is happening and will allow them to keep their belongings such as life-saving medicine, electronics, and personal treasures such as their photos, mementos, and their heirlooms. It is more predictable for the landlord because they know when the tenant's property is officially abandoned. It also saves the landlord from having to pay an employee to move all of the tenant's possessions to the curb on the scheduled date of eviction. And it's a win for the community. Again, no more will our streets and communities be filled with clutter and trash that block sidewalks, the right-of-ways, creating public safety risk and public eyesores. Right now in Maryland is far behind other states when it comes to tenants' rights over their own belongings. Locally, the District of Columbia, New Jersey, West Virginia, Pennsylvania, Delaware, and Virginia all have notice and reclamation periods to allow tenants access to their possessions after the eviction. 28 states and D.C. require notice of the scheduled eviction date and provide the tenant's right to reclaim belongings and give landlords some duty to store the tenant's property. Senate Bill 442 brings Maryland in line with those other states. This bill adds predictability around the eviction process. It benefits tenants, landlords, and community, and it addresses the Fourth Circuit's Todman decision to ensure that our localities are not open to the liability for constitutional violations. For these reasons, I respectfully urge a favorable committee report. Thank you.
Good afternoon again, Mr. Chair, members of the committee. My name is Matt Hill. I'm attorney at the Public Justice Center, which is a part of RUM, which has this bill as a priority for the General Assembly session this year. I want to thank the sponsor for bringing this legislation. I won't repeat all the excellent points the sponsor made, but evictions are not just a symptom of poverty. They actually cause a descent into poverty, particularly when a family, again, is losing their Social Security cards, their birth certificates, their clothes, their electronics, their medications. It's very hard to hold down a job when you and your family literally have nothing. The trauma this causes to tenants like Sharnae Hunt and her 9-year-old son is indescribable. Ms. Hunt testified last year. In my testimony, you'll see a link to an article in the Baltimore Banner describing exactly what Ms. Hunt went through because there is not this notice and limited window of reclamation for your belongings after an eviction in Maryland. Again, the senator already talked about the 28 other states that do this better than Maryland, including all of our surrounding states. And I just want to emphasize again something he said about the Todman opinion. This is the Fourth Circuit saying that Baltimore City's eviction law is unconstitutional because it did not provide notice and an opportunity to reclaim your belongings after the eviction. Baltimore County, Prince George's County, all have no notice and no opportunity to reclaim your belongings after an eviction. Prince George's does have a limited 4-hour window that if the tenant's on site, they can have 4 hours to reclaim some of their belongings, but that's it, and that's only if the tenant's on site. So it's our opinion that those counties and possibly other counties and municipalities, because of various policies the sheriffs have put into place in which the belongings essentially are abandoned, are facing significant liability. And so we think the General Assembly should act and should set a consistent statewide standard to make sure that everyone has some dignity in this process, and Maryland ends their very unique barbaric practice on this. Thank you.
Good evening, Mr. Chair. My name is Chelsea Ortega. I'm a private attorney at the law firm Santoni Vacci and Ortega. Our firm is also a RUM member, and I am also here in my capacity as the Maryland State Chair of the National Association of Consumer Advocates. Currently, Maryland car owners are given more opportunity to reclaim their car and their personal belongings in their car than tenants are when facing eviction. There are a number of licensing schemes and finance schemes in Maryland, but the one that's commonly used by finance companies requires that consumers whose vehicles are repossessed receive a notice by certified or registered mail 5 days after repossession where their vehicle is located, how they can redeem their vehicle. In addition, the finance company is required to keep their vehicle and their possessions for at least 15 days after the repossession. 10 days before the sale of the vehicle, the consumer is required to receive a notice of the sale of the vehicle by certified mail. This doesn't make any sense that the possessions that are moving around in someone's car are offered more protection than what are in people's homes. We have represented clients who have lost their family members' ashes through the eviction process, who have lost life-saving, sustaining medications, irreplaceable items. This is not necessary. We should be giving people notice of when they are going to be evicted from their homes. There are a number of studies that have been done across the country that shows the mental health impacts that are sustained by people who are at risk of eviction and who have been evicted. And then to further exacerbate those by losing all of their possessions is just cruel. These studies also include the impacts of children who have seen their family members be evicted and losing their possessions. Currently, there is an incentive for the landlord to try to evict the people as quickly as possible, put the people's possessions out, so they are being damaged and destroyed. And for all of these reasons, we would urge a favorable report. Thank you.
Thank you. This bill is long overdue. In Elk County, what policy we have is absolutely worthless. We have a number of our churches who have staff pastors who work with those who are going through or who believe they're going to be evicted. You know, they need money. They need money. We, give money. We do things. But then there are those who call us rather late. And by the time our staff gets there, it is not just the people who steal it. It is the companies that they hire to do the eviction who absolutely destroy their property, throwing it out, busting up china, stealing jewelry, stealing money. I have had a case where the ashes it was earth and spread everywhere. So this bill is necessary because what we do is barbaric, and it's something that maybe they did in the 1800s, but this is not something we should be doing this year. And so I want to ask you, Matt, just a question. So based on what you said, what are benefits to the landlord and community from this bill in your mind?
Thank you, Senator. With respect to the landlord, again, there's elements of this in Baltimore City already. The notice of the scheduled eviction date, not the right to reclaim, which is problematic. But what happens in Baltimore, what happens throughout the state right now is the sheriff requires the landlord to have 4, 6, 10 movers to be present, those companies that you were just talking about. And a lot of times, the tenant may redeem the property. They may pay and stay, and then the eviction suddenly gets canceled at the last minute. Landlord still has to pay all those movers, right? And so by having this new process, the sheriff would merely have to come, show up, escort the tenant off the property if they're there. The locks are changed. Landlord doesn't have to have any movers present, right? Because the tenant's still going to have a limited window in order to reclaim their belongings. So it resolves that issue from the landlord of having to recruit all these movers to be present, and who knows what's going to happen. You're going to have to pay them anyway. Secondly, for the landlords, it speeds up evictions, right? The sheriff is just going to have to come, escort the tenant off the property, locks get changed, and the sheriff can go on and do 5 more evictions instead of having to wait for all the belongings and whatever else happens. So we think these are significant benefits to the landlord, and that's why there's some support for this from the landlords in Baltimore City. In terms of the community, I think you already hit on it, and so did Senator Sidner, in the sense that this is a blight to communities and to neighborhoods, to walk home and just the kids walking and seeing their neighbors with all their belongings out on the front yard.
Right.
I mean, it's traumatic for the neighbors. It's a blight to the neighborhood. You talk about property values going down. That's a source of property value decline as well. And so we're talking about cleaner, greener communities when we don't, again, as you said, if we could end this barbaric practice here in Maryland. Thank you.
My last question, will this add any delay onto the eviction process?
Thank you, Senator.
Come and say that and blah, blah.
And the answer is no, it doesn't. And the reason is the 14-day notice happens right after the warrant's issued, okay? The landlord calls the sheriff, says, hey, I want to schedule the eviction. The sheriff's going to, in 99% of cases, give an eviction date that's more than 14 days out from when that person calls, from when the landlord calls. And so the landlord gets the eviction date and sends the tenant that same day a 14-day notice of the first scheduled date of the eviction. The bill even says if the eviction is rescheduled, no other notice is required.
Okay.
Right? It's just that first scheduled date. So that doesn't slow anything down.
Okay.
Now, the 10-day reclamation period, our understanding is that there's always some sort of turnover period, right, after a property is vacated. And that turnover period allows the landlord to come in and paint, do whatever repairs need to be made, and market the property to someone new. And so we're not actually slowing that process of turnover down at all. The landlord could do all those things. If they want to move the tenant's belongings to a storage unit in order to do that even faster, great. If they want to move all those belongings into one room of the property while they do all the repairs and they do all the repaintings, great. It's not actually going to slow down the process for an eviction or for re-renting the property in any undue way.
Okay, thank you. Great bill. Long overdue. Thank you, Mr.
Chairman, my first question is for Mr. Losek.
Mr. Hill?
Mr. Hill, I'm so sorry, Matt.
It's the other Matt. I don't talk about him.
My apologies, it's a long day. I wanted to, do you have the citation for the case, the Taubman decision?
Yes, I do. It should be in my testimony, and if it's not, I will get it to you.
If it's in your testimony, I'll check and I'll find it there. The Baltimore City ordinance is there. When a person is evicted, they have a rule, I'm trying to confirm, where you can't leave it at the curbside. You have to take that property to the landfill, is that right?
Correct. So
Okay.
what happens is the landlord gives the tenant, and this is only in failure to pay rent evictions, a notice, a 14-day notice of the scheduled date of eviction. But then the Baltimore City law says that the possessions upon eviction are abandoned. So what happens is sheriff comes, escorts the tenant off the property, locks are changed, and all the tenant's belongings are stuck in that property. And so what we've actually seen is tenants who then try to break in and get their medications back. We've seen landlords who say, oh, you want your heart medication? Pay me $500 and maybe you can get your heart medication back. So that's part of the process in Baltimore City that the Taubman, the Fourth Circuit, said was unconstitutional. And that's what we want to address.
Thank you, Senator. Is the issue that they couldn't, so like in Anne Arundel County, you can leave the property at the curbside. So if they have access to it because it's left outside, would that still be in violation of Taubman? Or is it because you're deprived of it because it's locked away or taken away?
It's an important question, Senator. I mean, so I'm just going off the language of, say, Baltimore County or Prince George's County laws that specifically say upon eviction, those belongings are considered abandoned. Okay. And it's that abandonment language that I think the Fourth Circuit zoned in on and said, wait a second, the state can't just declare your belongings abandoned without notice and an opportunity to be heard. And the Taubman court said, if there was a reclamation period here, it would do a lot to guarantee due process in that situation to avoid any errors and to avoid some fairness for the tenant to be able to still have access to their belongings.
I understand. My concern is the potential for curbside trials. I don't know if the bill sponsor has spoken with the sheriff's departments to see how they feel about it, but it seems like an incredible amount of responsibility placed on the sheriff that the landlord standing there and they have to provide the sheriff with notice that they've sent the notice. You have the 3 prongs of what it takes to make that showing to the sheriff. And then the sheriff has to make this like evidentiary decision on whether or not the landlord's met that burden. If the sheriff believes the landlord hasn't, then the sheriff has to send the notice to the court. So that's another piece of administrative work for the sheriff. But it just sounds like we're having a trial, but we're having it on the street corner without all of kind of the mechanisms that you typically would have in trial to authenticate documents, to have, you know, rebuttal evidence, all those different things. Can you help me work through that concern?
Yes, and you know, it's a concern, but again, this is actually that part of the process we already have in Baltimore City, and it actually works pretty well because the sheriff's not making a determination at that point. The sheriff is just saying, okay, wait a second, something looks off here. If something looks off, I'm going to take it back to the court, and the court makes the determination as to whether or not the eviction should proceed. So the sheriff's discretion here is very limited. If the tenant claims there is a problem, like for instance, we have this all the time and throughout the state already, the tenant claims, I paid, I should stay. The sheriff should not evict this person. And so the tenant will present that to the sheriff, and I think throughout the state, the sheriff brings that case back to the judge to make a determination as to whether or not they paid and stayed or the eviction should go forward. So the ultimate responsibility is the judge.
I would be interested in hearing from the sheriff and knowing if that happens. I've seen the person wants to pay and stay and the sheriff just won't sign the warrant, and then that's the end of it. It doesn't go back in front of a judge to determine if the person's actually paid. You know, the landlord then has a responsibility to file again or to, you know, take another whack at it if they can. But I would definitely be interested in seeing what happens at that next step. Thank you for that. I appreciate your responses. Thank you, Mr. Chair.
Do you want to answer?
Senator, just briefly, if I could respond to that, we have transcripts of sheriffs who have testified in cases that they have called the court, so I'd be happy to provide those to your office.
Thank you. And if I may, I did have another question that I just remembered. Thank you, Mr. Chairman. When the property is in the reclamation period and it's on hold for 10 days, is the landlord responsible? Are they liable? Like, let's say something's stolen or damaged during that time frame. Who's on the hook?
Right. So the best practice we've seen from other states is that the landlord is generally not liable unless the tenant can prove that they committed some deliberate or negligent act to cause the loss. And of course, incredibly challenging for any tenant to try to prove that. And in the vast majority of cases, that's not the issue.
Is there any responsibility on the landlord to like prevent that from happening? Like, let's say they choose to lock it and leave it in the unit. Let's say then the tenant's not current on the utility bills, and so the utilities aren't paid, and let's say it's something that needs to be kept at room temperature, and they're not able to preserve that, or any sort of other thing happens. Is it the landlord's responsibility at that point to kind of preserve that property?
No, Senator, because that would not be a deliberate or negligent act on behalf of the landlord, right?
Okay.
There has to be some deliberate or negligent act. And then as Senator Sidner was pointing out, the landlord or any person acting on the landlord's behalf may not be held liable for any loss or damage to property deemed abandoned under this subsection, and that's on page 10 of the bill.
When is it deemed abandoned?
It's deemed abandoned, it is right after the expiration of the reclamation period. So it doesn't exactly answer your question, but in terms of after the reclamation window ends.
So during the reclamation period, that provision doesn't shield the landlord, but what I hear you saying is that you would default to typical negligence?
I'm sorry, page 10, line 12 actually says the landlord is not liable to the tenant or for any losses related to the personal property unless the loss is the result of a deliberate or negligent act on the part of the landlord. So it's very typical of tort, yes.
And that extends for the entire cycle, not just after the reclamation period?
That provision would be just during the reclamation period. After the reclamation period, no liability at all.
Okay, thank you so much. Thank you, Mr. Chair.
Thank you.
Chair. Mr. Hill, I got a question for you, please, sir. I think you had made a comment that there was landlords that were in favor of this. I can't find anything in the testimony. Maybe I don't find it, but it would be great if you could provide said landlords that think this is a great idea.
I apologize, Senator, if I misspoke. What I was trying to refer to was the fact that when a similar bill passed in Baltimore City, I think in 2006, that provided notice to the tenant. There was some support from the landlord community because, again, it ended that problem of the landlord having to have the 5 to 10 movers present on the date of the eviction, and could make evictions move a little quicker if the sheriff just has to, be there for the change of locks. So if I misspoke, I apologize.
Yes, sir, thank you. Second of all, we've talked about Baltimore City. Baltimore City, Baltimore City, Baltimore City. Do you know what some of the other rural counties are, about how long they have to wait for the sheriff to have time to do that?
I'll let my colleague answer that.
So in speaking to some of the legal services providers who represent tenants living in rural jurisdictions, the process is, this is really statewide, but this is as quick as it can be under the state statutes that we have. So the notice of intent to file for an eviction can be provided on the 2nd of the month. So if most leases provide that the rent is due the 1st, if they don't pay it by the end of the day on the 1st, on the 2nd, the landlord can send a notice of intent to file for the eviction. Then the landlord can file a failure to pay rent complaint 10 days later, so as early as the 11th. There is a hearing typically within 5 days after the failure to pay rent is filed, and then if there's a judgment for possession, the landlord can apply for the warrant 10 days later. The eviction we have seen typically scheduled within 2 weeks in jurisdictions where there aren't a lot of evictions scheduled. So you're talking about a month and a half that the process is for failure to pay rent.
So I appreciate that, because I didn't know how I was going to articulate asking that question of how long it's going to take. But my question had to do for rural counties. Do you know how long it takes for a sheriff to actually execute the eviction?
It's our data is within 2 weeks is what we've heard.
Yeah, well, in Allegheny County, I can have it in 3 days. So this isn't going to help the landlords, is my point. I understand that in Baltimore City, this is something that they need to do, and that in Baltimore City, because they're not going to be able to schedule a time with the sheriff for the eviction because there is so many of them that it's going to be past the 2 weeks. But in smaller jurisdictions, this is not helping out the landlord. It is not whatsoever. If anything, through lining out the timeline you had, is just adding more time that the landlord is not going to be able to get their property back.
Well, what we've seen is that I just saw a case the other day, they were charging a $1,500 clean out fee to the tenant. And so it will help as far as if the tenant is able to get their possessions out, the landlord isn't incurring those fees, significant fees of.
Well, with all due respect, I understand that large landlord organizations, there might be some people, bad actors. But smaller landlords, this isn't happening. Smaller landlords, we're not trying to get a $1,500 clean out fee, because if we were trying to get a clean out fee, we would have rather put that money towards the back rent, and we wouldn't have wanted them to be evicted in the first place. And so I hear what you're saying, but for the smaller landlords, this isn't a help. And maybe that's something we can discuss.
Yes, Senator, and that wasn't a large corporate landlord that I was talking about. This is a post-move out collection case that's filed against tenants where we see these fees regularly, eviction fees and.
I understand that people are trying to collect, and they shouldn't be trying to collect on people that are already having a problem paying their rent, okay? But the real world is there are landlords that legislation like this will affect, that we have extended the time that we're able to get the possession of the property back. And on top of that, these landlords that I like to speak for would not charge a $1,500. We would have rather, that would have paid the 2 months back rent that they would have had in Allegheny County. So unfortunately, a lot of times these statewide bills do help maybe larger jurisdictions, but they actually hurt smaller jurisdictions and in this case, hurt smaller landlords. But Thank you.
Sure. And other states have these laws, and I think that they still have smaller landlords who are able to operate. So I think that we should be in line with these other states and surrounding jurisdictions that have these laws. Thank you.
Not be permitted, but possibly. Thank you, Mr. Chair. I'd like to ask the sponsor of the bill a couple of questions. Firstly, on page 7 of the bill, we talk about the 14-day notice.
Do you really want to talk to the sponsor, or do you want to talk to somebody who knows better than the sponsor?
No, the sponsor, I think, unless the sponsor would like to defer to somebody else.
No, go ahead.
So as the sponsor is aware, we've had quite a...
I'm sorry, on page 7 you said?
Page 7 of the bill, on line 18,
All right,
which is the 14-day notice requirement. As the sponsor is aware, we've had a number of landlord-tenant bills over the last 7 years now that I've been on this committee, especially during the COVID period and afterwards. The thrust of which has been to add additional notification periods and to extend the notification length. So as I read this adds an extra 14 days to the eviction process, correct?
No, it doesn't.
It doesn't? Okay. Mr. Hill, maybe you can answer that.
Yes, Senator, thank you. It does not, because in the majority of cases, and I understand Senator McKay's point that not all cases, but in the vast majority of cases, it's our understanding that once you get a warrant as the landlord and call the sheriff to schedule the eviction date, that eviction date is going to be at least 14 days out.
Well, not in Allegheny County.
I understand the point, but in the vast majority of cases, it's going to be at least 14 days out. And so this will not add any time to the eviction process.
Well, in Baltimore City, that may be the case, but I suspect in some of the smaller counties, maybe many of the smaller counties, the sheriff doesn't take 2 weeks to go out and serve the writ of, writ of restitution, warrant of restitution.
It's our position, the vast majority of cases, and our understanding that it is at least 2 weeks.
Okay, so you believe Allegheny County is an outlier?
Excuse me?
You think Allegheny County is an outlier?
I do.
Okay. So I noticed that it's 14 days, and part of the notice has to be the scheduled date of the eviction.
Yes.
So when the tenant receives that notice, the tenant is specifically told what date the eviction is scheduled to occur, correct?
Yes.
And the tenant therefore has 14 days to arrange to move furniture out of the unit prior to the eviction date. Isn't that correct?
Yes.
All right. If that's the case, why does the tenant need another 10 days after the eviction date to move the furniture out?
Right. A few reasons. First, the vast majority of eviction cases are for failure to pay rent. And in those cases, the tenants have the right to pay and stay. And so most of my clients honestly believe that they are going to be able to get the money together in order to be able to pay and stay prior to the eviction. And most of them do. But at times they don't. And so they're not prepared to have moved all of their belongings out of the property by that eviction date because they are focused on getting the money together in order to pay and stay. Secondly, the Ms. Hunt case is a good example of this. This is linked in my testimony as all of the Baltimore Banner. Sometimes there are errors. Ms. Hunt did pay and stay the morning of her eviction. The landlord allowed the eviction to go forward anyway. All of her belongings were thrown onto the street, her and her 9-year-old son's belongings, and they haven't really recovered since. And so that lack of room for error is what the Todman court cited when it said that any of these eviction abandonment ordinances are really leave no room for error, and that's part of the procedural due process issue.
Well, now what would happen if the scheduled date of the eviction had to be changed for one reason or another? Bad weather or a crush of business in the sheriff's office and they wasn't able to get there on time. Right. Suppose he moved the scheduled date back 4 days. Would you have to give again 14 days notice of the new scheduled date of the eviction?
No.
Based on this bill? No,
Senator, and that's specified in page 8, lines 22 through 24. It's only that first date of the eviction being scheduled.
Okay, that's helpful. Thank you. But adding the extra 10 days onto the 14 days, now you have 24 days, the better part of a month that's been added to the eviction process in Baltimore City.
Well, again, I'm not just talking about Baltimore City, to be clear. In the vast majority of cases, it's our position that it takes at least 14 days from the warrant being issued to when the sheriff can legitimately conduct the eviction. So that doesn't add anything to the time. Now, the 10-day reclamation period, I understand your question. Our position is that we understand that there's a turnover period. Anytime you're changing from one tenant to another, the property has to be painted, there have to be repairs made. Usually there's some leasing to be done, some lease the signing of the lease. And so that can all still happen. The tenant's possessions are either in a storage unit or they're perhaps moved into a corner of one of the rooms. Hopefully, too, more of the tenant's belongings are going to be gone because now they're going to have notice of the scheduled eviction date, which is, again, more time to move, and that opportunity to reclaim, again, more time to reclaim their belongings. Hope you're going to have less belongings, and it's not going to impede that turnover period. So I really don't think it's going to add significantly to the eviction time.
Okay. And then I guess my last question is, the bill provides that after the 10 days, if the furniture still hasn't been moved out, it's deemed abandoned.
Yes.
But then it says if the landlord decides to dispose of abandoned property by sale, the tenant's entitled to any proceeds of the sale that exceed the back rent. Does that suggest that the tenant would have to sell the property in a particular apartment separately from property in any other apartment, and therefore have a series of sales as opposed to one sale of all the furniture that has been left over for the past month? Because if it doesn't do that, how are they going to be able to account for it all?
I don't know, Senator. I mean, the vast majority of these cases, my understanding is the remaining belongings are either, there's some sort of, they're kept by the landlord if they're something of value. If they're not of value, then they're hauled away to the dump. And so I'm not familiar with too many sales of these belongings, but there's seemed to me something fundamentally wrong about a landlord getting to then sell all of a tenant's possessions and then pocket the money if they choose to do so. I think that's what this provision is addressing.
Okay, thank you.
Questions? We'll now move, I think that'll conclude the testimony for the proponents of the bill. We'll now move on to the opposition panel. And we'll hear from, let's see, is Mr. Costello here? Ashley Clark.
A third time around. Good evening now, Mr. Chair, Vice Chair, members of the committee. Ashley Clark here on behalf of the Maryland Multi-Housing Association. Because this is a reintroduction, I do want to focus my time on talking specifically about the reclamation period that we've been kind of talking about this evening. I think it really boils down to the storage costs that are associated with the evicted tenants' personal property. This bill does not allow a landlord to charge for the storage of the former tenant's personal property. The only costs they're allowed to collect during the reclamation period are the expenses incurred in providing the notice to the tenant of the eviction, and that amount cannot exceed $5. That doesn't factor in the turnover cost or the vacancy loss that will accrue during the proposed 10-day reclamation period. None of that can be recouped. And so if I'm looking at a resident who is now going to, they're up for the eviction, and say they've only been there for 6 months, it might be a 3-day turn where he was talking about the painting, talking about the carpet cleaning. That's a 3-day turn. And so in that case, you have 7 extra days to get someone into that apartment home. You can't recoup that vacancy loss if we have this 10-day reclamation period. It seems like this bill places the onus exclusively on the landlord, which has exercised their legal right to regain possession of their property. And we believe there's a shared responsibility that's not acknowledged by this bill, but instead elevates tenant protections over the rights of a landlord. And so it's for those reasons that we're asking for an unfavorable report. Happy to answer any questions on the bill. I'll reserve. I know I have questions. Thank you.
Hi, Mr. Chairman, members of the committee, Bill Castelli on behalf of the Maryland Realtors. And Realtors are property managers and sometimes landlords, mostly of single family. They do some multifamily, but mostly of single family. And the problem that they have with this bill is largely in the single family context. And I can tell you that most of the time when a tenant leaves behind personal property in the single family situation, it is abandoned property. They do not plan to reclaim it. And our biggest problem with this bill is that it requires us to effectively keep this property another 10 days idle, not returning it to the market as soon as possible, in order to babysit a bunch of property that is basically going to be thrown out because sometimes it's damaged furniture, it could be other kinds of damaged property. But we would not be in a position to be able to determine whether they want to come back and reclaim the cracked aquarium or the broken lamp or the couch until they actually do it. So that's the problem that we have. We think whatever time between the issuing of the warrant and that time that they're going to come and the sheriff is going to come to evict, people know when that time period, what that time period is, and people have an opportunity to actually get their personal property out. And in the single family context, a lot of them do, most of them do, but the ones that don't often are leaving that personal property behind. And again, and to Mr. Hill's point, this isn't just failure to pay rent. It's tenant holding over, it's breach of lease. So there aren't, in those situations, that question of, gee, I think I can still make the last rent payment. So for that reason, we encourage an unfavorable report.
All right, questions from the committee? Senator Henson.
Thank you, Mr. Chairman. If I may, you narrowed in on the reclamation period and the tenants that don't intend to reclaim the property and that genuinely have bona fide abandoned the property. If the bill had a provision that said if the tenant could consent, that at that moment that the sheriff's there and it's time for the eviction, the tenant could say, hey, I do need an additional 10 days, or the tenant could waive those 10 days and make the decision at that moment to say, I'm ready to move forward. There's nothing else in there. I want it. If there were some mechanism like that in the bill, would it be something you could support?
I think it's something our folks would definitely consider, but I do think, to the point that Senator McKay raised too, the length of time differs a lot in a lot of different counties. So you'd still have the 14 days. That is a longer period, and as Mr. Hill said, in some counties that wouldn't make a difference because there is a delay between, longer than 14 days when the sheriff's going to get there. But in a lot of rural counties, that's not the case. And there is an argument to be made that we want to return these properties to the market as soon as possible because there is a shortage of housing, and just keeping these properties idle makes it difficult for tenants to find apartments. It just feeds into that problem that we're currently having.
I'm not hearing an answer in there.
Well, I would have to take it back to the realtors.
Okay.
And have
Thank you. I appreciate your response. Thank you, Mr. Chair.
Senator Henson, if I could also respond. I think the other piece here too is I don't know where we came up with the 10 days. And I know that the proponents had referenced, other states and what they're doing, but even in Virginia, that's only 24 hours. And then if I'm looking at the Topman's decision, it says on page 21, even if it's just it's as short as a few hours. So the fact that we're trying to extend it to a 10-day reclamation period when there are shorter timeframes that are available, even in the decision that was made, is something that I think we should consider, the reclamation period time. Thanks.
All right, further questions from the committee? All right, thank you very much. Thank you. With that, that'll conclude the hearing for Senate Bill 442. We'll now move on to Senate Bill 566. Senator Sidnor.
For the record, Mr. Hinton really hates this bill. So you don't have to testify now, right? All right. Senator Sidnor testifying on behalf of Senate Bill 566. So Senate Bill 566 is a simple and straightforward bill designed to increase fees and monies collected from foreclosure actions, which will support the Maryland Housing Council and Fund Program, which is administered by the Maryland Department of Housing and Community Development. Since this fund was created in the aftermath of the Great Recession 2 decades ago, these monies have supported Maryland's nonprofit housing counseling agencies and also Maryland legal service providers assisting our constituents facing foreclosure. In the recent years, the funding for these agencies has reduced significantly, and Maryland nonprofit partners have struggled to maintain services designed to assist borrowers with sustainable solutions to save their homes from foreclosure, or alternatively, seek a soft landing to a new home and avoid the negative consequences of a foreclosure to themselves and the community. So, to reverse this trend, Senate Bill 566 will increase the foreclosure fees collected in each foreclosure from $300, which was the original amount when this fund was created in 2008, to $600. This is a fair increase when thinking about inflation alone has increased significantly since 2008. And the cost of services by our nonprofit agencies has also increased during that same time period. Also, it should be noted that the monies received from this fee will not come from the state, but will be paid by secured parties commencing foreclosure actions, hence Mr. Hinton's opposition. In many instances, the secured parties will be able to recoup the fee in the later stages of the foreclosure process. Given that most foreclosures are now commenced in Maryland by private equity funds who have taken over the secondary mortgage markets, it's hard to say that they will be unduly burdened by the increased fee, which simply reflects increased inflation and also the cost of services by our nonprofit partners. These entities have endless resources. When the fee was originally established in 2008, homeowner advocates agreed to it for the means of the greater good that preventing foreclosure whenever possible was a priority, and the state did not have adequate resources to provide such direct services, which could be carried out by its allies in the nonprofit community. Given the realities of the state's current budget situation, this increase serves an even greater paramount purpose today, since the state has little margin to provide the necessary direct services. For these reasons, I urge the committee to provide Senate Bill 566 a favorable report. Thank you.
Good evening. Thank you, Chairperson Smith and members of the committee. I'm Ruth Griffin. I'm the Housing Counseling Coordinator with the Community Development Network of Maryland, CDN. CDN works to support the efforts of organizations which improve the quality of life for people in our state, which includes affordable housing, neighborhood revitalization, family and stability and wealth building, small business development, and housing counseling. This is what I'm here to talk to you about. Housing counseling is a service provided by trained, certified professionals. They inform and support consumers in meeting their housing needs or working to achieve their housing goals. In 2023, the last year for which we have complete data, housing counselors served over 23,000 consumers in Maryland. Currently, Maryland's foreclosure rate is among the highest in the nation. I don't know if you knew that before today, but it's important to be aware of. And when consumers work with a housing counselor in the foreclosure prevention process, the success rate is higher than if the consumer tries to work things out with the lender alone. And the workouts agreed to between the mortgage lender and the homeowner have a higher rate of sustainability over time. And housing counseling has been around for over 50 years, and some of you may be learning about it for the first time today. And that's because of the very limited capacity for this very important service. The
housing counselors do a demanding job for modest pay with little job security and bring dedication and commitment to helping people make informed choices for their family's well-being and their housing needs. And here in Maryland, since 2007, we've developed one of the strongest housing counseling networks in the nation. By partnering and leveraging resources with many sources, including banking and mortgage companies and the Maryland Department of Housing and Community Development, we've added to the quality of housing counseling service delivery. Strengthening housing counseling has strengthened consumers. So we urge you to provide favorable report on the Bill 566, and thank you for your attention and all that you legislators do for Maryland.
Thank you very much. Mary, why don't you go next?
Good afternoon, Mr. Chair, Vice Chair, and members of the committee. Thank you, or good evening, rather. Thank you for this opportunity to testify this evening. My name is Mary Hunter, and I am the Director of the Housing Counseling and Services Program at Housing Initiative Partnership, also known as HIP. HIP is a 35-year-old affordable housing nonprofit developer and a HUD-approved housing counseling agency. We develop innovative affordable housing, revitalize neighborhoods, and equip people to achieve their housing and financial goals. We serve both Montgomery County and Prince George's counties, with offices in Hyattsville, Germantown, and Gaithersburg, which we are open up to the community as a community-based provider. And I want to thank Senator Cinder for sponsoring this bill, which increases the foreclosure filing fee that funds the Maryland Housing Counseling Fund, which provides critical support for our housing counseling program. HIP's housing counselors have touched the lives of 40,000 Maryland residents since we became HUD approved in 2003. Marylanders who are struggling with eviction, facing foreclosure, or who are daunted by the home buying process have relied on our multilingual staff for help navigating or resolving complex housing challenges, and these services are free. Our services are particularly crucial, and our phones ring off the hooks during the most challenging economic times, such as the Great Recession, the pandemic, and the current housing crisis caused by inflation and short housing supply. Our housing counseling program is currently operating at a deficit due to the loss of various federal funding sources that we have received over the years, most of which were federal grants passed through to Maryland DHCD, which then passed it on through this network that Ruth was talking about of housing counseling agencies. Those funds are expired, and we do ask that the legislature support this bill to fund our efforts to help some of the most vulnerable Marylanders access resources they need to stabilize their housing. Thank you so much.
Good evening. I'm Allison Harris. I'm the director of the Home Preservation Project at the Pro Bono Resource Center of Maryland. I'm here as a provider of legal services to low-income homeowners in Maryland facing foreclosure. As our sponsor mentioned, the fee has remained unchanged for nearly 17 years. But as I'm sure you all know, the cost of providing legal services for free to homeowners in Maryland has increased. The Maryland Housing Counseling Fund grants have enabled my organization to serve hundreds of clients. This grant allows us to provide foreclosure counseling to homeowners anywhere in the state, regardless of income, which helps us close that justice gap for middle-income homeowners who can't afford an attorney but are just over the income to qualify for other available pro bono services permitted only for very low-income homeowners. Notably, the other source of funding for this work is ending in June. The Maryland Legal Services Corporation, or MLSC, has funded foreclosure legal services for many, 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 many years. However, their funding stream has become depleted, and we are in the last fiscal year that MLSC will be funding foreclosure work for legal services in Maryland. This means that those of us providing pro bono legal services must make up these funds elsewhere to continue assisting homeowners. The Maryland Housing Counseling Fund is without question our main alternative source of funding for this work. Increasing the foreclosure filing fee will help ensure that homeowners across the state have expert assistance to avoid foreclosure. We know the positive effect of providing free counsel and free legal services when something as fundamental as housing is at stake. We urge a favorable report on this bill. Thank you for the opportunity to testify.
Good evening. My name is Claudia Wilson-Randall. I'm the Executive Director of the Community Development Network. And I just want to thank my colleagues for being here today and testifying in support of Senate Bill 566. I also want to thank our sponsor, Senator Sidner, for bringing this forward. And I just want to make a couple of points about why I think the state should invest in foreclosure prevention. For every house we save from foreclosure, we save the state approximately $30,000 in local and state taxes. This does not include the cost after a house becomes vacant in our state. We currently have a affordable housing crisis. I would say we have a housing crisis overall, not just affordable, but we are not building enough homes for our economy and to grow our economy in the state of Maryland. And wages are not growing as fast as housing costs. So it's really critical for us to figure out strategies that keep people in the houses that they currently occupy. And over the last 5 years, we've seen an alarming increase in Maryland, older adults in Maryland who are becoming homeless. And so we see this foreclosure prevention work is vital to preventing more home ownership loss, particularly for minorities in the state of Maryland. But it's really important that where we can intervene with housing counseling and legal services, that we do intervene. I also just want to say that in terms of how we compare with other states, right now, we have a non-judicial foreclosure process, so it's very hard to compare across the DMV, Delaware, Maryland, Pennsylvania, Virginia. Virginia is a judicial state, as is Pennsylvania, so it's a little bit difficult to compare. But I ask your favor report for Senate Bill 566, and thank you so much for the opportunity to testify today.
Thank you very much. With Senator Walstreicher and then Senator West.
Thank you, Mr. Chairman. I have a question for the sponsor, if that's okay. You can do it from your seat. But first, I wanted to thank Ms. Hunter, who's a constituent with whom I've worked for many, many years. And so welcome. Thank you for being here. So you mentioned inflation. I genuinely don't know the answer to this question. Maybe you don't have it on hand. But if we were to take the $300 and put in $25, do we know what that would?
I do not.
Okay, we can get that before.
The CPI index.
Thank you, Mr. Chair. I have a question of the last speaker. Could you go back up to the podium again? I was intrigued by your statement that we save $30,000 in taxes for every house that's not foreclosed. So it sounds like your organizations are doing a real service to the state and saving the state a lot of money at $30,000 a pop. Every time you prevent a foreclosure, that saves the state taxpayers $30,000, right?
Yes.
That's the import of what you said.
Yeah.
That being the case, wouldn't it make sense for the state taxpayers to pay for your organizations, the expenses of your organizations to do the work you're doing? Wouldn't it be a benefit to the taxpayers, for the taxpayers to pay for your organizations? Because every time your organizations prevent a foreclosure, you're saving $30,000 in taxes. Doesn't that make sense?
Why isn't housing counseling paid for by taxpayer dollars?
Exactly. If you're saving taxpayer dollars by the work you do, why shouldn't taxpayer dollars pay you to do the work you're doing?
I would say that would be a question for the legislature to make taxpayer dollars available for the housing counseling services. I will say we did sort of hash this out during the 2008 housing crisis about who should pay and how to fund housing counseling. So I feel like we've hashed that out previously during the foreclosure crisis of 2008. But yeah, I think that's been hashed out before.
Okay, well,
that this is the way we would pay for it.
The hashing out before was to set a $200 filing fee. So now we're asked to set a $600 filing fee, right?
It was $300. It's currently $300, and we're asking it to be increased To 600.
To 600. So you want the fee doubled.
Yes.
So it seems to me it's relevant at this stage to make another decision about whether or not it makes sense under the circumstances for the state taxpayers to pay for services which are saving the state's taxpayers money. It's a net benefit to the state to have you do what you do, and presumably the $30,000 per foreclosure that you're saving the state doesn't cost you $30,000 to counsel those people and to avoid the foreclosure. So the state's, every time you prevent a foreclosure, the state is making money. Am I correct?
Yes.
Okay. So my question is, I guess that maybe you're not maybe the right person to answer this. You said the right person is the General Assembly, which I guess is correct. Why should we impose that fee on private businesses as opposed to having the state taxpayers pay for something which is going to generate money for the state taxpayers?
I think the private industry is also making money on those foreclosures as well. And they will, I mean, they do get the money back from, they're getting those properties back.
I think the foreclosing parties would disagree that they're making money. They're trying to recover some of the money they've put out. And generally, they don't get it all back.
Okay, fair.
Okay, thank you very much.
Let it be known for the record that we have a Republican proposing a new tax, and I'm no, I'm kidding. No, seriously, I'm joking. No, yeah. So if you did like CPI, if you just indexed it, what would it be? 50% increase. A 50% increase instead of 100%. So it'd be something like. How much would that close your gap?
Well, so, oh, sorry.
I mean, it seems like we do this all the time where we index stuff, or we do like just incremental increases every year.
So in context, I put too much about us and not enough about the problem.
Yeah.
The federal dollars have been significant, although they've been crisis-driven, and they are ending or ended. So during the mortgage meltdown, there was a significant federal influx. After the mortgage meltdown, there was a significant federal influx from the multi-state mortgage servicer settlement. And most recently, COVID relief was huge in terms of supporting funds directly to families and also funds for housing counseling service provision to bring those funds to families and to help people work out their budget in the meantime to make things work. So the federal dollars are going away. So we're really at a crossroads for housing counseling, that if dollars don't come in, staff will be lost, highly trained professional staff that we've worked hard as a state to bring up to the level of professionalism they're at.
Yeah. I'm just wondering if you had pondered like just doing some sort of like indexing or like incremental increases every year or whatever. But
so is that actually something that is can be written in statute?
We do that all the time.
Awesome. Good to know.
Yep. All right. Thank you all very much. We have two people joining us virtually. Stephen Rose, and then I think Karen DeCamp was up first. I saw her pop on the screen. We'll let her.
Yes,
okay.
I'm here.
Hey, Karen, welcome. Let's get you on screen.
Yep.
All right.
I'm here. I won't take up too much of your time because I know it's late. My name's Karen DeCamp. I'm the Director of Home Ownership and Family Success at Southeast Community Development Corporation here in Baltimore. We're a HUD-certified housing counseling agency, and we serve, last year we served over 600 clients in housing counseling. So we help first-time home buyers. We help people save their home from foreclosure. We've done rental and post-purchase counseling. And we are funded by the Maryland Housing Counseling Fund, just for your info. I just want to support the idea that I think it's fair and reasonable to ask to increase this fee for filing for foreclosures in the state. I think if you look at the federal and the state scenarios, I think it's a fair way to fund the professionals who give, their neutral advice to often very frightened people who are in the midst of foreclosure. And they don't know what their options are. Our counselors get on the phone with them, their lender, and they help them figure out what are their options. I think in an uncertain economy now with uncertain federal funding and state funding, I think this is a very fair ask to increase this fee now. I did submit some written testimony, which has a client story in there, but I can give you many more of those. And I will just note, we've seen since the start of this year an uptick, a bump up in the number of calls we're getting for help with foreclosure. I had 2 ladies call me today. So this is really important, and I think a way not to burden the taxpayers, but help us help people in this state. Thank you.
All right, thank you very much. Questions from the committee? All right, seeing none, that'll conclude the testimony for the proponents of the bill. We'll now switch to the opposition panel. Mr. Enton.
Mr. N just told me he changed his mind. He likes the bill now.
I did feel sorry for having him sit here all day. Then I realized he's getting paid more than anyone else in the room to sit here. So I was like, you know what? Yeah.
Thank you for taking this last. My wife appreciates it. Robert Enton on behalf of the Maryland Bankers Association. You know, I've been up to my ears in this foreclosure issue going back to 2007, 2008, the task forces we had and everything else. And let me just clarify a couple points. The Maryland process is one of the most successful foreclosure processes in the country. I don't know what the statistics about it's one of the that was said about the number of foreclosures. The Commissioner of Financial Regulation tracks it. We had 10,783 notices of intent to foreclose that were sent in 2023. In 2024, that number was down to 6,542. Now, right now, we probably have in excess of 1.1 million mortgages out there. 1.1 million. This is, so you have to send out a notice 45 days before you file a foreclosure. So those notices go out in this year, in 2024, out of the 6,542 notices of intent, a total of 1,772 mortgages actually went to sale. That's it. So out of 1.1 million, we have 1,772 that actually went to sale. Why? Because we have a wonderful foreclosure process in place. The numbers do not in any way justify an increase to $600 for the party who hasn't been paid, who loaned hundreds of thousands of dollars to somebody and has no other remedy. You can't go anywhere. Bob Enton can't go in and say to the bank, loan me $500,000 unsecured. So they put up the property. 85% of the foreclosures result in a deficiency, and the amount is not adequate. My closing comment would be this. The current filing fee for a cause of action in the state of Maryland when someone is represented by an attorney is $185. The foreclosures are already paying double that amount, and this bill then would make it triple that amount. The reason the number has gone down, the revenues have gone down, is because our foreclosures have gone down. We really think this is not a good bill. It'll have a negative impact on the companies that make mortgage loans. And we'd ask you very strongly to give it an unfavorable report with all respect to my good friend, the senator from Baltimore.
Worth the wait, worth the wait. All right, Senator West.
I'll just ask one rather insouciant final question. I guess the companies that make mortgages are a pretty good target because they're commercial companies and they make profits. But lawyers are also a good target. Instead of increasing this fee on mortgage companies, why don't we just assess each lawyer in the state $100 and use the $100 per lawyer to pay this cost? Wouldn't that be just as acceptable a solution to you?
No, I guess that's my response, Senator West, is that when you look at the market decrease in the number of foreclosures, we have a program that works. 2/3 of the people that get a notice of intent to foreclose their property never goes to foreclosure sale. These numbers are dramatically lower than they've been in the past. And once again, I mean, you know, the fund is based upon the number of foreclosures. And when the number of foreclosures go down, the fund goes down. If the number of foreclosures go up, the fund will go up. And that's the system that we put in place. We did not fight for 1 minute by having the highest, you go back to 2008, the filing fees back then were probably $100. We didn't object to the $300. But once again, it's the success of the program that's lowering the revenues, not anything that the lender has done at all. So I just really can't see this bill being something that makes sense and being fair to the people that make mortgage loans. Thank you.
Just out of curiosity, what do you think about the indexing idea?
Well, look, you know, the index goes up and down, okay? I don't know that the index has anything to do, who knows when these mortgages were made, number one. Number two, the index goes up, the index goes down. I mean, right now, I guess our inflation rate is what, 3%? Basically, the consumer price index is 3%. I guess if it went up, it would go up. If it went down, it went down. I think it's 3%. I could be wrong. But I just don't see the justification for this increase, Senator.
Thank you.
The rate we're going nationally, I don't know. Give it a week or two. You may see a pretty significant adjustment on that one. But all right. All right, seeing no further questions, that'll conclude the hearing and hearings for the day. We are going to start off tomorrow. Is Sandy still here? She's still in the back. I think we're going to start off tomorrow at 9 o'clock. We're going to do voting for an hour, and then we're going to roll right into bill hearings just so we can get out of here. Council needs time to prepare, and full committee's out here, so. I'm not trying to push that off, but we can't just spring it on them. I'm not blaming council. I'm just saying that they need time to prepare. Okay. All right. Good evening.